You ready?
Ready.
All right. Good afternoon. This is House Judiciary Committee. It's the Tuesday, the 27th of February, 2024. We're going to got a large number of bills, and we'll start with House Bill 533 and Delegate Ruff. Do you have anybody? Robert Landau, Brandon Miller, Ken Phelps, Yannette Emanuel. All right, well, we're going to start with that group. And then there are quite a few people signed up to testify in favor. And we'll just start making our way through the list a little bit. So let's go with that. Delegate Ruff.
Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. Good afternoon. I'm Malcolm Ruff, delegate from the 41st District, and I'm here today to present House Bill 533, which seeks to clarify that a local governing body of a county, including Baltimore City, by local law has the authority to give its Police Accountability Board the power to exercise independent investigatory and subpoena powers and may conduct an investigation of a complaint of police misconduct concurrently at the same time with a law enforcement agency investigating the complaint. For decades, many jurisdictions in Maryland have advocated for community oversight of the police disciplinary process in response to widespread police violence and corruption in their communities, which includes the authority to conduct independent investigations. However, the Law Enforcement Officers' Bill of Rights impeded Maryland's jurisdictions from establishing adequate community oversight due to provisions in the law that expressly prohibited investigations conducted by civilians from resulting in discipline. That would be Public Safety Article 3-104B. This is why the efforts to repeal the law in 2021 received immense support from community members across our entire state. Back in 2021, we repealed the Law Enforcement Officers' Bill of Rights, and we replaced it with a new disciplinary framework and mandated that each county create a Police Accountability Board and Administrative Charging Committee. However, critical features of the board were left up to local jurisdictions, allowing them to establish the membership and budget and outline additional powers and procedures. Since the passage of the MPAA, and that's the Maryland Police Accountability Act, there have been attempts to give the police accountability boards independent investigatory powers and subpoena powers. However, these efforts have been met with consistent pushback from the Fraternal Order of Police, who you'll hear from today, and claims that state law preempts local jurisdictions from giving their police accountability boards these powers. These claims are not warranted. However, the act does not have a preemption clause. That would indicate the legislature's intent to fully occupy the field regarding any legislation having to do with police accountability mechanisms. This bill seeks to address that issue. More importantly, distrust in police is fueled by prevailing public opinion that police departments do not sufficiently hold other officers accountable for misconduct. According to a national poll by the Pew Research Center, 86% of Black people, 65% of white people surveyed said that police departments do a fair job holding officers accountable. So I will wrap up. I hear the bell. But I will say that in my own personal experience in dealing with police accountability as a civil rights attorney, I often have found that more likely than not, when there is no independent oversight, there is often cover-ups, there is often corruption, and there's often opportunity to fudge the facts. And what we need today is transparency for our community. So I would ask for a favorable report, and I look forward to all your questions.
Whoever'd like to go next.
Go ahead. Oh, you want to start?
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. For the record, my name is Yannette Emanuel, Public Policy Director for the ACLU of Maryland, here in support of HB 533. You have our written testimony, so I'll focus my remarks on addressing the opposition. First off, there is no provision in the Maryland Police Accountability Act that prohibits local bodies from giving their boards these powers, either in place of internal affairs or in parallel with them. Furthermore, the MPAA does not have a preemption clause, as you just heard, that would indicate the legislator's intention to bar the implementation of certain police accountability mechanisms and thereby preclude any local innovations or experimentation. Second, giving PABs investigatory authority is not inconsistent with police agencies also having the authority, nor will it unequal the playing field. The Baltimore City Civilian Reboard and the Prince George's County Complaint Oversight Panel have had similar powers for decades. And although these boards have been significantly underfunded and under-resourced, the independent investigations performed by the CRB staff have proven to show just how critical it is to have the option of conducting independent civilian-led investigations into complaints. Beyond the increased trust and cooperation complainants show with CRB investigators, the CRB and Public Integrity Bureau disagreed in 26% of concurrent investigations. Finally, opponents may argue that giving PABs independent investigatory authority would undermine the uniform disciplinary process in HB 670 sought to create statewide. While there's no doubt that the legislator sought to create a uniform process, authorizing PABs to conduct misconduct investigations does not change the process in any way. It simply just changes the identity of the people engaged in one of the tasks and that are part of the disciplinary process. Taking the position that only police can investigate the police would treat the repeal of Leo Bore utterly meaningless. By allowing PABs to conduct independent investigations, PABs provide a greater likelihood that investigations will be meaningful and that the public will trust their outcomes. For the foregoing reasons, the ACLU of Maryland urges a favorable report, and I'm happy to answer any questions. Thank you.
Chairman Clippinger and Vice Chair Bartlett, rest of the committee. I'm Ken Phelps. I am the Director of Public Policy for the Episcopal Diocese of Maryland. But I want to start by reading a statement from the Episcopal Church, and this is in my written testimony, but I think it's worth repeating because they say it better than I do. But in 2018 at General Convention, the resolution stated that while we honor and raise up the work of dedicated police officers who put their lives on the line to serve and protect, we also acknowledge the numerous inexcusable deaths and intimidation of people of color at the hands of law enforcement personnel in communities all over the United States. So it is that we encourage our congregations to stand in solidarity with community leaders and grassroots leaders who advocate for substantive and mandatory change in police departments and policing, and for the allocation of resources for community-based models of safety, support, and prevention. And in that spirit, the Episcopal Diocese of Maryland urges a favorable report on this bill. The Diocese of Maryland, we've committed ourselves to the process of truth and reconciliation and also embraced the concept of reparation. And they may seem like they don't apply here, but I wanted to argue that they certainly do, because everything before you is about truth, is about reconciliation, healing, is about reparation, which is repairing that which is broken. And we applaud the progress that we have made through the General Assembly since the year 2015, the death of Freddie Gray, but incremental steps, and we need to do so much more. And this is one more opportunity that we have to take one more step in the restoration of public trust and the healing of our communities. Thank you.
You were already on. Just wait a second. Go ahead.
My name is Robert Landau. I live in Gaithersburg, District 17, and I'm testifying for the Silver Spring Justice Coalition in favor of HB 533. The Silver Spring Justice Coalition is a coalition of community members, faith groups, and civil and human rights organizations from throughout Montgomery County, committed to eliminating harm caused by police and empowering those communities most affected by policing. As the lead community advocacy organization that worked with our county council to pass the PAB and ACC legislation in the county, we asked that the PAB be empowered with independent investigatory authority. However, council members said that they were concerned that the MPAA did not expressly give the PABs that authority and that they could not do that because it was unclear what the state law was. This bill would clarify this important issue, removing any doubt that local governing bodies may, if they choose, give their PABs independent investigatory authority and subpoena powers. It is enabling legislation and nothing more. While some argue that giving the PAB independent powers is redundant and unnecessary because it overlaps with the ACC, we disagree. The PAB should not have to rely on law enforcement agencies' investigations alone as it now currently stands. This concern has only grown for us this year, as we have seen that our PAB, for example, does not have access to body-worn camera recordings that are taken by most of the police in Montgomery County. So without those kinds of authorities, without the ability to actually look at this, they frustrate the intent of this body to ask civilians for change. We therefore ask a favorable report. Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Brandon Miller. I'm a second-year student and the Eric L. Barron Fellow at the Gibson Bank Center for Race and the Law at the University of Maryland Francis King Carey School of Law. The Gibson Bank Center works collaboratively to reimagine and transform systems and institutions of racial and intersectional inequality, marginalization, and oppression. The center supports the push for more police accountability in Maryland. In Prince George's County and Baltimore City, officer misconduct has historically been enabled by weak internal accountability systems within the police departments. Community oversight through empowered police accountability boards represents a more effective way for achieving accountability. In the US, the earliest proposals for police accountability boards were a response to Black people's experiences with abusive policing in the early to mid 20th century. The call for these boards became louder into the 1960s as civil rights leaders such as Dr. King joined the advocacy. In visits to cities like New York, Los Angeles, and Chicago, Dr. King advocated for the establishment of these boards. As a racial justice demand, the logic behind the movement for police accountability boards is clear. Officers in racially marginalized communities must be responsive and accountable to the needs and concerns of residents. Thus, the Gibson Bank Center strongly supports House Bill 533. The independent investigatory powers that this bill would authorize are essential for effective PABs. This bill seeks to ensure that PABs are able to deter officer misconduct, empower communities, and fulfill their mission. For these various reasons, we ask for a favorable report.
Questions, Delegate Williams?
Thank you, Mr. Chair. Thank you, Delegate Ruff, for bringing this bill forward. Just a couple questions. One, I noticed that there was a letter from the Prince, represent part of Prince George's County. So from the Prince George's County PAB, and I guess they feel like your bill doesn't go far enough. They would like it not to be enabling, but just for it to be enacted. I don't know if you have a response to that. And then I have a follow-up question.
If this committee has the appetite to mandate it, I think we would definitely be open to that.
And then the other piece I wanted to just reach out about, Delegate Ruff, I don't know if you had a chance to see the letter from the police and sheriffs, and obviously they expressed some concerns with regards to the legislation, most notably the concurrence of the investigation at the same time, while the police is also possibly doing their internal investigation in these types of matters. And I was wondering if you had a comment with regards to that concern that is raised, which I'm sure will be raised by the opposition.
Well, I'll jump in there. So let's just talk about specifically cases in Prince George's County. The case of DeMonte Ward Blake, young man pulled over for suspended tags, smell of marijuana. The police aggressively get him out of the car. The argument ensues. He's handcuffed behind his back. And the next thing you know, he's up in the air and slammed on his face, nose broken, neck broken, spinal cord compression injury, paralyzed for the rest of his life. The Internal Affairs Division of Prince George's County Police Department investigated that case, and the official documents stated that my client, who I was representing, who now is no longer with us, was trying to escape and ran away and ran his face into the ground and paralyzed himself. That was the narrative for an entire year, until the state's attorney's office for Prince George's County did a further investigation and found that actually what had happened was that officer, who was actually convicted and sentenced to jail for 1 year for a second-degree assault for breaking the man's face and neck and paralyzing him for life, had actually picked him up and his feet were above his head when he did that while he was handcuffed behind his back. So the concerns that the police might have for a contemporaneous investigation are far outweighed by the concerns that the public should have about whether or not police officers can actually police themselves, and whether or not we as the public have the right to know exactly what is happening and to have independent assessment of that.
And if I could just add that there are several other cities that do the same thing. So Oakland, Philadelphia, Miami, DC, Atlanta, all of these jurisdictions have concurrent investigations alongside police departments, and there haven't been any issues, including the Baltimore Civil Unit Review Board, who's been doing this for the last several decades.
Thank you. Delegate Ruff, let me be clear that I do like your bill, but I wanted to just give you an opportunity to answer the questions while you're still here, and that is dovetailing a little bit on Delegate Williams's question. The police and sheriffs call your bill a recipe for disaster, which to this delegate is a bit of hyperbole, but they do say something interesting, and that is that they say having the witnesses testify will cause witness fatigue in multiple places, will cause witness fatigue and imperil investigations. And given that you are a lawyer, I was wondering if you had a comment on that. And secondly, like I said, I do like your bill, but just to play devil's advocate, because I'm sure they're going to bring this up. In the example you gave, there was justice for that officer who grievously injured your client because he said he was found guilty or found guilty of a charge. So does that not suggest that the system is working? So those are my two questions.
So I'll address your second question. No, the system is not working because it should have been discovered contemporaneously with the investigation, right? There shouldn't have been an entire year before that officer was charged with a crime, because there was no furtive and realistic, truthful investigation into what happened to him until the state's attorney's office got involved, right? So no, there needs to be contemporaneous investigation that's independent of the internal review. And I don't understand why anybody would have an issue with that unless they simply don't want accountability. And so dovetailing into your first question, it sounds like just a poor excuse for not wanting for oversight. Thank you.
Thank you, Mr. Chair, and thank you, Delegate, for the update or the information on this piece of legislation. Just two questions for you. I wanted to inquire about the process. If you have these concurrently, do you foresee an expeditious process happening? Because as of right now, it's somewhat delayed, and I'm partly want to inquire if you would see any additional efficiencies in the process through this.
Yeah, I think that that's something that each board is going to have to internally ensure. But I also think that by having this process laid out and the authority to engage in the contemporaneous investigation, it will empower the boards, to, number one, seek subpoenas and to be able to efficiently get those from the courts. And also to have their own investigators conduct these investigations in a timely fashion. So I think that that's not necessarily something that needs to be envisioned in this legislation, but it's something that needs to be handled by each individual board as far as their internal processes are concerned throughout their investigations.
Second part of the question is, I believe, for Ms. Emanuel from the ACLU. You had referenced that this process has been successfully happening in Oakland and Philadelphia. In those cases, are you aware whether or not this process that's being proposed here was, or has it ever been unfair or tainted for the outcome of an officer that was not found guilty, meaning that they have to continue to appeal the process because of the investigation that was going on in two different processes and subpoenas?
No, we haven't seen that. And what we've actually have seen is that it's actually helped in those situations where officer was falsely charged of misconduct, maybe from an internal accusation or externally, and it has helped exonerate that officer and help the public actually trust the outcome of those investigations.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Thank you, Delegate, and thank you, panel. I have a few questions. I'll try to go them in order. To begin with, I'd like to know, where would these investigative members be? Would you be looking to expand these boards, or would it be the boards themselves that would be carrying these investigative powers? In other words, who would be doing the investigating concurrently?
Accountability boards would be able to hire investigators that would be accountable to them. So in Prince George's County, the Police Accountability Board actually has post-investigatory power. So after the ACC concludes their investigation, they do have they have the power to conduct investigations and issue subpoenas, but it's not concurrent. So they are able to hire investigators. And what we've done locally in implementation is make sure that in these jurisdictions where there might be the political will to do so, is that they have adequate budgeting in order to be able to hire these investigators. So again, in Prince George's County, the board has 1% of the police department's budget for the purpose of hiring these investigators.
So it'd be county by county. So Prince George's County would fund this component of the investigation.
Exactly, yeah.
The second question I have is, would this be applicable, or are you looking for this to be applicable in every investigation, or is this just selected investigations?
It would be selected investigations. The board would be able to decide whether they want to conduct an investigation or not.
And my last question is the word may and the shall, which we touched on earlier about with this would be enabling legislation, or if it would be selective. I guess the concern I have is how widespread is this statewide as far as the 23 or 24 police accountability boards? Are you seeing these concerns in select 3, 4, or 5 jurisdictions? Or, for example, my Western Maryland counties, this is not an issue, or it has not been brought to me or some of my colleagues. So I'm hesitant as to, would it be more appropriate to make this selective to certain specific counties in legislation?
Well, I mean, I think that's the reason why we've made this kind of middle ground to be enabling as opposed to a mandate. I mean, there's no need to parse out which counties should and should not. It's up to the counties.
So you would be comfortable with the shall?
I'm certainly comfortable with the mandate.
Or the may,
Right.
I'm sorry, I had my notes read. The may, the may is okay.
That's what we got in the
Yes.
doc, in the bill.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill, and panel for coming in. To the gentleman that spoke about the police worn body camera footage, could you speak a little bit more about that
Sure.
issue?
So as you all know, the Police Accountability Board is responsible for reviewing the results of the ACC's decisions and to make policy recommendations to the community and to the elected officials, as well as to the police department. But to do that, they really need to have full access to the information that was reviewed by the ACC. And one of the problems in so-called liberal Montgomery County is that we still don't even have that kind of body-worn camera information. So we may have a report that says the officer did such and such and such and such, but without actually seeing that body-worn camera recordings, which virtually every officer in Montgomery County is using, then it's hard to know whether there are recommendations that should be implemented. And let me also point out that the way you have structured the ACC and disciplinary process, it requires basically a civilian to come forward and file a complaint. And we have talked as the Silver Spring Justice Coalition to a number of people who say, I'm reluctant to do that. I don't want to get involved. I don't want the police to retaliate. By giving the PAB this independent authority, you are actually helping to hold everyone accountable, as well as to provide recommendations to that county that can actually improve policing, and most importantly, to improve the trust that the community has in policing.
Can't get the body camera footage if you run the investigation concurrently?
No, well, we think we absolutely could. Through this bill, we
No,
absolutely
but
would
right
be.
now you can't get it.
That's right.
So why do you think that you should be able to get it through this bill?
Because this bill would give the PAB independent authority and they could ask for that information from the law enforcement
So
agency.
they could subpoena the law enforcement agency.
Yeah, but I'm asking about you subpoenaing the video footage.
Right, you would
Yeah.
subpoena to produce the footage from the police department
Yeah, I
through
think
the subpoena
question-
power.
I think the question is a little deeper than what we're on right now. So I thank you very much for your answer.
No, I don't think it's that deep
I
at
do.
all.
I do.
Well, if I might just address your question.
Go ahead.
You're asking us how we would compel the police department to provide body camera footage, correct?
I asked you.
We would compel them through the order of the court, through the subpoena that they would then apply for from the court, would receive that subpoena back and would serve it on the police department. And they would be compelled to provide that body camera footage or face the consequences of being in contempt of the court.
Okay, thank you very much.
Thank you, Mr. Chair. So I remember the discussion around the creation of this section of code pretty well. And you're sort of hitting on some of the things that I think we left unanswered from when we did this. So if you could get, and this is actually just for my own education, I need a little bit of a refresher for how this all is working currently. So I'm looking at the section of code you are seeking to amend, Public Safety 3102. And it says that these county police accountability boards have a charge to hold meetings, to appoint members, to receive complaints of police misconduct by the public. And this is the part that I'm particularly interested in. So there's sort of an intake office, at least one of the intake offices for police complaints. They make recommendations on things, and they review outcomes. They review outcomes of disciplinary matters considered by the charging committees. So sort of the interesting formal stuff here is you can take in complaints at the PABs, and you can also review the outcomes of complaints, seemingly all of the complaints, whether they came in through a PAB or not. So here's my question. As I recall, we left this a little bit murky. Putting aside investigatory and subpoena power for a second, do the local police accountability boards have access to any information, case files, documents, investigatory files for the cases that they did the intake for?
The public intakes?
Yeah. So if the local county board did intake on a case, and later one of their functions is to review outcomes of all the cases, do they at least have access to the records of investigatory? You're shaking your head no. My recollection was we did not clearly give the PABs access to the investigatory files, even for those cases that were brought in through them. And so that would lead to my second question, which is, okay, so the PABs are now made to make recommendations on the outcomes of all of the cases. And my question would be the same. Do they have access to any information about that larger set of cases? I think the answer there is also no, which would lead me to a third question, which is, on what basis are we making recommendations if we don't have access to any of the underlying information? I throw this out there because I remember we could not include this discussion in the police reform bill itself. But now that you're here in front of me with this bill, I'm reminded that we left some of this on the table. So I appreciate you raising this. One thing I might suggest. There is. Would you?
Yes,
Well,
we're
I answered my
amenable
own
to your
questions,
amendment.
unfortunately. I answered my own questions, unfortunately. But here's my actual question. It's really whether you had contemplated a baby step here, without jumping straight into having a second track of investigation and subpoenas. I mean, we don't even have access to the records yet at that level. I wonder if you would entertain, a partial reform.
Well, I don't see why it has to be either or. I think that there needs to be access to all the information that's out there for there to be true accountability. And so if this body looks to amend so that that occurs, I would hope that it wouldn't amend it to slow down the progress, which would be to ensure that at the same time that the investigations are going on, that these folks that have committed their volunteer hours to ensure that they're overseeing and that the police departments of their communities are following the rules and taking great care as they have sworn themselves to do as they took that badge. At the same time, I think we would be, that would be acceptable. You have some good ones.
Seeing no further questions, thank you all very much. Going to move on to having more people testify here in person. Joshua Harris, David Kramer, George Bunton, Nashana Kess. And we'll take the two virtual testifiers, Jesmyn Riggins and Jennifer Sell. No Jennifer? Okay.
How are you? It's good to see you. Have a seat.
Delegate, you don't get to testify twice.
I'm not, I'm just here for any potential questions.
No, you're done.
Okay.
No, no, you're done. Okay, whoever would like to go first, please.
Go ahead.
Good afternoon, Chair Clippinger and members of the committee. My name is Nashana Kess. I am the Executive Director for the Maryland NAACP, and I'm here to testify in favor of House Bill 533. Lord. Okay, now that we got the number right. This bill is a crucial initiative aimed at empowering local governing bodies, including Baltimore City, to establish police accountability boards with investigatory and subpoena powers. For too long, as you know, communities of colors have suffered the devastating impacts of systemic racism and discrimination within our criminal justice system. These accountability boards, composed of civilian members reflecting the diversity of our communities, play a vital role in restoring trust and transparency in law enforcement. Additionally, the bill establishes administrative charging committees to ensure a fair and transparent process for reviewing complaints and recommending disciplinary actions while upholding principles of due process. House Bill 533 offers a critical opportunity to advance accountability and transparency in policing, fostering a more just and equitable future for all Marylanders. I urge a favorable report on House Bill 533. And Mr. Harris was unable to make it.
Good afternoon, Chairman Clippinger and other members of the Judiciary Committee. My name is David Kramer, and I'm a member of Showing Up for Racial Justice, Surge Baltimore, and work in collaboration with the Coalition Campaign for Justice, Safety, and Jobs. I am a resident of District 43A. I also serve as a member of Baltimore City's Administrative Charging Committee, and that informs my comments below. As an ACC member reviewing hundreds of cases of alleged misconduct by members of Baltimore City's Police Department and Sheriff's Department since June of 2023, I am a direct witness to the importance of the quality of investigation reports that we use to fairly judge the innocence or guilt of accused police officers and then impose discipline. Myself and fellow other 4 citizens who sit on the ACC board view this work as an awesome responsibility. After all, a police officer's career and citizens' trust depends on us. But to do our job fairly requires a complete and accurate investigation. I am witness to the internal investigatory work of both of our city police forces. The Baltimore Police Department has greatly improved its office that handles investigations since the beginning of our city's consent decree. But we know that changes in leadership often lead to changes in priorities, as in any bureaucracy. Baltimore experienced many turnovers of police commissioners leadership prior to Commissioner Harris, who brought stability and progress on many crucial fronts. And he has now been replaced already. And we see how leaders in crucial positions in the police department are already affected, especially in areas of police accountability. My hope is that this investigatory work continues, but the quality of that, I believe, depends on having separate and independent investigatory powers to keep that honest and complete. Thank you.
Jasmine Riggins? No? All right. Jasmine Riggins, if you would please unmute and we'll bring you in. Just checking also in the room. George Bunton? No, I didn't think so. Didn't see him. There we go.
Can you hear me? Oh,
Yes,
okay.
there you are. That's fine.
Finally. All righty. Good afternoon, Mr. Chair and members of the Judiciary Committee. I'll try to be brief as possible. My name is Jasmine Riggins, and I join you today to share why I think House Bill 533 will improve policing in those jurisdictions that choose to give their police accountability boards the power to concurrently investigate potential acts of misconduct. My testimony is based in part on insights that I have gleaned from my personal experience in the law enforcement oversight space in Baltimore City. To give you a bit of background about myself, I'm a former staffer of the Baltimore City Offices of Equity and Civil Rights, where I managed and supervised the Baltimore City Civilian Review Board's concurrent investigations into potential police misconduct. I am currently a member of the Baltimore City Administrative Charging Committee and the Baltimore City Police Accountability Board. As was mentioned earlier, the chair of the board was unable to attend, Joshua Harris, but he wanted to convey that he supports my testimony. So generally, I think that House Bill 533 is pivotal in advancing police accountability across Maryland. Drawing from my experience with concurrent investigations, I'd like to highlight three benefits that I see in allowing PABs to conduct such investigations. So the first is that these investigations will help ensure accountability for both police officers and members of the public, which in turn will help rebuild and maintain public trust. You know, dual investigations affirm that community concerns are both valid and taken seriously. The second is that they offer a balanced perspective and at times uncover critical details that internal probes might overlook for whatever reasons, right? Inherent biases, institutional culture, or lack of an external perspective. And then the last benefit, they will help to foster organizational improvement by highlighting the police department's dedication to transparency and accountability. So I believe the passage of this bill would further position Maryland as a leader in effective and equitable policing and police oversight. And given this, I urge the chair to swiftly place this bill on a voting list, and I urge the committee to provide a favorable report. Thank you for hearing my testimony, and I'm more than happy to answer any questions.
Seeing none, thank you all very much. We have one person who signed up to testify favorable with amendments, Beverly John. Okay, go
Good
ahead for 2
afternoon.
minutes. Thank you.
Chair Clippinger, Vice Chair Bartlett, and committee members. My name is Beverly John. I'm submitting this testimony on behalf of the Talking Drum Incorporated and the Concerned Citizens for Bail Reform in Prince George's County, a nonprofit and community activist organizations. As members of the Maryland Coalition for Justice and Police Accountability and the Prince George's County's Coalition for Police Accountability, we support HB 533 that would give all county boards investigatory powers and subpoena powers. And we'd like to suggest an amendment to actually prohibit former sheriffs and police officers from serving on the PABs. This legislation, as it currently stands, if passed, would provide a critical missing piece that is needed to give our local police accountability boards the power to fully investigate misconduct complaints. Without the ability to independently investigate these complaints, we are once again relying on law enforcement, internal affairs departments as the primary body to investigate our complaints. And as we know, that without independent review and investigation, some of our cases will go unaddressed. During a recent briefing of our Police Accountability Board to our Prince George's County Council, and I'm glad that they actually sent a letter to this committee as well in support. Concerns were actually raised about without investigatory powers, independent and concurrently, there's delays that will be held in terms of getting complaints reviewed and addressed that would end up meeting actually expiring that 1 year and a day deadline that most cases have to be able to be resolved. So without that, we would actually run into delays where our citizens' complaints would not be heard and circumvent the intent of HB 670. Also, we must eliminate any real or perceived bias in the process by prohibiting former law enforcement from serving on PABs. So therefore, we do urge favorable with the amendments that we provided. Thank you.
Questions? Delegate Conaway?
Mr. Chairman, thank you for coming in to testify. Can you repeat that 1 year and a day?
Yes, there's a 1 year to a day time that if a complaint is made, you have 1 year to a day to get that addressed. If not, it expires and no, you can't do anything with it.
Okay, thank you very much.
Further questions? Seeing none, thank you very much.
Thank you.
We'll go to those people testifying in opposition now. Michael Shire, Michael Davey, Clyde Broderight. Whoever would like to go first.
Thank you. Good afternoon. My name is Michael Davey. I am the General Counsel to the Maryland State Fraternal Order of Police, and we are requesting an unfavorable report on House Bill 533. As you well know, the Maryland Police Accountability Act was passed by the General Assembly in 2021 with an effective date in July of 2022. The passage of House Bill 533 would grant the Police Accountability Board the ability to exercise investigatory and subpoena powers for complaints of police misconduct. The FOP believes that this bill is not necessary as the Police Accountability Board already grants investigative authority to their self-appointed administrative charging committees. They already have that authority. If we just use Baltimore City as an example, if this bill were to pass, you would have a police misconduct investigation done by the Baltimore Police Department's Public Affairs Division. You could also have an investigation done by the Baltimore City Citizens Review Board, and then we would have a third done by the Police Accountability Board. The Administrative Charging Committee, which is a subsection of the Police Accountability Board, already under the law, Section 3104E, has the authority to review all body-worn camera footage relevant to the investigation. They can call the officer to appear before them where they can ask him questions. They can request additional information from the investigators. They can require additional investigatory steps be taken by the investigators, and they already have the ability to issue subpoenas. The question that has to be asked, and I've done this for 25 years representing police officers, we have these multiple investigations, and what if the outcomes are different? What do we go with? Do we go with the one that sustained the charges? Do we go with the one that not sustained the charges? Who makes that call, and what's the decision to be done? Giving the police accountability boards the authority to conduct their own investigations can only create more confusion, unnecessary delays, and an already complicated disciplinary process. Based on our concerns, the Fraternal Order of Police asks for an unfavorable report on this bill. Thank you, sir.
Good afternoon. My name is Mike Shire. I'm with the Fraternal Order of Police, Maryland. Speaking in opposition, I'm also an attorney in the state of Maryland. A few years ago, this body celebrated the passage of the Maryland Police Accountability Act. It was developed to root out misconduct that was apparently so rampant throughout the state. Civilian charging committees were given subpoena power, as was just mentioned, to make sure that police internal investigations were done thoroughly and properly. Police accountability boards were created to review the discipline and make recommendations for improvement. Trial boards with civilians and neutral ALJs or judges were created to try the cases. The Attorney General was given investigative power and now criminal charging power, and yet no conspiracy has been uncovered. The fact is that police officers are much more likely to live and work with integrity than any other profession. So when does this stop? When do we admit that it is not police officers who are the cause or instrument of our society's ills? We did not build a highway to nowhere in Baltimore. We did not create the income disparities in our society. We did not establish redlining. So why are we the scapegoats? It's easy to point at us. It distracts everybody from the real problems that are facing our society, the hard problems to solve. It must be the police, the people who enforce the very laws that this body asks us to enforce. And so with this great Maryland Police Accountability Act, what great scheme have we uncovered? None. Should we just keep digging into this dry hole, or should we look to find real solutions to these problems that cause poverty and crime in our state? It's the police officer who's one of the very few people in the most crime-infested communities, day in and day out, trying to make life better for the people who live there. You've vilified our profession, and now we can't recruit or retain officers. How is that working out? Why does the public not trust their own ACCs? These are civilians that are appointed by other civilians, police accountability boards, to do investigations. They have the subpoena power. Why are they not using it? Why is it that the ACLU says last night that their end goal is to get rid of all internal investigations, and yet they come in here today and say, no, we just want to give this option to the agencies? There are many reasons. You've been given lots of misinformation, and we ask for an unfavorable report on this piece of legislation. Thank you.
Good afternoon, Mr. Chair, members of the committee. Thank you for the opportunity to speak. My name is Clyde Boatwright, and I'm the president of the Maryland State Fraternal Order Police, representing 21,000 men and women across the state of Maryland. I do want to simply say I appear before you 2 years, well, now 3 years after we passed this historic piece of legislation, House Bill 670 from 3 years ago, wearing a trophy. If we all recall, when we talked about this, my trophy is these eyeglasses. We were under the pandemic and under Zoom at that point. And so now I have to wear eyeglasses because of that. We spent a lot of hours together working on that piece of legislation. And to take a quote from a famous songwriter from the Osley Brothers, here we go again. We're back. Let's let this process work. We have good people that are citizens that volunteer, that sit on these accountability boards and PABs and administrative charging committees. Again, like Mike Shire said, the smoking gun hasn't been uncovered yet. With all of these investigations, as one of the people in support says, that they review hundreds of cases. So we're now looking at hundreds of cases, and we still haven't found the one case that says that this should have been done differently. We feel as though there's a duplication of processes at this point. If we allow this to move forward, let's let the trained investigators investigate. And if we find that a person in our profession has violated some sort of policy, then there are many remedies that already exist, such as the trial board process, such as criminal law proceedings. There are many remedies that can already address the concerns that will be uncovered if this piece of legislation is allowed to pass. So with that and wrapping up, I'm asking for an unfavorable report for House Bill 533.
Thank you, Chair. I just have two quick questions. How would this affect, first of all, recruitment and retention? And then how do the ACCs, why would they not be using the subpoena power?
Yeah, so the recruitment and retention piece is we're already struggling to fill our ranks at this point. I gave an analogy of baseball. We don't have a bullpen. We don't have people that's warming up and ready to get into the game. And so further complicating the process is going to further push people away from this profession. So we would ask under the So when you become a police officer, you go in with good intentions, and if you happen to make a mistake, you would expect that the people that are judging you will give you a fair and impartial investigation and a fair and impartial trial to defend yourself. For those that intentionally make those mistakes, we want to do all we can and use every piece of the law to get them out of our profession. So as far as the recruitment and retention piece, I think that it will continue to hinder us recruiting and retaining police officers because it's another dig. As I said earlier, here we go again. It's another dig at the profession.
As it pertains to your second question, why the ACCs don't use the authority already granted to them under the law, I have no idea. We deal with a lot of cases. Some jurisdictions deal with hundreds of cases, others just a few. I can tell you in Baltimore City, this process has been known and in place since 2021. It took effect in July of 2022. Today, Baltimore City has yet to develop a trial board process under the new law. So all of the cases that have gone to the ACC for sustained charges, exoneration, are sitting in a pile. In my understanding, it's almost 250 right now. They just haven't moved on them. But why the ACCs themselves don't use their subpoena power, or I know they do look at body worn camera because I get to review their reports when the officers are in fact charged. So I know what they're doing, but why they don't use the tools that they have already, I can't answer that question.
I could say that I'm sure many of the ACCs, and I believe it's the case in your Anne Arundel County, our Anne Arundel County, is that the ACC asks questions back to the investigators and gets results. They don't need to go to the subpoena power. If there is an agency who is not getting that kind of open cooperation between their ACC and the police department, that's when that subpoena power should be coming in, and they should be forcing the agency to open those things up. If that's happening, and you had a member of an ACC sitting here saying, who has subpoena power, saying he wanted to give somebody else subpoena power. Well, why isn't he using it himself in his body to get that information that he says is so lacking? I can't answer that. As far as the recruitment and retention, in Anne Arundel County, we used to hire classes of 40, 50 plus police officers. We have a class starting on March 14th. The personnel order came out for it this morning. It came out yesterday afternoon. As of yesterday morning, we were expecting 9. We only got 8. 8 officers. We are, by all accounts, some 400 officers short. That's 30% short. Our agency is falling apart because we cannot provide the services that our community demands. We can't provide the community interaction, the community-oriented policing, the investigations. If we don't stop attacking and vilifying the police profession and trust the people who are doing these investigations, the civilians that this body and this General Assembly has set up to do these investigations, why do we not trust them? They are the people you wanted in those positions. If we don't start trusting their judgment, we are going to keep spinning our wheels with this over and over and over again. We are going down a dry hole. If we don't find anything in that hole, why do we keep digging and digging and digging? Maybe the oil, the water, whatever we're looking for is in a different place.
Thank you, Mr. Chairman. Mr. Shire, I think you were kind of getting there with this when you gave your opening testimony. What do you see as the end goal with this legislation?
I think, as I said, it's frustrating to us that, you have the advocates coming here and saying one thing today and a different thing last night. The end goal is for the advocates. They said it. You can go and find it on the PAB meetings that are public record, to eliminate internal investigations. They say police cannot police, okay, to eliminate internal police investigations and have PABs do all the investigations. Okay, so when they come up here and they say that this is we just want to give the agencies, the jurisdictions, the option, that's not consistent with what they said less than 24 hours ago. Simple as that. We already have an internal investigation, the ACC, an attorney general, an IID. There are tons of investigations that are being done to make sure that police are conducting themselves properly. We wear body-worn cameras, so everything we do is watched. How much more do you want drones to follow us around everywhere we go and record us? Like, how much more can we provide you to show that we are trying to do the best job. Are we going to make mistakes? Absolutely. We are. We're humans. Okay. But why is it that when we do make mistakes, we are not given the same forgiveness at some point after we've served our due, discipline? There is no expungement for our records. There is no, for even our records that are unfounded and not sustained, those remain on our records. We cannot get rid of those when it's a false complaint. Why are we treated so differently in that respect? I don't know.
Thank you, panel, for coming in to testify. So the ACC have the subpoena power, but the PAB wants it, but does not have it. Is that correct?
That's correct.
And the ACC can review unredacted police video footage?
Yes, sir. They get everything that's part of that internal investigation that was conducted by the internal investigation of that local department.
Unredacted.
Unredacted.
So should the PAB get that also unredacted?
I think what happens is the ACC will write up their report. They are eventually can be reviewed by the police accountability boards themselves. I think the way the law that is attempted to be passed now is to give them full authority to do their own thing. They don't want to look at what the ACC gives them. They want to do a separate and complete independent investigation on their own. And that's where we see the negative complications to that.
That would give them access to the footage if they had their own independent.
Yeah, sure. They could subpoena it and get it. Yes, sir.
But
unredacted.
But we should also add that they also have access to it through the MPIA process as well as anybody does. The redactions that are being done are really just to protect innocent civilians. If you're not,
Right.
so they'll blur out somebody's face or something like that. It's not going to not show a police action or what the police officer is doing. It's not like whole sections of video are being redacted out. So yes, the answer is yes, they do have access to the files. They can get access to the video.
It's part of my concern. So
Yes.
Thank you very much.
Thank you, Mr. Chair. Good afternoon, gentlemen. I want to make sure I'm clear. The ACC is an investigative body, correct?
Yes, sir.
All right, and they have access to the footage, and when they're done, they make a recommendation, right?
That's correct. They write a report based on the investigation that they have reviewed, the body worn camera, and with all the options they themselves already have under the law. Like I stated, they can call the officer in and ask him questions about what happened. They can request the investigator to go do additional investigation if they think more should have been done. They can request additional information outside of what's already been done. And then they have the ability to issue subpoenas for anything they want.
And what's the timing on that?
So
How does that relate to the internal investigation?
1 year and 1 day, the way the law reads right now, in a case that involves the public, which would be reviewed by the ACC, it's 1 year and 1 day from the date the incident comes to the attention of the department. And the reason for building that statute of limitations in 2 years ago was to ensure that the public gets these answers as quickly as possible, because some of these cases were taking way too long.
But they're not necessarily doing a concurrent investigation.
The ACC, they're not doing a concurrent,
They're
doing a very thorough review with the ability to request additional information if they need it.
One of the concerns I think the community has is that these reviews be done swiftly and that the PABs be actively engaged. That was the thought, I believe, right? The implication was that they would be involved and all of this would happen swiftly. This sounds to me that this could be and it might maybe one of the reasons why Delegate Ruff has brought this bill. It sounds to me like this could be an elongated process for which the community doesn't get the response quickly enough to either exonerate or to suggest that an officer has not done the right thing.
Sure. No, I understand that, but you also have to understand that these investigations, there's not just one of them. You know, in Baltimore City alone, they do probably 4,000 internal investigations a year. They have, I believe, close to 45 investigators just in their Public Integrity Bureau. These investigations don't happen overnight. There's witnesses, there's body-worn camera, There's a lot of things that they have to look into in order to ensure that they're doing a fair, unbiased, independent investigation. So as much as we'd like to be able to wrap something up in 10 days, 20 days, 30 days, honestly, based on the amount of work that they're doing and the number of complaints that come in, that would just completely be impossible.
And just to give you an example, if there is an incident where 5 officers were accused of wrongdoing and their body-worn cameras are each 45 minutes a piece, you have to watch that entire piece of body-worn camera footage for each officer to see each angle to ensure that you're charging the correct person and you're making sure that you're exonerating the correct person.
And that would include the body-worn camera of any other officer who was on the scene who may not be accused, but may have just been a witness.
So last week, State's Attorney Bates brought an action against 3 officers, happened to be Baltimore County officers, which I represent, who were making an arrest in Baltimore City. That incident occurred in September. It is now February. Had there been a civilian complaint, and I don't know whether there was or there wasn't, my assumption is maybe there was. I don't know what the PAB's actions in that. I would have hoped that the PAB would have been involved to participate in that maybe sooner and had its own independent ability to make some assessment of what took place, just so that the public would feel that what we passed, right, had value.
So what happens, without getting into the details of the case, because we're very familiar with it, I'm somewhat involved. The process for something like that is you would get a citizen's complaint and they would make that complaint. It would go to the police, whether it goes to the police department or to the police accountability board. It would then come back to the internal affairs section of the local police department. They will then begin their investigation. Generally, what will happen is after the investigators at their internal investigation division looks at that body-worn camera, they will immediately get the state's attorney's office involved, because the actions which may or may not have been depicted may rise to the level of criminal activity, not just administrative violations of policy. Once the criminal aspect kicks in, that case is then jointly investigated between the internal affairs investigation and the state's attorney's office. State's attorney's offices, especially with Mr. Bates in charge, he does not rush to judgment. He will make sure that he has a thorough, very clear understanding of the case, that all the witnesses have thoroughly been interviewed, all the body-worn cameras been watched, and everything he can do prior to him initiating charges, not only against the police officer, but anyone else. Mr. Bates is, I've worked with him on the defense side, and I know he will not make a rush to judgment. Some things will take longer than others, but he will make sure that he has all the information before he places charges against anyone.
I'm just trying to understand why. At what point are you suggesting the PAB should not be involved early in that process?
I believe no, they shouldn't. It should be left up to the local police department to do their administrative investigation as best they can. But what you have to understand is that the criminal aspect of that investigation will override any administrative case. And the main reason for that is under a Supreme Court case, Garrity versus New Jersey, if an officer is ordered, if an officer is required or ordered to give a statement about what he did, it cannot be used against him criminally. So there has to be a line drawn so they don't want to interfere with each other's investigation.
I got it. Thank you, Mr. Chair.
Thank you, and welcome, gentlemen. So, y'all talked a little bit about kind of the process that the ACC go through, as well as departments when it comes to reviewing law enforcement actions. I wanted to give you the opportunity to kind of expand on just about the police department capabilities of investigating crimes that take place with officers or complaints when it comes to officers. What does that process look like?
You want to?
I mean, we have, every agency has an internal investigations unit. The public, this body has made it very clear over the past few years, if it wasn't important to an agency before, it certainly is now. And there is a level of expectation in the professionalism of those investigations. There is this accusation that we do not want, that we want to cover up, that we do not want our officers' bad acts to be seen, or that is not true. We want to root out the bad acts of our police officers as badly, if not more, than the public does. We do not want bad actors within our profession to besmirch the badge that we wear so proudly. It is just, it defies logic to think that we would be opposed to officers being disciplined for their bad acts. The investigations are done thoroughly. They are done carefully. If there is, in the case that was just given, the allegations, even right off the bat before an investigation has really gotten off the ground, most agencies will take a quick look at it and say, oh, there is the possibility of criminal acts here. The officer's suspended. They're taken off the street. Their police powers are removed while that investigation is going on. And it's very important to all of us to make sure that that investigation is done thoroughly. Once that investigation is done, it goes to the ACC, as was said. The ACC then has the subpoena power, the investigatory powers to ask for more information. They can say to the agency, hey, you didn't ask this question of this officer. Go ask them that question. Or they can call the officer in and say, we'll ask it ourselves. So the ACCs are the check on that. The ACCs are appointed by the PABs. If the PABs don't like the job that the ACC is doing, they can appoint better people to it. Once the ACC determines there's misconduct or not, then the officer gets offered the punishment. The chief can actually raise that punishment if they so choose. They can't lower it. They can only raise it. If the officer accepts it, which I don't know, what 99% of officers accept their punishment because we'll say, yeah, we did wrong. We'll take it. They accept their punishment and they get it and off they go. Back to training, whatever they need to do to do better in the future. Or if they disagree, then they go to the trial board. The trial boards now include a civilian member and an administrative law judge or a retired judge to make sure that there's a civilian in there and a legal expert. There's also a police officer of equal rank to bring that perspective of the training and experience that an officer gains into the process. Once that trial board makes a decision, that's final.
I wanted to just also add, and this is very brief, there's a notion out there that the internal affairs investigators are some way in shape or form trying to cover up for police and things like that, that there's this whole big conspiracy for internal investigators to not do a proper job. As a 24-year police officer in the state of Maryland, and Mike is a retired captain, Mike Shire is a lieutenant with Anne Arundel County, and so Davies from state police. So all of us have worn a uniform, and I think they'll agree with me. The last person that a uniform officer wants to talk to is internal affairs. There's a divide between rank and file police officers and internal affairs, even though that they are still like us. We just, don't want to talk to those guys. So that's for a number of different reasons, but it's the internal, like, brother and sisterly battle. But it's almost like the SWAT guys and the K9 guys are their own specialty. It's the same with internal affairs. So I just want that notion to be dispelled, that some way, shape, or form internal affairs go out of their way to sweep things under the rug and cover it up. They're the people that's going to make sure they get to the bottom of something that's wrong.
Thank you, Mr. Chair. Thank you, gentlemen, for educating us on the whole process again. I served on the Police Accountability Board as well when we were working on the legislation. 2 questions for you. Mr. Davey, you brought up the potential for multiple outcomes to come out of this potential piece of legislation. So if it were to pass, that would, in your opinion, would that be something that has to be defined?
Yeah, from a defense attorney standpoint, what would basically happen is, and we have some of these cases now between the ACC and the police department. The police department has said, we believe the officer should be exonerated. But the ACC has come back and said, no, we believe that they violated policy. So we do have that. But the way the law is written now, the ACC has the final say. That's how it works today. And honestly, that's how it should be. That's what the independent overview or oversight was done for. But then we have other issues that may come up. Well, what if it goes the other way around? What if the department says, yeah, we should charge him, but the ACC says no? Well, then I've got an officer who may have a sustained internal case within the department for something that might be serious. But the ACC says no, but then this officer, if it's an integrity issue, gets put on a do not call list. And I have no remedy whatsoever to get him off that list because there's no adjudication of the case. So it's a complicated process already. Adding another layer to that would make it even more complicated. I know there was some discussion about witness fatigue and things of that. Trust me, that happens a lot. The more times a witness is interviewed by a police department or an investigator, inconsistencies inevitably will come up. The only place those inconsistencies are helpful is to me as the defense attorney, because I will run with that. And of course, inconsistent statements would affect the witness's credibility, and I would present that to a trial board in an effort to have my client found not guilty. So there's a lot of issues.
If we were trying to tamper with the process and get officers out of trouble when they legitimately should be in trouble, we would be for this bill because it would introduce elements that as a defense would be helpful to getting an officer a not sustained. We are explaining to you that not giving this subpoena power is the better way to hold officers accountable. You are more likely to be able to hold officers accountable if you don't give the subpoena power, if you let this process play out, than if you were to pass this legislation. To some people, that would seem like we're advocating against our own interests, but we're not, because like I said, we are not for police officers committing misconduct. We want them to be held accountable.
My last question, in this process, as we know, it's 1 year and a day to resolve it. Throughout the process, are there benchmarks where the officer and or the victim or both are given updates or notification?
It's currently in the law now.
And by whom is that by? Who
It's by
provides?
the police department.
By the police
There's
department.
already in the Police Accountability Act today, there are provisions where they're supposed to hire a witness victim coordinator, the police departments, and are supposed to update the victims or witnesses or the complainants in these cases on a regular basis.
That's correct.
Some agencies like
And the
my own.
officer as well?
No, I don't
You
think
like,
so.
not usually.
That's the piece
It's usually the
that's missing.
complainant. It's usually the complainant of the case.
And so you don't believe that our officers should have updates as well?
I think generally, based on the department, I usually know what's going on the case.
There are departments, I know police officers who have gone months and months and months with no updates on their case, and they're in limbo. And if, you think they're having parties at home, different. That's not what's going on.
It's very stressful.
Yeah, it is an extremely stressful. It is stressful to go into internal affairs and know that you have a case that is absolutely unfounded. You know for a fact that you will be exonerated. The body camera will show that the complainant is lying, and it is still stressful to know that that is hanging over your head.
So the answer is yes, the officers should be made aware, but unfortunately, they're usually not.
Yeah, I'm sure that would affect the morale of the officer and the agency.
I can tell you,
Thank you.
my firm represents the Baltimore City FOP, and we are at Internal Affairs 5 days a week, and we average 8 to 9 accused statements, interviews by Internal Affairs a day. Not a week, not a month, a day. I have to commit an attorney and a half to sit there every day to just do accused interviews.
Thank you, Mr. Chair. So you guys have explained some of the process in ways that I just want to pull apart to make sure I understand what you're saying very clearly. And it goes to what I was asking the sponsor about, which is what records the PABs have access to. And you started to answer this, but I want to make sure I understand it clearly. So in the law, the PABs receives two of their core functions are to receive complaints from the public and then separately to review the outcomes of disciplinary matters.
Correct.
Are they automatically provided any of the investigatory files or footage for either of those two categories? Of
Automatically, I don't believe so. If they ask, I don't see anything in the law that would prevent them from reviewing it.
It's interesting you say it that way because, again, when I sat here and we were working on this law, I recall we left it unanswered. And so what you're suggesting to me is that unanswered question about whether they do or do not have access,
It's still
you would
unanswered.
but you would answer it in the affirmative, that
Yes.
if they request the full unredacted footage and files, they will get it.
I would think they would, but I don't sit on an ACC and I am not the attorney for the police accountability boards. So I cannot comment or give you an answer as to what they get, don't get, what they ask for, and what they're still providing. That would be
Okay,
up to the
so-
police
And
accountability.
it's also important to recognize that the entire file, because of the actions, removing those internal affairs files from personnel records are completely open to MPIA. So a police accountability board can get those,
Okay,
including the body worn camera footage, which is also subject to MPIA.
so the PABs do not automatically get this. They would have to PIA, they could PIA to get it and be entitled to it, unredacted.
There's going to be some redaction, again, to protect witnesses and victims,
Sure.
as Della Conaway mentioned.
But you also think theoretically they could just ask for it and it should be provided, not could be, should be.
I can't say because I've read the law, I'm familiar with the law, and I'm not sure. I can't sit here today and tell you, yes, that's the way the law reads, and therefore it happens.
And sorry, Mr. Chair, one final, would you agree that if this is provided, as you suggest, it should be and could be, that if we're not talking about running a separate subpoena and investigation, that this is all done at the conclusion of the investigation, the PABs could at least provide an audit function?
Sure, I don't, if they had the ability after the fact to review things, I don't think we would have an issue with that. Because the way the law is written, it's the ACC that has the decision-making authority as it pertains to exoneration, unfounded, or sustained.
And the PAB holds accountability over that ACC because they are one of the appointing functions of that ACC. So naturally, the PAB should be the one to say, hey, we want to see what you're doing, ACC. We agree with it. Okay, you can stay, or no, you're not doing a good job. We're going to get somebody else to do that job. So that's the oversight function. You have civilian oversight over police departments. There's multiple layers already built in so that the transparency that everybody desires is there. And as Mr. Davies said, I don't think we would have any problem with PABs getting access to the investigatory files, assuming that there's the same controls that are there for ACCs to, protect the innocents and all that. That's not a problem.
Seeing no further questions, thank you all very much. That
Thank you.
concludes
Thank you.
Thank you, Mr. Chair.
testimony on House Bill 533, and we're going now to House Bill 960. And I believe presenting is Delegate Simpson. And just the one witness.
All right, I'm going to be quick. Good afternoon, my chair and my vice chair and fellow members of the committee. For the record, I am Delegate Karen Simpson from District 3 in Frederick. And I'm here to ask for a yay vote on House Bill 960, the City of Frederick assignment of offenders to road work. This is a reintroduction of a bill last year that I presented to this committee. This bill is a simple repeal of an outdated, archaic 1917 Jim Crow law that is still in statute in Frederick, but has not been practiced in a very, very long time. To our newer members, this law was passed in, well, neither one of them are here, but anyway, 1917, and required vagrants or homeless people to actually be required to do road work for as long as they were able. And we do not do this in Frederick. And so therefore you will see on your, that we have letters from the Mayor O'Connor, as well as the County Executive Fitzwater, as well as the state's attorney, saying that this is no longer what we do. As you can see by those letters of support, also with the Frederick County delegation, that we all believe that this law should be repealed. And with that, I ask for a yay vote. Thank you.
Questions? Right, seeing none, thank you very much. That concludes House Bill 960. We're going now to House Bill 1060, being presented by the Carroll County Delegation. All right, we'll hold on that one and come back to let Delegate Rose get here. Is the Baltimore City Delegation? Baltimore City Delegation? Oh, okay, yeah, we could do that then. Councilman Conway, come on up. This is House Bill 732. And we'll hear from Meredith Riley, David Kramer. Well, not Meredith Riley. Okay, that's fine. You'll do the council. No offense, Meredith Riley. David Kramer, Rachel Cutler, Christina Roth, Nina Themelis. And
shall I begin?
yes, please.
Thank you, Mr. Chair.
We'll let other people sit down there, but that's fine. Go ahead, Council.
Sure, I'll try to be brief. You guys have heard this all before. I'm here in strong support of House Bill 732, Baltimore City control over powers of police commissioner, which would strike one very short line in the charter of the Baltimore City Charter in Article 2. This is an issue, as everyone is now aware, because we've been here a few times on this issue, that goes back 164 years till right before the Civil War, where the control of the Baltimore City Police Department was taken away from the city of Baltimore and controlled by the state for the last 164 years. In 2021, this body authorized a ballot initiative that would decide once and for all whether or not the Baltimore City Police Department should be a city institution or a state institution. And overwhelmingly, that ballot measure passed with 83% of residents voting in favor of it. But unfortunately, there is still that one very simple line that restricts the city council from writing any laws that govern the powers of the police commissioner. Since that time, we've been back to this body. Unfortunately, that bill did not move last year, and we're back again. But we've been working really, really hard with the support of the local control advisory board advocates who are here with me today, and the administration. Thelma is sitting up here as well to get this done. We passed two bills just at the end of last year that outline the responsibilities of the police department, both in the charter and in the city code. That charter amendment will be up for consideration in this coming election in November. And we're really looking forward to getting this done. This is a straightforward bill. This is hopefully an easy bill for this body to move. Simply what it does is it clarifies the legislative responsibility in line with the actions that this body has taken in the past, and gives the authority of the city council to write laws that govern the responsibilities of the police commissioner. So I urge the committee to vote in favor and urge your support. Thank you.
Thank you, Mr. Chair. Nina Themelis, Director of Government Relations for Mayor Scott, here to testify in support of HB 732 on behalf of the Baltimore City Administration. I'm not going to read most of my talking points because Councilman Conway covered most of them. Just want to reiterate that this was a piece of legislation that was introduced last year as well. There were several actions taken by our city council and the local control advisory board in order to finalize and remove any additional concern that may have existed before passing this final piece of legislation. The last action is just to remove that portion of Article 2, Section 27 from the Baltimore City Charter. That really, based upon an AG opinion from last year, would just remove any ambiguity that anyone might have concerning who has the authority currently to legislate over the Baltimore Police Department. So with that, we're here with our full support for House Bill 732, and I'll keep it short.
Good afternoon. My name is Christina Roth, and thank you for having us here, Chair Clippinger and Vice Chair Bartlett and the rest of the committee. And I am Senior Policy Associate with NAACP's Legal Defense and Educational Fund. HB 732 would effectively authorize the Baltimore City Council to pass ordinances that provide oversight to the Baltimore City Police Department. For more than a decade, Baltimore City residents have pushed for City Council to have local legislative control over BPD, to increase civilian participation in the oversight and accountability of a city-operated police department. LDF urges the committee to enthusiastically support this legislation to advance this long overdue change. I'm going to skip some of my remarks too, since things have already been said. Between 2015 and 2019, 90% of all BPD use of force incidents were against Black people, compared with just 7.3% of force incidents that were against white people. The killing of Freddie Gray in 2015 and the police response to the uprising that followed spurred national attention. These events served as a tipping point for the ongoing 6-year consent decree between BPD, DOJ, and a federal judge, demonstrating continued urgent need for police accountability. In 2022, as Councilmember Conway said, 82% of Baltimore residents voted to ratify a charter amendment, making BPD a city agency. Now that the City Council, with the support of the administration as well, informed by the work of the Local Control Advisory Board, has established the scope of BPD powers and duties and embedded laws governing essential BPD structures and processes into code, we hope the Maryland General Assembly will eagerly support HB 732. Finally, as Black plurality cities around the US are facing an overreach from state legislatures and the US Congress when it pertains to DC, the Maryland General Assembly has a chance to buck this wrong-headed trend and empower also Black residents and all Baltimore residents to regain local control of BPD through their democratically elected city officials. Thank you.
Hello again. Good afternoon. My name again is David Kramer, and I'm a member of Showing Up for Racial Justice, Surge Baltimore, and in collaboration with the Coalition Campaign for Justice, Safety, and Jobs. I've been a native of Baltimore for over 70 years and a resident of 43B. I'm also proud to be a 4th Councilmatic District constituent of my Councilman Mark Conway, who has taken the lead with the City Council in this effort in the last couple of years. I would like to express my strong support for HB 732. Last year at this same hearing, there was lots of division. We're now united in terms of having this passed. This is the last thing that is needed, and it takes away the ambiguity. We're kind of in a no man's land right now of who actually controls the police department. This will help resolve that, and we hope that you would pass this quickly.
Good afternoon. My name is Rachel Cutler. I'm the Baltimore Director of Jews United for Justice and a resident of District 45. On behalf of JUFJ, I'm submitting this testimony in support of HB 732. JUFJ organizes 6,000 Jewish Marylanders and allies from across the state in support of local and state campaigns for social, racial, and economic justice. Judaism's ethic of mutual care calls us to hold police accountable to the people. This is why JUFJ has been working for over 7 years with our partners at the Campaign for Justice, Safety, and Jobs, who have been working on it for even longer, for the restoration of local control of the BPD. Baltimore is the only locality in Maryland and one of 2 in the entire country that does not control its own police department. Jurisdictions within and outside of Maryland have used local control for their police departments to prohibit chokeholds and no-knock warrants, to collect data on use of force incidences and arrests, and to create stronger consequences for police officers who abuse their power. Baltimoreans deserve the same opportunity, yet have remained in a legal limbo, unclear if we can do so. In partnership with the Campaign for Justice, Safety, and Jobs, we are asking you to support HB 732, which would eliminate the last legal obstacle to local control. This remedial legislation removes an outdated clause in Article 2, Section 27 of the Baltimore City Charter that prevents the Baltimore City Council from legislating changes to the BPD's policies and procedures. We have waited long enough. In 2018, the Civilian Oversight Task Force, which was established as a requirement of the federal consent decree regarding the BPD, recommended that local control be restored with all deliberate speed. We must move forward on this fundamental matter of self-governance, racial justice, and police accountability. On behalf of JUFJ, I respectfully urge this committee to return a favorable report on HB 732. Thank you for your time.
All right, seeing none, thank you all very much. I see Delegate Smith is here, but I think they just did your job for you for that, right? Anything else to say? Well done. I think that was a universal signal for me too, so that's fine. And that concludes the testimony on House Bill 732. Delegate Smith, you do have another bill, but let me see if I can, there are people on both sides of your bill. I'm gonna try and work out whether we can get you out of here shortly in a second, but Delegate Rose and the Carroll County delegation is here and it's just her, which is fine. It's more than enough. So, but it is one witness and we'll hear from her on House Bill 1060.
Thank you so much, Mr. Chair, Madam Vice Chair, and to the wonderful, hardworking members of this committee. I appreciate the opportunity today, Delegate Rose, for the record, for House Bill 1060. This bill, you'll have to basically ignore my written testimony. We have amended this bill a couple of times in consultation with our current county commissioners, and the current amendment will be delivered to your office because I literally just got it about 25 minutes ago. Basically what we are doing, so once every term, we do revisit our sheriff's salary. And so we are doing that once again with consultation after our first decision on the bill, based on conversations with our commissioners and their concerns with the fiscal impacts as we move forward with implementing a lot of county structures in our fiscal outlook as we implement Blueprint. What we came to was, if you go to page 2, beginning in 2026, we will be moving the salary for our sheriff to $191,078.10. And then in 2027, we will move it to $212,309. It's very similar to a lieutenant colonel in the state police. However, we do not want to tie it to that moving forward. And that way they can look at what our fiscal impact is at that time and decide moving forward. So that is the basics of the bill. And I appreciate your time and happy to answer any questions.
Delegate Cardin has a question about small change.
Thank you. I just want to know, Delegate Rose, do you have to be a resident of Carroll County to be able to apply for sheriff? 212,000?
Oh, you want to be the sheriff?
Yeah, why not? 212,000? That sounds great.
I mean, I will be happy to hook you up with some real estate agents. We'd love to have you.
Skirt the lines of ethics on this bill. And you're not going to ask her about the 10 cents?
No, I really, inquiring minds want to know about the 10 cents. Not me, but some folks might want to know.
They're basing it, I believe, off the state police pay scale. So that's where it falls, I guess, currently. And that's what we tied it to. Okay. But if I would take it as a friendly amendment, if you would like to remove the 10 cents.
Right. Just round it up. Thank you.
You know that's going to happen now, right? Delegate Moon.
I'm sorry. Thank you, Mr. Chair. I'm just reading the fiscal note. Carroll County would pay the salary increase. Is that correct?
Yes.
And did you say the county did weigh in on whether they wanted to do that?
Yes. So we started off in one posture. We sort of morphed into a second one, which is mostly what my written testimony demonstrates. But after further consultation with our county commissioners, everyone is happy with this final result. And so that was the consensus of our commissioners and our delegation.
Got it. Thank you.
Seeing no further questions, thank you very much.
Thank you. Enjoy your day.
That concludes testimony on House Bill 1060. Committee, I am going to jump Delegate Smith's Baltimore City Sheriff's Bill. I think I see everybody here on both sides so that we can get that done. It doesn't look like it's going to take very long, he said, and then, here we go. House Bill 1034. So we'll hear from Delegate Smith and Mr. Blendy, and then we'll hear from 2 people in opposition. Go ahead.
Thank you, Mr. Chair. And I guess Madam Vice Chair was just here, and to distinguished members of the Judiciary Committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 1034. It is concerning certain hiring decisions that could be made by the Baltimore City Sheriff, and this bill was submitted by request of the sheriff's department. And so it is a pretty simple bill. It will enable the sheriff to continue his professionalization of staff by hiring 2 additional assistant sheriffs, and then also the ability to hire 2 social workers. So that is all that I will contribute to the dialogue on this, and I will defer to Assistant Sheriff Blendy for more details.
Good afternoon, Mr. Chair, members of the committee. Nicholas Blendy, for the record, Assistant Sheriff of Baltimore City, one of the 2 positions that are being added should this committee and the city delegation pass this local bill. Thank you to the chair of our delegation for the brief synopsis. She's correct. Sheriff Kogan, when he ran for office, he ran on a couple of things, and one of the things was more managerial oversight and more professionalization. And so he's asking to increase the amount of assistant sheriffs from 1 to 3. They're already funded in the city budget. They're just not codified yet. That is a important thing he campaigned on. The other change that this makes is Sheriff Kogan ran on humanizing the evictions process. I know many folks in this body are going to hear a lot of bills, particularly one introduced by the governor. Social workers follow the model that I guess Cook County Sheriff does in the city of Chicago. When an eviction is filed, the sheriff's office intervenes the moment the rent notice is posted and tries to provide wraparound services and identify ways to keep people housed or help them find new housing. So we already have the funding for the 2 positions, and this just codifies that and fulfills his campaign promise. Lastly, so that currently doesn't have a number on it. We've been working with the city administration, and we'll be submitting amendments to the delegation to limit that to 2, because that is what the sheriff believes he needs. Lastly, we're working with the administration on some language to make it more consistent about the flexibility and funding provision at the end of the bill. And we'll be working on that. And I do understand people are in opposition to this bill. And I think there might be some confusion because the paragraph that deals with collective bargaining rights and covered employees is paragraph I. That is untouched in this bill and included in both our written testimony and the administration's testimony. Happy to answer any questions. Thank you.
Thank you, Mr. Chairman. Thank you, Chair for coming in and members for coming in to testify. So I was just wondering, can you briefly explain why does Cook County come up so much?
So yes, great question, Delegate. Thank you. So the Sheriff Kogan's very keen on this Chicago model, as he calls it. And what is fascinating about it, and I guess wonder why we haven't done it before, is because the sheriff's office is the agency, at least in Baltimore City and in most jurisdictions, that has that point of contact with people who are about to lose their houses potentially through the evictions process, right? And so it's natural, it's a good fit to embed that office with people who are expert and in talking to people and connecting them to services. And a social worker is very important, right? Because those sworn law enforcement officers wearing a uniform and has a badge, and persons might not share or trust that individual as much as someone who's a trained social worker and wearing civilian clothes and is a civilian. So that's the model. In fact, the members of the office are going to take a visit out there to witness firsthand. We don't have a date yet, but certainly be happy to update the delegation when we have that information.
Further questions? Seeing none, thank you very much. We'll have testimony in opposition now from Mike Davey, Clyde Boatwright, Sabrina Tapp Harper is right there. All right, we'll hear from all 3 of you and go from there. Whoever would like to go first, please.
Ladies first.
Good afternoon, Mr. Chair, Vice Chair, committee members. Thank you for allowing me to present testimony today in opposition of House Bill 1034. I'm Sabrina Tapp Harper, Secretary of Lodge 22, the Baltimore City Sheriff's Office, one of the exclusive bargaining representatives certified by the Baltimore City Labor Commissioner to bargain wages for the deputy sheriffs in Baltimore City. I'm also a retired major from the Baltimore City Police Department, 26 and a half years of service, and former assistant sheriff, as I was the highest ranking woman sworn and appointed in the history of the Baltimore City Sheriff's Office, serving that office for 9 years. The Fraternal Order of Police Lodge 22 is tremendously concerned about the introduction of House Bill 1034, as it is viewed as both anti-union and anti-collective bargaining. In short, this legislation seeks to deprive union members of the right to collectively bargain for wages. It would permit Sheriff Sam Cogan to establish any additional positions in his office at any salary, making Sheriff Cogan the only sheriff in Maryland who could establish his own positions using taxpayer dollars, and making FOP 22 the only bargaining unit in Baltimore City that cannot bargain wages. Currently, the Department of Budget and Management, not the City Council or the sheriff, sets the salaries for deputy sheriffs. President Shauna Carroll, president of the FOP Lodge 22, stated the following: "We are more than disappointed that Sheriff Cogan will not support a simple fix that would permit FOP 22 to bargain wages with the sheriff in the city of Baltimore. Instead, the sheriff insists on claiming he has sole authority to establish positions and wages within his office. Right now, the city is writing a blank check to Sheriff Cogan, who continues to claim unfettered authority to spend money as he, not the taxpayers, see fit. I respectfully request the committee return an unfavorable report for House Bill 1034. Thank you.
Good afternoon, Mr. Chair, members of the committee, Madam Vice Chair. My name is Clyde Boatwright, President of the Maryland State Fraternal Order Police, here on behalf of Lodge 22 President Shauna Carroll, who is unfortunately out of the country. We stand with our local union that just unionized just 2 years ago, the Baltimore City Sheriff's Office. They have a collective bargaining agreement. This would, and I had a conversation, in-depth conversation last night with Sheriff Cogan. The way we see subsection I, this would allow the sheriff to create a position such as marshal, bailiff, constable, whatever he chooses to call it, and not pay the deputy sheriffs a comparable wage. He can decide to pay these people that he will create any salary that he chooses, and it's not necessarily overseen by the Department of Budget and Management. As Madam Assistant Sheriff stated, this will be using state law to basically give the sheriff the ability to force Baltimore City government to pay his budget, and it's an unchecked blank. It's an overseen blank check. He can do whatever he wants when he creates these positions under subsection I for any sworn personnel. So we are vehemently opposed to this. We've worked over the years with Delegate Stephanie Smith, so I'm not sure she's aware of this, but this is another tactic to just go around the collective bargaining process, and we would ask that you would return an unfavorable report for this piece of legislation.
Thank you. Just briefly, good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police. And as President Boatwright said, we're requesting an unfavorable report on House Bill 1034. The way this bill is written, this is a difficult process for the FOP. Under the bargaining law that pertains to the deputy sheriffs in Baltimore City, for whatever reason, when that law was created, it allows them to bargain working conditions, but it doesn't allow them to bargain wages. Doesn't make a lot of sense, but that's how it's written in the law. So basically, any raise or increase in salary or any base salary is really driven by two things: the sheriff and the courts and judicial proceeding, which does set a limit on what they, at a minimum, what they have to pay them. By changing in this law, we're now adding 2 assistant deputy or assistant sheriffs. It says social workers. I understand there might be an amendment now to just make it 2. But what they did in section 2 is the sheriff may appoint up to a maximum. The law currently says how many he has to have. Now it's up to. And what the FOP sees now is him reducing the number of deputies in order to pay other individuals, social workers, his additional 2 assistants, and anyone else he seems fit, any salary he wants to give them, because there's no control at this point. He can do what he wants as long as he meets the minimum salary in court judicial proceeding for those deputies. It's a pot of money that the FOP cannot bargain for wages, which then again gives the sheriff the ability to pay whoever he wants, whatever he wants, as long as he stays within that budget. We just don't believe that's fair and equitable to the men and women and the deputies of the sheriff's department. Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Was this bill heard in the Baltimore City delegation?
It was heard on Friday. It was not on the agenda, but it was heard on Friday, but there was no vote. The vote was held over from what we watched on the live stream until next week. Well, this week, I'm sorry.
Did you get to testify?
No, we did not. We were prepared to testify, but it wasn't on the original agenda. And we were notified at like 8 o'clock in the morning that it was going to be heard on Friday. So we didn't get a chance. We would have brought these issues up then, but we didn't get a chance to testify.
Are you going to communicate this information to the Baltimore City delegation, you guess?
Yes.
Okay, thank you very much.
Yes.
Thank you. And I do wish we could have heard some of these points in delegation, but just to be clear, the city has no objection and believes that they still have all the normal powers in their budgeting process as they currently do. Is that correct?
Well, so here's the problem. The city has to pay the budget, but the sheriff does not want the city to make decisions on day-to-day operations. So as it currently stands, the labor commissioner of Baltimore sits at the table and negotiates the salary and all of the different provisions. But the sheriff wants sole authority over top of that. And he just wants the city to just write the check and stay out of the sheriff's office business. Under subsection I.
But that takes no power from the city's budgeting process.
I'm sorry?
The city's budget powers remain identical. So I mean, nothing in here that I can read takes away from the city's budgeting powers.
It says, ma'am, it says,
yep,
any additional sworn or civilian personnel to be hired that are funded by the sheriff's operating budget or by any other funding source.
So you're pointing to the any other funding source? Is that what you're relying on?
Yes.
So you're worried that he could get a grant and that would not be subject to the city's budget authority?
And it says any additional sworn or civilian positions.
Well, as Council Mike Davies said, it says up to 103 deputy sheriffs. He can say, all right, we're going to have 50 deputies and 53 constables, or 53 bailiffs, or 53 marshals, or whatever he wants to call them. And then he can pay them, you know, the deputies, he'll pay them the base salary that's under Department of Budget and Management. But the marshals or deputy or constables or whatever, he creates this name, you can pay them $90,000 and pay the deputies 50. There's no oversight to say that he can't do that.
Well, the city, I'm saying the city through its budgeting process, at least through its budget, does have that oversight, as far as I can tell. But you disagree with that?
I think that once you give if this bill passes, it gives him the ability to set his priorities, and the city wouldn't have too much oversight over his priorities.
Okay. I think
and I want to note that there's no other administrator in the city of Baltimore that has this type of authority. Not the state's attorney, who was also elected, or any other member of city government. The police commissioner doesn't have this authority. No one else does.
Well, that's not correct. I mean, it's very unusual because of the state role of the sheriff that there's any codification of their personnel positions. The state's attorney, for instance, there's not state law telling the state's attorney how many positions they can hire. That's up to them, and of course, they're subject to the city budget process, as are the other agencies. The fire department, we don't say in state law how many people they can hire, but the unique nature of the sheriff, of course, is the reason historically.
Yeah, I think the bigger issue is the fact that they changed the language to an up to a maximum, and that would give the sheriff the full ability to reduce the number of sergeants or anyone in the bargaining unit, and then take that extra salary funding that's in his overall budget and do whatever he wants with it. And that's obviously a concern due to the fact that the current state law does not allow the deputies to collectively bargain for wages. Okay. They're basically at the will of the sheriff.
Thank you.
Mr. Chair. I do have a question with the up to, and I guess this is my question. What would concern me would be if he were to say, instead of 103 deputy sheriffs, the up to, and he say he wanted to be 75, for example, is there any protection in your bargaining unit where, say, he wanted to reduce that by 25 and reclassify individuals? Could it be made mandatory involuntarily, or could it be through attrition? Say he has 40 vacancies and he wants to reclassify. Are these individuals protected from being involuntary reclassified?
No.
No,
No.
Okay.
no.
Seeing no further, okay, Delegate Roberson.
Thank you, Mr. Chair. You know, I rarely ask, but I just, for clarification's sake, as far as legislation as written, it says the sheriff shall appoint. Would you be amenable if it said may appoint?
I would say no, because to the sheriff, may generally means shall.
Well, I mean, it says may as well to
We would be-
103 deputy sheriffs. So
we
that
would be
means
confident he
if
would do it.
we're using that interpretation, then it would be shall appoint 103 deputy sheriffs if we're going to use that interpretation. So I'm just trying to find a middle of the road, just because we see the need also for counselors in that aspect. And so I'm trying to find a way for the city and the FOP to come to.
And to be clear,
agree.
the addition of the assistant sheriffs is not our issue. The additions of the social workers is not our issue. It's about the collectively bargained positions that we are concerned about. If we remove this piece of subsection I3, if that is removed, we wouldn't have necessarily a big issue with this piece of legislation moving forward. If it only gives them the 2 assistant sheriffs and the 2 social workers, we're fine with that.
Take out.
Oh, I'm sorry, subsection 2.
Thank you. So you're saying the removal of don't allow the sheriff to appoint 103 deputy sheriffs is what you're saying?
No, I think we'd have to take out the language, the added language of up to, and leave it the way it currently is in courts and judicial proceeding.
Understood.
And strike triple small I.
Okay, thank you.
Seeing no further questions, that concludes the testimony on House Bill 1034. Thank you all very much. We're going to go to 1209 next.
Is that us too? 1209?
Yeah. Delegate Cardin, Timothy Bradford.
Good afternoon, Mr. Chair, members of the committee. House Bill 1209 is a simple penalty reduction bill for drug paraphernalia. What you heard a bill earlier this session that attempts to, and I'm still pushing for, a decriminalization. However, this is a much simpler bill that I can explain in greater detail if you want. But basically what it does is it takes down the penalty from 2 years to 1 year for anybody who for a second offense from 2,000 to 1,000 and from 2 years to 1 year for anybody in possession of paraphernalia. We, as has already been indicated in the past, this was something that was just overlooked and missed in our previous Justice Reinvestment Act, and I would ask us to correct it. And this is a simple bill that just takes care of that penalty and making commensurate with what it should be based on the other types of offenses in the code.
All right. Good afternoon, Chairperson, members of the committee. My name is Tim Bradford. I'm with the Office of Public Defender for Caroline County. The Office of Public Defender is in favor of House Bill 1209. It takes away incarceration for the first offense and lessens possible incarceration to subsequent offenses. As I've told the committee before, incarceration is not the answer. This is a public health issue. Also, drug paraphernalia laws can lead to improperly discharged syringes. The threat of incarceration causes addicts to dispose of paraphernalia as soon as they're done using the paraphernalia to lower the risk of arrest and/or incarceration. And finally, drug paraphernalia laws are not equitably enforced across different racial groups. African Americans are more likely arrested for paraphernalia charges, even though more drug users are Caucasians in the United States. The statistics back that up. We asked the Office of Public Defender asked for a favorable report as to House Bill 1209. Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. Can you be more specific as to what type of paraphernalia you're talking about? Are you just talking about needles or something else?
So this is for, the definition of paraphernalia. Possession, intent to use drug paraphernalia. It is any type of object that's used to help administer plants or other types of CDS to inject, inhale, otherwise induce CDS into the human body. It could also be the types of objects that would cultivate, harvest, or manufacture, compound, convert such types of CDS into usable drugs. Does that make sense?
A empty leaf wrap be considered paraphernalia?
So that's a good question. So my aide, who is a diabetic and needs to use insulin and uses it by injection, he asked, if he's caught with for example, a needle or a spoon that he uses for his insulin, or something else, any other type of device, like what did you talk about? A leaf rack? A leaf wrap? Okay. Any other type of device, if you had it, but it was not, the intent was not to be used for CDS, then no, it wouldn't be considered paraphernalia. However, if the intent was to be used for CDS, controlled dangerous substance, in an illicit way, then yes, it could be considered paraphernalia.
Would not be considered paraphernalia?
No, and if he gets arrested, the charges would probably be dropped once they found out that there was no CDS, there was no elements or even negligible amounts of CDS in and around the paraphernalia. Usually that's how they determine that it's paraphernalia.
I thought it would be dropped because he has a medical excuse.
Right, I think so, but I think they would have to test the device first to make sure that there were no CDS that was actually in the syringe.
Thank you very much, Doug.
Seeing no further, I'm sorry, Delegate Moon.
Thank you. I was hoping you was gonna ask a question.
Sorry, thank you, Mr. Chair. Just based on murmuring around me, I just want to clarify for you. This bill, to be clear, that list that we're seeing in the bill of items, you're not proposing those to be criminalized. That's existing law.
That's correct.
And what your bill is doing is reducing the jail time for possession of that list of items, correct?
Thank you, yes.
Yes, okay.
Yes, that is correct.
There's some confusion about this.
The question was, what is paraphernalia? The definition of paraphernalia is already in the code. I was just kind of.
No, I understand.
And I was just saying that all this does is reduce the penalty for possession of it from and the amount of money that you would have to pay on a second offense.
Thank you.
Thank you, Mr. Chair. Thank you, Delegate. I think I'm reading this right. I just want to make sure the one under 619 and then 620, the penalties and link up, they're the same for the first.
Correct.
That's what I want to make.
That's the goal of the bill.
Thank you.
Seeing no further questions, we'll go to testimony in opposition. Moreau Williamson, please.
Thank you.
Sure.
Good afternoon, Chairman Clippinger and members of the committee. My name is Moreau Williamson. I'm an assistant state's attorney in Anne Arundel County. I've been a prosecutor for 15 years and prosecuting felony narcotics cases for about 9. Today, I am representing the Maryland State's Attorneys Association. With regard to HB 1209, I really don't disagree in terms of reducing the penalties under 5619 for paraphernalia commonly used to use drugs, not opposing that. However, 5620 addresses different kinds of paraphernalia. Section 5620 addresses paraphernalia that's used to manufacture and distribute controlled dangerous substances. addresses paraphernalia that's been obtained under methods of fraud or deceit. There should be a distinction between 5619 and 5620. If this committee wants to reduce 5620, that's one thing, but it should not be on par with 5619. I do not believe such a strong reduction should occur. Thank you, and I welcome any questions.
Thank you, Mr. Chair. I just want to make sure you were aware there was a separate bill that fully passed both chambers. It got vetoed and blah, 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 but it actually removed fully a range of items from the definition of controlled paraphernalia entirely. And so I gather the sponsor is seeking some middle ground here. The bill as introduced here applies totally to all paraphernalia categorically, but I guess you're suggesting controlled paraphernalia should be pulled out. One of the subject objects in all of this has been the syringe and spoon combo. And I guess what would you make of where the appropriate penalty for that should be?
So a syringe and spoon for personal use combo would fall under 5619. So that would be the proposed 1-year penalty, which seems reasonable because simple possession of heroin or cocaine is a 1-year penalty. So the paraphernalia, I agree, should not be a higher penalty than the actual substance inside. The issue I'm addressing is under 5620, items that are commonly used to prepare a controlled dangerous substance, a cutting agent, a sieve, a measuring spoon, something that a drug dealer would use to manufacture drugs in order to sell them to someone else. So we're talking user versus dealer.
So just to clarify then, you would not oppose this bill if it clarified on that controlled paraphernalia section that the manufacturer, sort of the production bits are separated from the user bits, because the syringe actually does appear in the controlled part.
Correct.
And this has been one of the points of confusion over the years.
I do believe a syringe should still fall under 5619. It's still paraphernalia used to inject, a controlled dangerous substance is a human body. You don't want to go down the slippery slope of decriminalization regarding that. However, the distinction that I'm making today is between 5619 and 5620. I do not believe that the penalties should be the same for both of those code sections to go from 4 years down to 1.
Okay. All right. Thank you.
Thank you, Mr. Chair. I have a far easier question than that one. The Attorney General's written testimony, she says, Tiffany Johnson says, where did I lost it? Criminalizing drug users as opposed to treating them can be costly and counterproductive. I remember when I reached out last year to my state's attorney's office and asked how they felt about it was either this bill or another, or maybe the other bill that Delegate Moon had mentioned. And I asked about kind of what the Attorney General is hitting on. And their response was that, it's not necessarily, it's not that necessarily, we're trying to lock up, throw away the key with addicts, but that it's used as a mechanism to get these folks into treatment and to, get them into the system, which for the most part now, we've got drug courts and whatnot. Do you have any comments on that?
I know a lot of people end up in treatment from a judge. They got caught, they have to go to AA or NA. I think treatment as a result of being caught with a personal amount for an addict, yes, that's appropriate.
Seeing no further questions, thank you very much. That concludes the testimony. I'm sorry, Delegate Moon coming back. Go ahead.
Okay.
I'm sorry, Mr. Chair. I want to be very clear about this because we've been talking about this issue for so many years. 5620 controlled paraphernalia. It's a 4-year prison term in Maryland and the definition of paraphernalia includes paraphernalia to administer drugs. Does that not implicate things like syringes?
So that is how the law as it stands. If the committee or the legislature would like to make that distinction, that's something that
So again, you would not
Welcome to do-
oppose pulling that out of the
The-
4-year penalty?
The issue is it a drug dealer item? Is it a sieve? Is it a scale? It is to make drugs, to distribute drugs. That is different than simple user paraphernalia. So if that's something that the committee would like to address, that may be something to look into.
Okay, thank you.
Okay.
Okay, thank you very much. That concludes the testimony for House Bill 1209. We'll go now Delegate Cardin, House Bill 15, call up Mike Davey, Mike Shire, Clyde Boatwright, Ari Plout. Yeah, that'll be the next panel. House Bill 15.
You guys can center stage. I'm just the. Thank you, Mr. Chair. Okay, now we're talking turkey. Okay. Ladies and gentlemen of the House Judiciary Committee and Mr. Chair, John Cardin on House Bill 15, asking for a favorable review on this bill. This is legislation that I'm pulling in my notes. I got so caught up on the last one. This is the year and a date bill. Okay, so this is a bill you heard in the previous. Oh, this is I'm on 15. I apologize. Okay,
I called 15.
Thank you, Mr. Chair. Trying to use up all my time here so I can. This authorizes a law enforcement officer who has been administratively charged either by the administrating charging committee or the law enforcement agency to file a petition to show cause in the circuit court. If the officer believes that the right granted under the Maryland Police Accountability Act has been denied or violated, the petition must be filed prior to the start of the hearing in the jurisdiction that is consistent with the appeal rights at the conclusion of the hearing. Additionally, if a circuit court judge agrees that the law enforcement officer's rights were violated, the judge has the option to order an appropriate remedy. You heard about the statute of limitations running issue in this one. Certainly tolling should be allowed. You'll see testimony opposed that I believe this isn't the one that the ACLU talked about tolling, but there should be tolling that should be permitted if a hearing has been commenced and that is causing a delay in the decisions of the administrative agency, then there's no reason why I wouldn't have a problem with a tolling agreement there. I just think that police officers should be given at least the same rights that every ordinary day citizens have, which is to be able to bring something to the circuit court if their rights have been violated. And so I would ask us to move favorable on this.
Good afternoon, Mr. Chairman, members of the committee. My name is Ari Plout. I'm here on behalf of the Maryland State Fraternal Order Police in support of House Bill 15. Thank you, Delegate Cardin, for sponsoring this legislation. We see this this is a pro-employee piece of legislation. As Delegate Cardin outlined, this bill would allow an officer to be heard immediately if a right was denied, if an officer was administratively charged. By virtue of this is pro-judicial economy. It would prevent a lengthy delay. There have been instances where an officer is waiting, not getting paid, and ultimately would receive back pay. But for that lengthy delay, this would provide the officer immediate access to address that. You will hear from the experts to the left of me. They'll go into more detail, but I thank you for the time, and we ask for a favorable report.
Again, Mr. Chair, members of the committee, thank you. My name is Clyde Boatwright for the record, President of Maryland State Fraternal Order Police. The history of show cause orders is simply just to give the officer a remedy if their rights were violated during an administrative investigation. We do have an example of in a time where a show cause order would have been sufficient, and that was recently in Prince George's County about a year ago. There were 14 officers charged as a part part of an investigation to which all of the officers were suspended without pay for a period of 9 months. After the 9-month period, there was insufficient evidence to move forward with the criminal proceedings against them. And so the charges were dropped and they were reinstated. But throughout that 9 months, the officers' kids' tuition, their health care, their mortgage, and everything else, those bills still came in. And when you were suspended in an unpaid position based on an allegation, these officers knew that their rights were being violated, and the only remedy that was available to them since this law change was, and please forgive me, I'm the only non-lawyer on this panel, it's a writ of mandamus, which was filed, and it still has not been heard as we speak today. And that case was almost a year ago. So a show cause would have given the officers the opportunity to go before the circuit court to be heard and have those issues addressed. So we would ask for a favorable report in this piece of legislation. Thank you. House Bill 15.
Thank you. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police. As already stated, this bill would simply allow the law enforcement officer prior to the beginning of an administrative trial board the opportunity to go to the circuit court in the location in which his department works in an effort to have the court require the department to show cause why a certain right under the Maryland Police Accountability Act was not followed or granted. The action would require the law enforcement, as I stated, require them to explain it. The purpose of the bill basically is just judicial economy. We would like to try to get out in front of this issue before having to waste the department's time and money going forward with a trial board that may not have had to occur in the first place, or even have to do a trial board a second time if a right was in fact not granted. We're already starting to see some examples of violations of the Police Accountability Act as they pertains to the provisions of the statute of limitations clause for those cases that go to the ACC. And we're also starting to see cases where the departments are sending cases to the ACC that by law shouldn't be. And we're seeing cases that should have gone that aren't. That's delaying the entire process. We can make that argument in a trial board. If we lose, we're going to go through the whole thing, have to appeal it. Whatever happens to the officer, whether he's disciplined or he could be terminated, have to file an appeal, and then we may have to do this entire trial board all over again. So it's basically just judicial economy, trying to get out in front of a negative problem before it happens. And based on that, we're requesting a favorable report on House Bill 15.
Good afternoon again. Mike Shire with the Maryland Fraternal Order of Police, speaking in favor of House Bill 15. This bill is a problem solver. It simply allows us to fix a problem before we get too far down the road. Heard a lot of fancy legal terms, judicial economy, writ of mandamus. I'll simplify this. Okay, I analogize this to like building a house. Somebody points out that you're building the house and the foundation is broken. It's not going to support the house. Say, no, leave it alone. It'll be fine. You build the house, then the building inspector comes in and says, that foundation is broken. Tear the whole thing down and start over again. And you got to tear the whole house down and you got to dig up the foundation and start over again. It's a waste of time. It's a waste of effort. One of the foundational claims of the opposition is that of the LEOBR was that it took too long to discipline officers. Well, how long is it going to take when you have to basically double the amount of work? You have to go all the way back to the beginning and start over. You're gonna have to build that house twice. If there's a procedural error that's not corrected, the appeals court, the circuit court in this case, will basically say, nope, go back, start over, do it again. Their rights were violated. The officer will go through the entire process tainted by that procedural problem, and then they'll have to begin from scratch. On top of that, if you're opposing this, you're basically saying, it's okay, we don't mind that a chief might be able to illegally suspend an officer without pay for months or years, as has happened, forcing the officer into that position where they can't feed or house their family. And they have no recourse except to wait for the disposition of the trial board and then appeal it and wait for the appeal to come up in the circuit court and go through all that and then go back. That is abhorrent, right? We should not be putting our police officers in that position where they can't pay their bills because of an illegal action against them. This will end up costing the agencies money because they're going to have to go and pay the back pay and pay for all the do-overs on the trials. And those do-overs could have easily been tainted by the original case and make the case unwinnable even on its merits, which defies the actual purpose of the MPA, which is to properly discipline officers. So we ask for a favorable report on House Bill 15.
Thank you, Mr. Chairman. Thanks for being such an honorable, distinguished panel in front of us, even my colleague Delegate Cardin down there. It seemed in the beginning as if you didn't know how this committee works, but that's okay. My question has to do with page 2, lines 3 to 4. It states that officers who are employed statewide or by county have original jurisdiction in the Anne Arundel County Circuit Court. What is the logic behind that? Why it wouldn't be wherever the offense or potential took
So
place?
if you are an individual, say you work in the Princess Anne Police Department, you would file that show cause in Somerset County. If you are in the Maryland State Police or the Maryland Transportation Authority, where you have statewide jurisdiction, we agree that it should be filed in Annapolis, and that simply files the appeal process of an administrative trial board under the Police Accountability Act.
So there's precedence.
We're just following the Police Accountability
Thank you very
Act.
much.
Thank you once again and appreciate the panel for returning. Can you tell me a little bit about when we talk about show cause order dealing with our law enforcement agencies, when an officer is set aside or set aside, what can they not do? Can they go get another job? Are they allowed to work another job, or what can they do to earn a living?
So it's difficult. Every department's kind of different. You can be suspended 2 ways. You can be suspended with pay. And if you're suspended with pay, generally you are brought back to the department. And again, it depends on the department. You can be brought back to the department to do an administrative job. Basically, the only thing that is suspended is your police powers or your ability to carry a gun and make an arrest. So that's one way to be suspended. And that really has the impact on their finances there is generally when you're suspended with pay, you cannot work overtime and you cannot work any secondary employment, which is granted under the law. The other section is when you're suspended without pay. There, you're staying home, you're not getting paid. Most police departments there will waive their provisions of secondary employment, and you can pretty much work where you want within the guidelines of the department. You can't be a bouncer, you can't work at a strip club, but you could go work at Home Depot or something of that nature. But the job could not have anything to do with the ability to carry a firearm or make an arrest.
Thank you. I want to start this question off nicely by telling Sergeant Boatwright that he has a very snazzy bow tie.
Thank you so much, sir. I really appreciate it.
But my question is, my question is that the NAACP of Maryland is very strongly opposed to Delegate Cardin's legislation. They say that there's a significantly negative racial impact for communities of color, and that the communities of color, and that the bill, if enacted, would exacerbate racial disparities for communities of color that they assert are already marginalized. Can you tell me why you think they're wrong?
Well, so there's no impact on the investigation. There's no impact on the decision-making of the chief of or sheriff. If the officer decides to seek counsel, and the fact that they feel as though that one of their rights have been violated, putting this before the circuit court does not delay the process at all. Everything is moving along concurrently together. So the investigation part and the officer's due process hearing would happen together. So there's no roadblocks, or it does not have a position where it would impact communities of color, because it's the officer's right, that it's the officer that's alleging that his rights are being violated. So there's no impact on those that file complaints.
And if I may just add, Delegate Kaufman, as it pertains to any delay, there's been case law on show causes on law enforcement cases in the past. It's the Hayden case. The Hayden case basically says that if you file a show cause, it is not an automatic stay of that proceeding. The court basically ruled you can stay it. It might be in your best interest to stay it to the department, but there's nothing in the law that requires it to be stayed. So it can move forward.
And
go ahead.
Delegate Kaufman, I just wanted to make sure. So philosophically, from a public policy standpoint, the NAACP, and they made it very clear in their testimony, they do not like the LEOBR, the Law Enforcement, Bill of Rights. And we moved away from that with this new legislation. And I think they're trying to suggest, and maybe we'll hear from them later, that this is moving us back that direction. And I think that what you've heard from this panel is that is not only not the intent, but that is not what this bill does. What this bill does is it gives people who believe that a right has been violated an opportunity to have some process to just look at it in a concurrent way while the investigation is going on. And I think that from a public policy standpoint, this is not only creating judicial economy, but it's also making sure that we're treating everybody with the rights they deserve. I don't think this is going to in any way marginalize any communities or disproportionately harm communities of color. And I just, so I would just disagree from a public policy standpoint with what they're saying. I understand it, and I'm happy to work with them. I just think that we're talking about apples and oranges here.
Delegate Valentine.
And thank you, panel. This question is directed to Mr. Shire. I'm trying to put this together on the bill. The circuit court for an order that directs a law enforcement agency to show cause why the right should not be granted. And when we're dealing with law enforcement agencies and administrative charging committees, how would an agency respond if it was actually the administrative charging committee that was violating the right?
The agency fully has the ability to respond and say, this is what the ACC did, and, present that. The lawyers for the ACC are hired by the jurisdiction of that same police department. So they can just give their response that this is what they think is going on. And if the court finds that somehow the ACC violated those rights, then the officer's rights, then they can provide the appropriate remedy.
If I may, we're going to see most of these, what we perceive to be violations of either rights or provisions, are not really going to happen from the ACC. They're going to happen from the police department as it pertains to a statute of limitations. That's clearly on the police department. Whether the police department sent the appropriate case to the ACC or not, that's up to the police department. So most of these show causes, and I can't honestly at this point think of one that would be directed towards the ACC. They would be directed to the law enforcement agency themselves.
Any further questions for this panel? Seeing none, thank you very much. And concludes the testimony on House Bill 50. We're now going to House Bill 188.
Is that, I think isn't there?
Oh, no, I'm sorry, there's opposition. Oh, my
Yeah.
God. I am so
I'd be
sorry.
happy if you want to end there.
Oh, my. So I genuinely apologize. I knew there was opposition. I'm sorry. I apologize. Robert Landau, David Roca, Shauna Kess. Oh, my God. And then Jerome Spencer and Joshua Harris. I don't think Mr. Harris is here. Is there somebody? But that's fine. Jerome Spencer is virtual, I think. No, and I'm sorry?
Information not up to.
Oh, I see. We'll have you come next. I'll take them and then I got it.
Thanks.
That's why it's highlighted. I'm used to that being. Okay, I'm thoroughly confused, but let's hear from Mr. Roca first. That'll help clear things up.
Thank you very much, Mr. Chairman, members of the committee. My name is David Roca. I'm a staff attorney with the ACLU of Maryland here in opposition to HB 15. We heard two important statements today from the proponents. One, that officers should have the same rights as others, and two, that this would promote judicial economy. Both are frankly ridiculous assertions in the context of this bill. There is no other public employee who has the right to interrupt disciplinary proceedings by filing an order to show cause, as this bill would establish, bringing back one of the worst provisions of the LEOBR. And in terms of judicial economy, the way we operate our court system and administrative proceedings shows that we are creating a special right here for police officers, because in no other context do we allow litigants to file piecemeal appeals, interrupting proceedings to appellate courts during the process, except in truly extraordinary circumstances with judicial approval or defined by statute. this bill would not promote judicial economy. It would produce the opposite. In our written testimony, I noted multiple appellate court decisions here in Maryland that talk about how the old order to show cause process in the LEOBR was a truly extraordinary, unusual remedy, as one court put it, a powerful and unusual exception to the usual rule requiring an appeal only after a final judgment. When else can a party seek an interlocutory, preemptive, in limine ruling from a superior tribunal before his rights are even violated? I think that shows how this is such an absurd and wrong provision. With that, I thank you for your time and urge an unfavorable report.
Good afternoon, Chairman, members of the committee. My name is Robert Landau. I'm a resident of Gaithersburg in District 17. I'm testifying on behalf of the Silver Spring Justice Coalition in opposition to this bill. I won't tell you about the SSJC because I already have, but I have 4 points I want to make. None of the parade of horribles described by the proponents of this bill when they talked either this today or last year have come to pass. They have alluded to problems, but none of those have actually occurred. In fact, the MPAA's disciplinary procedure seems to be working, and it would be premature to change the structure without more research and input from all stakeholders. Secondly, the bill would create an exception for employee discipline procedures in virtually all arbitration of employee discipline. The employee cannot interrupt the process to complain to a court that some right has been violated. Think about this judicial economy argument. It's actually providing 2 bites at the judicial apple because they're asking for it first to show cause and then to appeal the trial board. The same should be true of the trial board. If there is an issue about whether there is a whistleblower or some other problem that the officer was protected by, that can all come out. It can come out in the ACC deliberation. It can come out in the trial board. We don't need to change the process. And when Mr. Davey talks about there is no requirement that there be a tolling or suspension of the statute of limitations, what he's really saying is that if the law enforcement agency doesn't complete their process and the ACC therefore can't complete theirs, the 1 year and a day rule can expire and there can be no appropriate justification for suspending the officer. So for all these reasons, we ask for an unfavorable report.
Please go ahead.
Thank you, Mr. Chair, and members of the committee. My name is Nashana Kess. I am the Executive Director of the Maryland NAACP, and we stand in opposition to this bill. This bill aims to resurrect the detrimental provisions of the Law Officers Bill of Rights by allowing police officers under investigation for misconduct to halt these proceedings by claiming certain rights violations. Such a measure not only obstructs justice, but also perpetuates a system that shields officers from accountability. When an officer files this show cause, it may not be heard immediately. We did hear that it may be heard immediately. These courts are have a long list of hearings. And so putting these on the docket may certainly extend the time frame. People of color are often impacted by the bad acts of police officers. More often than not, the person on the other end of the complaint is a person of color. In addressing the court process, the attorney on the first panel stated that the court may continue at the same time as the administrative hearing. But he also basically said that it is best practice to request the halting of the administrative process after filing this hearing. So yes, this impacts the marginalized people because it continues to interrupt the accountability for the officer when they may harm this community, my community. We urge lawmakers to reject this bill unfavorably. Thank you.
Questions for the panel? Seeing none, thank you very much. We're going to go now to our informational testifiers. And we'll hear from Jerome Spencer, and I don't think there's anybody here from the Baltimore City PAB, so we'll just hear from Mr. Spencer, and this is informational testimony only.
Yes, good afternoon, Mr. Chairman, members of the committee. My name is Jerome Spencer. I'm the General Counsel for the Charles County Sheriff's Office. I'm here today on behalf of the Maryland Chiefs and Sheriffs Association. I'm here to provide you some information to consider as you discuss among yourselves House Bill 15. So in broad terms, it'll be very clear the chiefs and sheriffs absolutely support due process for all of our employees, including our police officers. But there are three things we want you to be aware of as you deliberate on this bill. Number one, the show cause order does cause delay, inevitably causes delay. At a minimum, we have to get a circuit court hearing. When is that going to take place? The next day? Highly unlikely. The next month? Maybe. Within the 6 months? Maybe. If you go back through all the cases under the LOBR where show causes were initially in the appellate court, now go into case search and see that the circuit court hearings came a day, a month, several months, almost a year later. That is built-in delay. And although it is true that theoretically an agency could still go forward the process, no agency would do that or should do that. Certainly my agency would not be doing that if they're following my advice. It does not make sense. The investigation must stop until the show cause resolved. Number two, as Senator Valentine pointed out, this bill directs the agency to show cause. Many of the issues you have heard do not apply to the agency. We have no control over the ACC. We give the ACC their investigation and they sit on it for 6 months. We can't control that. We can't control when the PAB selects their members for the ACC, their member for the trial board, when the county selects a member for the trial board. And yet this bill requires the agency, me, to go to court and justify things that I have no control over. And finally, number three, if there is an issue in the discipline process, following a hearing board, if the officer is found to have committed some form of misconduct, the officer has a right to appeal that decision to the circuit court, where this can be resolved and litigated in the circuit court, which is the same as pretty much every other government employee. So those bits of information, I'm happy to answer any questions you may have about this bill.
Questions for the witness? Seeing none, thank you very much. That concludes the testimony for House Bill 15. We're going to go to House Bill 188 now. Delegate Cardin. Mike Davey, Michael Shire, Clyde Boatwright, Ari Plout.
Good afternoon again. For the record, John Cardin, on behalf of House Bill 188. Mr. Chair, this is a legislation that we introduced. That I introduced last year. I'm reintroducing it. This would let me just pull up my notes. This bill requires that a law enforcement agency to file any filing any administrative charges arising out of an investigation of alleged police officer misconduct, that it needs to be done within a year and a day from the date of the incident that led to the investigation. I believe that it's actually a year and a day from the time that the incident was known, actually not the actual date that it was done, but the time that it was known is the appropriate language. In addition, everybody in the room has received a copy of our amendments that conforms this with the Senate bill that was the proper drafting of it, which makes sure to include language that brought the chiefs and sheriffs, the FOP, and the counties all within assent of how it should go. You have those amendments on your computers. And I will be happily to answer any questions, but maybe I'll let the experts speak.
Good afternoon, Mr. Chairman, members of the committee. My name is Ari Plout. I'm here on behalf of the Maryland State Fraternal Order Police in support of House Bill 188. Thank you, Delegate Cardin, for sponsoring this piece of legislation. I'll be brief and then I'll turn it over to the experts. Statutes of limitations, having a statute of limitation in place forces timely resolution on administrative charges. It's unfair to have a disciplinary action held indefinitely. This bill would apply to cases not involving members of the public. There already is law that exists for cases that involve members of the public. There already is a statute of limitation in place. I'm sorry, this bill applies to cases not involving members of the public. Apologies for the confusion there. So this bill would essentially require law enforcement agency to file charges not required by the ACC within the statute of limitations. And with that, I'll turn it over to the experts, and we will request a favorable report on House Bill 188. Thank you.
Good afternoon, Mr. Chair. Again, my name is Clyde Boatwright, President of Maryland State Fraternal Order Police. So this is a simple fix to a problem that we're seeing with, and I'll give you an example. We all talked about the recruitment and retention of police officers. If another agency has an attractive package that benefits me and my family, and I decide to leave and go to that other agency, I can decide to fill out the application, go through the process, get hired. But during that process, that new agency, receiving agency, has to go and look in my background folder to see if there's any administrative charges pending against me. Because if there are charges against me, I can't accept the job and move to the new agency. What we have seen happen is the minute that a police department finds out that an officer is attempting to leave to go somewhere else, bam, here's an investigation that prevents them from leaving. Now they're stuck at that agency. Even though it's a complaint that really has no merit, the chief can hold that up and send it through the process. And now the agency that was receiving a new recruit who otherwise has no history or no background now has to move on to the next candidate. And so what we want to see is timely investigations, timely charges, and we want to stop this thing of using a police chief holding on to the fact that I didn't wear blue socks 5 years ago, and now that I'm deciding to accept a new job, he's going to open an investigation. We want to prevent that. Have the agency, if they have information, bring it forward. Don't sit on it and don't hold on to it. So we urge a favorable report for this piece of legislation.
Good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police. This bill is simply cleanup language of the Maryland Police Accountability Act. Currently, Section 3-113C already has a statute of limitations for those cases that go to the ACC, that involve the public. It's very clear in Section C, and it states the process of review by the investigating unit through disposition of the administrative charging committee shall be completed within 1 year and 1 day after the filing of the complaint by the citizen. But it's silent about those complaints that are internal and don't involve the public. You know, not turning on your body worn camera, insubordination, being late for work, missing a court date. There is no statute of limitations currently in the law for that. House Bill 188 completes the section of law that would require a law enforcement agency to file any administrative charges arising out of an investigation of alleged police misconduct that is not required to be reviewed by the administrative charging committee with 1 year and 1 day from the date the incident came to their attention. We have worked hard with the Maryland Chiefs of Police and the Sheriff's Association, and we've actually agreed to an amendment to this bill, which states now that the 1 year and 1 day statute of limitations will have an exception. And that would be an exception if that law enforcement officer is under criminal investigation. We know that cases involving criminal investigations take much longer. So we were willing to agree to grant an exception to the 1 year, 1 day based on that. Discipline should not always be initiated just to punish an officer. Discipline is a tool to correct behavior. Disciplining an officer 2, 3, 4, 5 years after an incident occurred does nothing. You're not correcting anybody's behavior because he didn't go to court 5 years ago. What did he do during those 4 years in between? Therefore, we're requesting a favorable report on House Bill 188.
Good afternoon again, Mike Shire with the Fraternal Order of Police. The purpose of statute of limitations has been said is to ensure swift justice. That was one of the purposes of the MPAA, to make sure that these charges are being adjudicated in a timely manner. It's also so that the defendant themselves, the person who's being accused, can get the evidence and the witnesses together and preserve those things so that they can provide themselves a proper defense. If we just let these things go,
then the defendant does not have the ability to properly defend themselves from the accusations. The MPA has a time limit for charges that involve a member of the public. These are for those that don't. So it's weird that we want the administrations, the police departments to adjudicate those charges. Why do we want to have these other administrative charges that don't have anything to do with the public hanging over a police officer's head? These time limit things can be abused. A police chief or sheriff could hold that minor violation, in addition to what President Boatwright said, can hold that minor violation over an officer's head indefinitely and use it to negatively influence their actions. If you don't do what I say, I'm going to bring this charge back. The lack of time limits can easily cause more problems. Do you think an employee is going to exercise their First Amendment rights or their whistleblower rights when a chief is holding a 10-year-old disciplinary action over their head? This inherently stifles constitutional rights. So it's interesting to me that the opposition to this is saying that this is not something that we should do when we're the only employee group that they would do that for. If these rights were granted to all employees, would they not be in favor of them? These organizations defend people for their rights that are for employment rights, for constitutional rights. Why are they attacking us? We are the only organization, the only profession that is subject to the level of oversight that this body has put upon us. So in the interest of swift justice and proper process, the FOP supports this legislation, asks for a favorable report.
Are there questions for this panel? Delegate Sample Hughes.
Thank you, Mr. Chair. Thank you, Delegate Cardin. Being we're in this section of the code, would you think it's appropriate to put an amendment in to ensure that the officer is given updates as to when in the process that it's going on maybe every 60 days as to what's the status of the case?
We would certainly support an amendment in this section, put into the MPAA, even in this section or attached to this bill, that would require agencies at a minimum of every 60 days from the onset of an investigation as to what that status is, just like a civilian complaint gets.
Okay, thank you.
Oh, thank you. There's an amendment suggested, I think it was by Montgomery County, I may be wrong, to change the trigger from, I'm sorry, but to the time when the law enforcement agency learned of the event versus when the incident occurred.
I don't
Okay.
think that's an issue for us
Thank
at
you.
all.
Yeah. Thank you.
That just makes sense.
Further questions? Delegate Tomlinson.
Thank you, Mr. Chairman. Have you gotten a chance to read the ACLU's testimony, unfavorable testimony? Do you want to comment on that at all?
Yeah, I'll just very quickly comment. So there were the ACLU brought up 4 separate points. One of them, point number 3, was about tolling, which is we've already agreed that we think that's already included in the amendment that's on the Senate side. Number 4, issue number 4 was that this is about it shouldn't include excessive force. Well, that would be something that would have to do with the public, so that would be excluded from this entire issue in the first place. Correct me if I'm wrong, Mr. Davies.
That's correct.
And number 3, trigger is not correct. That's the amendment that that Delegate Embry just asked about. So we're okay with that. So now we're down to issue number 1, which was that there shouldn't be a statute of limitations on administrative matters. And that's just a question of public policy that I think we've made a good point about. And I think that reasonable people can disagree about these things. And I think that there ought to be a reasonable expectation of predictability for our police officers. So that would be my comments, if anybody else wants to comment.
Basically, there's two areas of statute of limitations. One was already taken care of back in 2021, putting in a statute of limitations for the cases that go to the ACC. I think it's just common sense that if you're going to have it for there, you should have one for those internal complaints also. It just meshes and completes the law.
Oftentimes, these are the more minor charges. We have statute of limitations in our criminal charges for many of them, misdemeanors, year and a day. But for the major charges, homicide, we do not. There is no statute of limitations for those, the major charges. So we've already said that The more major charges are generally those involving the member of the public. They have a statute of limitations that this body put in there. Why would the lesser charges that I forgot to shine my boots or I missed court not have a statute of limitations? That doesn't make sense. And again, the MPAA was designed to make sure that these issues are adjudicated quickly. The major complaint of the LEOBR was it was taking too long. Well, the statute of limitations tells the agencies, get going, do it. Don't delay.
Seeing no further questions, that concludes the testimony in favor of the legislation.
Thank you.
We'll hear now from Jerome Spencer, who's favorable with amendments. And then after him, we'll hear from Mr. Roca. Please begin, Mr. Spencer.
Good afternoon again, Mr. Chairman. My name is Jerome Spencer. I'm the General Counsel for the Charles County Sheriff's Office. I'm here on behalf of the Maryland Chiefs and Sheriff Associations. We strongly support House Bill 188 with the amendments that Delegate Cardin talked about. Strongly support it. In addition to what you heard about providing incentive for an agency to go forward with its investigation and get cases resolved, more importantly, the amendments that Senator Cardin talked about address a huge hole in the current PAA. Under the current PAA, an officer who is accused of a crime and acquitted of that crime cannot be disciplined by the agency. I will say that again. An officer who is acquitted of a crime cannot be disciplined by the agency. And I say that because criminal investigations and criminal prosecutions take more than a year. They just do. And so when the case goes to trial 18 months later, 2 years later, and the verdict is not guilty, the chief and sheriff is stuck with that employee. The amendment Senator Cardin talked about is fixing a massive hole in the PAA, which frankly has chiefs and sheriffs very worried. If you do nothing else this session, please pass this bill with that amendment, because we do not want to have an officer who is acquitted of criminal charges but did engage in misconduct and we're stuck with him. And let me just address one thing that came up in some of the conversations before. The year and a day statute of limitations is not from when the incident occurred. It's from when the agency learned about it. So a citizen who was affected by some issue that occurred and happened sometime in the past, it's not a statute of limitations on the incidents when the agency learns about it. And that puts the onus on the agency to do our due diligence, get the investigation done, and get a charge document filed, which is fair and appropriate. And I'll stand ready to answer any questions you may have.
All right, seeing none, thank you very much. Mr. Roca, please.
Thank you, Mr. Chairman, members of the committee. I'm a little bit hampered today because my written testimony and prepared testimony was for the bill as written, which I now understand is quite different. So I understand that the sponsor has proposed amendments to conform it to the bill as it was introduced in the Senate. And so I'm going to focus my comments on what I said in the Senate. As to tolling, as to the trigger, my understanding is that the sponsor panel said they're okay with the trigger being when the misconduct comes to the attention of the agency. That's critically important. And if that change is being made, then that is good. Regarding tolling, the tolling provision, it is certainly critically important that there be tolling for criminal investigations. That's not the only thing that should be told. The provision as it existed in the LEOBR also had tolling for excessive force cases. It is not correct to say that all excessive force cases would fall under the category of cases that go to the ACC, because not all excessive force cases necessarily will begin with a civilian complaint. Some may, but there also have been, are, and can be excessive force cases that begin only through internal investigations. There was one other point I wanted to make, and I don't remember what it was.
Okay. Any questions for Mr. Roca? Let me go to the question, I guess, that appeared to be the public policy question at the end of the story. What's your position about just having a, I think I'm.
Whether there should be a statute of
Whether there should
limitations
be
at
a
all?
statute of limitations at all.
I think here's the dilemma, the problem. The LEOBR, as originally written in 1974, did not have a statute of limitations. Statute of limitations wasn't put in place until 1988. I don't think it's constitutionally required. I think there certainly can be cases. I do not think it is right for a police agency to have an allegation and to sit on it and not even open an investigation and wait until some later point to start an investigation because they want to hold it over an officer. That's appalling and wrong. The idea that frequently happens, I think, runs contrary to the earlier testimony that you heard from the proponents of this bill, that police agencies want to weed out misconduct, et cetera, and aggressively pursue it all the time, et cetera, et cetera, et cetera. But the bigger problem with the statute of limitations, it's a problem even with the Senate bill, is that there are investigations that sometimes take a long time to complete. But B, the reason that investigations typically take the longest time to complete is because there's a parallel criminal investigation, and because in Maryland there is this practice of not doing, because of the potential Fifth Amendment problems, which arise only with the questioning of the officer, there is this habit in Maryland of not pursuing administrative discipline concurrent with criminal cases. There are certainly cases and times when doing that abstention makes sense and is appropriate, but when it doesn't involve any compelled testimony by the subject officer, then that makes far less sense. And in those cases, there is no constitutional bar, no Fifth Amendment problem that Mr. Davey alluded to from the Garrity case with pursuing simultaneous charges. The reason for delay also is more typically not, I think as Mr. Davey has alluded to today, not the investigation, but the adjudication. Mr. Davey talked about there being 200 and some odd cases now pending before in Baltimore City before their ACC. I can't confirm, I have no information about the accuracy of that figure, but those investigations are already done and are now awaiting adjudication. Having a long lag between the completion of the investigation and adjudication is a huge problem, but that's not solved by the statute of limitations. Finally, the other critical problem with the statute of limitations is when there is civil litigation, it is often the case that civil litigation discovers significant misconduct by police, but if the statute of limitations period has run by the time the civil litigation is concluded, which is virtually all the time, any of that misconduct can no longer be subject to discipline. Does that answer your question?
Yes, it does in part. Well, I guess it leads to another question of, I've asked the question of why a year and a day, and that what's the magic behind 1 year and 1 day, and whether a longer period for a statute of limitation wouldn't address some of the issues that you just raised, while at the same time giving certainty and finality on the administrative side of it. So I kind of wonder whether something more like 3 years would address the adjudication of cases and handling of claims, while at the same time, again, providing some finality to what comes next. But isn't that so?
I don't know the origin of the year and a day provision as opposed to 3 years. You're certainly correct that in Maryland, 3 years is the general statute of limitations for tort and constitutional claims. But I mean, again, I agree with what I've heard from some members of this committee and even from the proponents. There is universal agreement, I think, that a properly run police agency and the public and victims of police misconduct have an interest in expeditious investigations. The problem with a hard and fast statute of limitations in this context is when it operates to, there's one other thing that I should have said that I didn't say, which is that the other way that the statute of limitations operates is behind the scenes. In the LEOBR regime, there were huge numbers of cases that were administratively closed. I mean, it varied from agency to agency, but in many agencies, there were huge numbers of cases that were administratively closed because they were coming up on the statute of limitations and were not going to be able to proceed with the case. And in that they are then closed without any adjudication of whether the officer actually has or hasn't committed misconduct. And the general point I want to make is that we should be making substantive decisions on whether officers have or haven't committed misconduct. If they really haven't committed misconduct, then that should be determined and said, because that is important for public knowledge and trust. And if they have committed misconduct, then that should be determined and said, because those officers need to be disciplined. And when this arbitrary one-year deadline sets a impediment to that, that is a problem.
Further questions? Delegate Embry, then Delegate Munoz.
Thank you. And forgive me if I just don't understand. You've been talking about adjudication, but this just talks about charging. What am I confusing? This just requires the agency to charge them within that time frame, not adjudicate.
Correct.
But so they
But
could have.
What in my most recent comment, you mean what I was referring to is in the old LEOBR regime, what would in some jurisdictions, what would frequently happen is that when an investigation was running up on the one-year deadline, but they weren't complete, which generally is a product of there being too many complaints, not sufficient internal affairs staff to adequately investigate all of them in the requisite period of time, they simply administratively close the investigation and say, that's it. We're not gonna reach a determination. We're simply gonna administratively close it. I believe that in the new MPAA regime since 2021, administratively closing is, at least as I understand it from the statute, no longer an option. Whether agencies are still doing that behind the books, I confess that I do not know. But in terms of the statutory outcomes, those are now specified for the ACC, and administratively closed is not one of them. And there was one other point I wanted to make with respect to that. I forgot what it was. But the general point that I was making, I think, remains, which is that the statute of limitations can operate as an impediment to a substantive determination of whether the officer has or has not committed misconduct, and that is the important thing.
Thank you, Mr. Chair. So I just want to clarify, because I'm getting a little bit confused. What we're talking about right now, what this bill addresses is only complaints not involving members of the public. Is that correct?
Correct, because there is a provision which we opposed in 2021, but this body in its wisdom didn't heed our views. But there is now in the existing law in the MPAA from 2021, a strict one-year statute of limitations for cases, but only for cases that begin with a civilian complaint. And I agree with the notion there is something goofy about treating cases that begin with a civilian complaint worse in the sense that they are subject to a statute of limitations when cases that do not begin with a civilian complaint are not.
And so
the law should be harmonious, but it should be harmonious in a better way than it is now.
Okay, so just to clarify, so earlier you were talking about like a brutality complaint or excessive force, but that wouldn't fall under the bill we're talking about today, because that would involve a member of the public. Is that correct?
Well, so to be clear, the existing law, the trigger for the existing law is not the nature of the complaint, the subject of the complaint, the type of complaint, but how it's initiated. So under the existing law, under, what is it, 103C, the statute of limitations is triggered because the complaint begins, I don't have the statutory language in front of me, but it begins with a complaint by a civilian. So it doesn't matter what it's about. If
So
I,
that's
as
not this bill, though. This bill is only,
this bill is adding a new statute of limitations that are not covered by that category. So, right.
okay, so this is not involving, this is administrative, not involving members of the public.
It's not that it doesn't involve members of the public, it's that it doesn't begin with a civilian complaint. It begins with the investigation is initiated by the agency itself.
And do you have, is it House Bill 188 that you have in front of you?
Yes.
Okay, all right, thank you.
I take it you think I'm somehow confused about the bill? I don't think I am, but
Seeing no further questions. Thank you very much. That concludes the testimony on House Bill 188. Going to go now to House Bill 1065 with a questionable sponsor. It's me. Ask Nicholas Blendy, he's there. And Brad O'Brien should be there virtually. We'll bring him up. And my remarks are going to be relatively quick, so I'm going to stay right here. House Bill 1065 and Mr. O'Brien is there, so we'll get to him in just a moment. House Bill 1065 would establish a Maryland Entertainment District Security Grant Program. The program and the purpose of the program is to assist community organizations, not-profit entities, and local governments to fund security operations during times of high pedestrian traffic in entertainment districts from which a higher than average number of calls from police assistance are reported to have been made. In my district, that would probably in all likelihood include neighborhoods like Federal Hill and Canton and maybe a couple other places as well. And there are places you could probably think of across the state in your districts where this grant program might be something that people would be able to use. Mr. O'Brien, who is on who's on virtually, is going to talk a little bit about his ideas of how this might work in the Federal Hill neighborhood. And so I'm going to hear from him because he especially got on just now because he's got to go somewhere else at 4:15. And we'll hear from Mr. O'Brien first, then Mr. Blendy.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Brad O'Brien. I serve as the Public Safety Chair for the Federal Hill Neighborhood Association, and I'm here to speak on behalf of House Bill 1065. For the past 11 years, my family has called South Baltimore our home. For the past 5 years, I've served in the role for Federal Hill Neighborhood Association, and additionally, I serve as the Baltimore Police Department's Community Relations Council President for the Southern District. It was actually a violent crime in the neighborhood that led me to get engaged. A mother was walking home from the grocery store. She was pistol whipped while carrying her newborn baby on her body. I could envision my wife and my children as victims of that type of crime, so I wanted to serve the community where we live, work, and play. The Entertainment District and Federal Hill Neighborhood Association is uniquely positioned between 4 residential communities. We have some of the highest density of liquor licenses in the state, which means many of our entertainment areas, businesses are open late night, providing drinks and entertainment from people across the city and the state. Our community sits a few blocks from M&T Stadium, Camden Yards, the Inner Harbor, and that makes us one of the state's most visited areas. However, the needs that we have for public safety go beyond what we have access to right now. Public data of 911 calls for service clearly outlines our entertainment district as an area of need. Additionally, we can track those calls and identify specific days and windows of time where we have our greatest needs. In our attempts as a group of volunteers to increase public safety, we've applied for and won grants from the Department of Housing, Community Development, Community Safety Works upwards of $500,000 to invest in license plate reader cameras, also enhance pedestrian cyclist safety, traffic calming, installing cafe lights, and installing privately owned cameras on privately owned buildings. We need this bill. We need your help. So we ask for these reasons and other that you support House Bill 1065.
All right, now for Deputy Sheriff Blendy.
Thank you, Mr. Chair, giving me promotional titles. For the record, Nicholas Blendy, Assistant Sheriff for Baltimore City. And I'm here on behalf of the Sheriff, Sam Cogan, who is a constituent of Delegate Clippinger's in the 46th and was in a previous point in his career, president of the South Baltimore Neighborhood Association. So sent me here on behalf of him from that perspective to echo what Mr. O'Brien said, but also to talk about what this means from the law enforcement perspective. As the chairman indicated, this would create a grant funding opportunity set to the governor to decide which areas of the state are eligible based on the factors of liquor and live entertainment density. Many of those places are in the 46th district and other areas around the city of Baltimore and also around the state. For example, if you want to think about the Ravens Stadium, the Oriole Park at Camden Yards, and whatever its new corporate name is going to be, those are areas where people come from not just all around the city or the state, but all around the region to attend. And I think this idea is born out of the former police commissioner in Baltimore City, Michael Harrison, who was the police commissioner in New Orleans. For example, in New Orleans, the Bourbon Street, the French Quarter District, is actually policed by the Louisiana State Troopers and not New Orleans PD. This would create a structure unique to Maryland in a good way, I think, that would allow security funding for these entertainment districts throughout the state to be funded through alternative resources and not just like the sheriff's office budget or BPD budget, but perhaps some folks working on secondary employment, drawing money from these grant programs. We're already doing lots of work throughout the city of Baltimore in the sheriff's office, and this would be an excellent tool to add and an excellent funding source to help fund safety in these areas. Would be a favorable report. Thank you.
Questions for the panel? All right, that was easy. Thanking Mr. O'Brien for being with us. That concludes the testimony for House Bill 1065. We'll go on now to Delegate Acevedo. Delegate Acevedo, please, for House Bill 27. And he will be joined by Robert Landau, Vanita Taylor, Nashana Kess. Delegate Acevedo, are you ready to begin?
Yes, but I wanted to make sure, I think she stepped out for a bit. She might
I was
join.
going to say,
Go ahead.
they were just here, so we'll keep an eye out for them and we'll go from there.
Sure.
Yeah.
All right. Well, good afternoon, everyone. Members of the committee. For the record, Delegate Gabriel Acevedo here to present my bill, House Bill 27, that would essentially end no-knock warrants, which is a practice, quite frankly, that is not rooted in data, that places law enforcement and civilians in a standoff. And quite frankly, we should be ending the practice because there is enough, whether it's technology or tactics or strategies that are available for us to accomplish pretty much the similar goal without, again, putting law enforcement and civilians in a standoff. This also represents really unfinished work of police accountability. I think it also falls under just the work that we should be doing to ensure that we're protecting the public as well as law enforcement in the commission of their duties. And so I would point out that other states, from Democratic as well as Republican states, have passed or ended no-knock warrants for various reasons. States have ended it because we recognize that there's a disproportionate application in terms of no-knock warrants in communities of color, poor communities who oftentimes are impacted when these no-knock warrants are executed. And then you have in more Republican or conservative states who have ended no-knock warrants because they recognize, again, that we are asking law enforcement officers to go into a situation where they have little to no information, armed, not knowing if the person on the other side is armed, and then expecting them to take action or to execute that warrant. In most cases, while a warrant may be executed, we find civilians also being executed as well. And so what we want to prevent is those unnecessary deaths. I think there are a number of prominent cases across the country where we have seen no-knock warrants gone bad, whether it's Breonna Taylor or Rakia Boyd or so many others, where a no-knock warrant and the execution of a no-knock warrant went terribly wrong. I would submit that we have had instances similar to that of other states right here in Maryland, where civilians, were extrajudicially executed in the process of carrying out this no-knock warrant. And there is something that we can certainly do about it. This is prescriptive. It ensures that we're not just balancing the rights and the safety of civilians, but also law enforcement. It is one of the demands that we've heard from many communities of color when it comes to policing, and equally as important is that it is the right thing to do. So with that, I would ask for a favorable report and hope that we can take some serious action to ensure we're protecting the public as well as law enforcement.
I'll call your panel again. Well, come on up, Robert Landau, Vanita Taylor, and Nishana Kess. And whoever would like to go next, please go ahead.
Good afternoon, Chairman, members of the committee. My name is Robert Landau. I live in Gaithersburg, District 17. I'm testifying for the Silver Spring Justice Coalition, and we urge your support of this bill. We've all heard and seen horror stories about no-knock warrants gone bad. Breonna Taylor is just one of many Black community lost to no-knock warrants gone awry. In 2019, a no-knock warrant executed by Montgomery County Police injured a firefighter of color, his wife and child, none of whom were subject to the warrant. And the error led to a lawsuit against the county for $2.5 million. Given that no-knock warrants are among the most dangerous and hazardous police activities, the Washington Post has documented that judges and magistrates grant police these warrants far too frequently and with far too little oversight. The Center for Criminal Justice stated that there may be significant racial disparities in the execution of no-knock warrants. For example, one study indicated that 42% of households rated under SWAT search warrants had Black occupants. The argument that no-knock warrants are needed for surprise to subdue dangerous people is a self-fulfilling prophecy. Of course, people who have guns, sometimes legally, are likely to defend themselves when they think that criminals are breaking into their homes. Why do we jeopardize the lives of officers and innocent civilians by permitting no-knock warrants? No-knock warrants are not worth the danger they pose to innocent civilians or law enforcement officers. Think about it. Officers don't need no-knock warrants to seize thousands of fentanyl pills or kilos of illegal drugs. Those quantities can't be destroyed when police serve a regular warrant, nor are no-knock warrants needed to seize guns or other contraband. No-knock warrants are obsolete and have been so abused, particularly to harm people of color, that attempting to reform the process is futile. Please provide a favorable report. Thank you.
Thank you, Mr. Chair, members of the committee. My name is Nishana Kess, the Executive Director of the Maryland NAACP. And we stand in support of House Bill 27, which aims to repeal the authority for the issuance and execution of no-knock search warrants. The proposed bill emphasizes the necessity for officers to announce their purpose and authority before entering a building, apartment, premises, or place. It also restricts the execution of warrants to specific hours and requires officers to give reasonable notice before entering certain areas to alert the occupants. The racial equity impact note associated with this bill underscores critical issues such as officer and civilian safety, mistaken identity, inaccurate information, and insufficient judicial scrutiny surrounding no-knock warrants. Moreover, it highlights the disproportionate impacts of the criminal justice system on people of color, including racial disparities in arrest and sentencing. For instance, I want to highlight the Minneapolis Civil Rights Department that conducted a review. 74% of no-knock warrants were served on Black individuals, despite Black residents constituting only 18% of the city's population, according to the 2020 census. This disproportionate targeting of Black communities, as evidenced by the tragic recent events like the fatal shooting of Amir Locke, who was fatally injured just 9 seconds after the entry. This underscores the urgent need for reform. House Bill 27 represents a crucial step towards addressing systemic injustices within our criminal justice system and safeguarding the rights and safety of all Maryland residents, particularly communities of color. We urge a favorable report.
Good afternoon. Benita Taylor from the Public Defender's Office. We're in support of this House bill. We believe that no-knock warrants should not be in the state of Maryland. No-knock warrants may be issued in every state except Oregon, prohibited by state law, Florida, prohibited by a 1994 state Supreme Court decision, Virginia, prohibited through legislation passed in 2020, and Tennessee, prohibited through legislation passed in 2021. This bill does not take away the right of a police officer to request a no-knock warrant. They may still request one if there's exigent circumstances. What this bill does is that it clearly outlines that if it's not exigent circumstances, that there should not be the issuance of a no-knock warrant. It requires the judges who issue these orders to think twice. Is there exigent circumstances or not? We live in times today where people do not even visit you unless they call and say, I'm coming to see you. They don't just show up at your door and say, hey, I was thinking about you and decided to drive by. That does not happen. People call to announce that they're on the way to the house, as the police should call to announce when they get there who they are, so that you're not surprised. There are many legitimate firearm owners who, if someone bursts into their house with a no-knock warrant and you have a gun, you are going to come down those stairs with your gun pulled out. Who are you entering my house? Let's be real and let's be honest about it. That's human nature. And this bill protects not just the citizens, but it also protects the police from entering a home where someone has a gun, either licensed or unlicensed, but it protects them from being hurt by mistake. It protects the citizen from being hurt by mistake. There are issues where we need to be clear that is it an exigent circumstance or not?
Thank you to the panel. Can anyone on the panel just explain to me the process that a police officer have to explain to a judge to obtain a no-knock warrant?
Sure. So, well, since 2021, we've made some changes to the no-knock warrant process. I think we pretty much made it, I call it hours of operation, where when you can essentially execute a no-knock warrant from 9 to, I can't remember the exact time, but you would submit a request, and that judge, I guess, would look at various circumstances that would warrant that. As was pointed out, in most cases, judges do issue those warrants. And at that time, that's when, I guess, law enforcement can, they'd receive approval as to whether or not they'd have no-knock, they would have that warrant or not.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. I just want to say this was my first bill. If you hear someone breaking into your home and you're upstairs with your legally registered firearm and they're downstairs, you have a duty here in the state of Maryland to go out the closest window you can as if it was a fire. So thank you very much. They call that the castle doctrine, what you're talking about.
Further questions for this panel?
That's great.
Delegate Tomlinson.
Thank you, Mr. Chair. I was wondering, Delegate, have you seen the written testimony from your county's police department?
No.
Okay. Yeah, it's pretty long, says, yes, says the department strongly opposes the bill. They talk about if the element of surprise is lost, the police will have to engage in more surround and call out warrant services. They go on to talk about that results in a barricade situation, more high probability innocent family members or residents could be barricaded inside, and leads to poor decision making.
Yeah, so I haven't looked at that testimony, but just hearing a little bit about it, I disagree with that. One is I think there are a lot of law enforcement agencies, I'll just point out in Florida, they've ended no-knock warrants. And they pretty much, the rationale for doing that was because it places law enforcement in a dangerous situation, a standoff with civilians. That was the rationale. That does not change here in Maryland. We don't do, well, at least I'd like to think we don't do policing that much different than Florida, but that danger, that dangerous situation is still very much real for law enforcement officers over here. So that coupled with the fact that we have technology, I think it was a blimp that was in Baltimore City that could scan homes. I think we have a bunch of other technology that, quite frankly, I think personally violates some people's civil liberties that folks could be employing to accomplish some of the very things that we're talking about here, as opposed to having no-knock warrants, which, as I said in my testimony, there's no data that really supports the effectiveness of this practice. And that's the most important thing here. We're keeping a policy in place that is not backed up by data, empirical data, and certainly it's not something that is uniformly supported by law enforcement across this country, because if that were the case, then law enforcement in Florida would not have supported ending the practice, because, as I said earlier, it puts law enforcement and civilians in a standoff. No one is going to react any differently to someone coming into their home unannounced than anybody else. If you are armed or if you don't have a weapon, you're going to find one. And it's not going to end up in it's just not going to end up in a good situation. We could move beyond that. We could look at technology and other strategies to accomplish that goal. And I think, quite frankly, just some of the old arguments that has been used about, like, well, flushing drugs down a toilet bowl or whatever it is. I mean, again, we have technology that we could be incorporating into policing. And I'll also say, lastly, about my county police department, I certainly disagree with, just some of the views, particularly the policies that our police department employs in doing their job. And I think this is one of those areas where we also disagree, So, I mean, again, it's about safety of law enforcement, safety of the public, and we don't have data that supports the effectiveness of no-knock warrants. It just doesn't exist.
All right, seeing no further questions from the panel, thank you very much.
Thank you very much.
We will hear now from those in opposition, Scott Schellenberger and Jazz Ball.
Good afternoon, Mr. Chair, members of the commission. My name is Chaz Ball. I'm speaking on behalf of the state FOP. Ultimately, what our opposition to this bill is about is the use of a no-knock unit. It's one of many possible tools in an officer's bag. The use of a no-knock warrant is something that can be utilized, but often is not utilized. Frankly, 3 years ago in 2021, it was made into the law specific requirements for the use of a no-knock warrant. Specifically, not only does the officer have to agree, a supervisor has to agree as well. Not only does those elements have to be there, but the state's attorney from that jurisdiction has to agree as well. Not only does those elements have to be there, but as with any warrant, it has to go to a judge for approval as well. There are scenarios, and the idea of a standoff is specifically one of the issues where you would want to have that ability, that potential tool to have a no-knock unit. Because if you know that the suspect is downstairs and the weapons are upstairs and you've gone through that process of investigating it, and you know that if you give that suspect those 20 seconds of knocking on the door and saying police, that they're going to go upstairs and grab their weapons and potentially take hostages, potentially engage in a shootout with the officers, then you're creating that danger. But if that tool of a potential no-knock warrant is there, then an officer would be able to engage in it more safely. And that's the safety not only of the officers, but the safety of the civilians that are involved, the safety of the potential hostages that are involved, and ultimately the safety of everybody that would be potentially involved in that scenario. We're not saying no-knock warrants should be used every time. They certainly should not be. But when that deliberation is there, when that process is there, we get to what we have, which is a tool in the bag if necessary. And if you take that away, you endanger everyone involved. Thank you.
Mr. Chairman, Scott Schellenberger, State's Attorney for Baltimore County. I'm here opposed to HB 27. I sign very few no-knock warrants, usually averages somewhere between 15 and 20 a year. As was indicated, a couple of years ago, you all put some very strict restrictions on there. It is one of the few things, there are two things that I cannot ask my assistant state's attorneys to do. One is to sign a wiretap, and two is to sign a no-knock warrant. And what the procedure requires is that the officer has to write the probable cause statement. A supervisor in the police department has to approve the fact that it's no-knock. It then comes to my office, where a senior trial assistant will review the no-knock and then refer it to me, telling me that it complies with the statute. I've obviously been involved in the statute from the beginning. I then read the no-knock warrant and decide whether or not I'm going to sign it. And as always, a third party, an independent judge, has to decide whether we've met all the requirements. So one of the other parts of the bill that I think is difficult is it limits when you can do search warrants to certain periods of time. Well, the question was asked, why do we have to do this, have these no-knock warrants? And the answer is very simple. It is for officer safety. We only pick these out in times when we're going in and we know the individual has guns, and more than one usually, and more than one person usually. It is usually saved for the absolute most scary of cases. And again, there are lots of checks and balances in there. And the reason, I mean, I was here when you all passed the bill. The reason that I have to sign it is because the decision was made to have somebody who is politically accountable to sign no-knock warrants. And therefore, if my county doesn't like what I've been signing, then they could do something about it. And that was the intent when we were here a couple of years ago.
Questions, Delegate Kaufman, then Cardin.
Yeah, just a very brief question, Mr. Chair. I know it's a long day, but Mr. Bull is your name? Is that
Ball.
correct? Ball? Okay. Nice to meet you. I have a question because you're talking about taking the tool away, but the way I read Delegate Acevera's legislation just simply says that that tool is still available with some restrictions, but also that the warrant must be executed between 7 a.m. and 8 p.m., which is 13 hours within a day. So I guess I'm a little confused. I admire your passion, but I guess I'm a little bit confused because under the gentleman's legislation, the tool is still available and you have 13 hours a day in which you can execute it, just not when people are sleeping. So
Well,
could you elaborate a little bit more on your concerns? Because
Well,
the tool would still be available.
If I could, I mean, maybe I'm reading this wrong, but on page 4, halfway down, it says, the search warrant may not authorize a law enforcement officer executing the warrant to enter a building, an apartment, a premises, or a place to be searched without first announcing the law enforcement officer's purpose and authority. I mean, I don't know if I'm reading this wrong, but that sure sounds to me like knock and announce, which is what a regular search warrant requires, knock and announce.
When in listening to the testimony in support, I was certainly surprised. The entire portion of the current law that talks about no-knock warrants is being excised. That's what the bill does. It takes away the entire process by which an officer would apply for and get a no-knock warrant. That's what this bill does. It takes away that tool.
So yeah, if you look at page 3, the brackets take out the procedures you all put in place 2 years ago, or maybe 3 now, that takes out the procedures you put in place to require what was required of a no-knock warrant. So it takes that out and then reemphasizes on page 4, this paragraph I read to you that we can't do them. So unless I'm reading that wrong, I think it's trying to outlaw our ability to do no-knock warrants. And in addition to that, on page 4, number 5, down near the bottom, a regular search warrant can only be executed between 8 and 7. And just so you know, if the police go to the scene of a murder and they enter a house and they find that it's secure, they step out if no one's there, and then they get a search warrant so they can investigate that premises. They get a search warrant for those things. So now all of a sudden, we're going to be standing outside somebody's house. There's a dead body inside, and we can't go in there until the next day. It just makes no sense, and it interferes with the police ability to do their jobs.
Thank you once again, Mr. Chair. And talking about the importance of a no-knock warrant, can you just draw down a little bit further on the type of cases that warrant a no-knock warrant?
That warrant.
Yes, warrant a no-knock warrant.
Warrant. My typical case would be a crime of violence in which a weapon was displayed or used, developing a suspect, being unable to get to that suspect in a public place that would be safe, believing that there is evidence of the proceeds of the crime in the house, and the fact that the defendant is known to have the weapon. Typically, they will list in the no-knock warrant the number of convictions the individual have. Very often they will have crimes of violence and handgun offenses in their background. So it is very tightly put together. Like I said, this is one of the two things that only I can do, and my assistants cannot. So we believe there are enough checks and balances there, particularly because I have to we then go to the judge, and the judge has to be convinced that we've met the requirements of the no-knock. So there's a lot of checks and balances.
So in talking about the dangers of a no-knock warrant, can you talk a little bit about collateral damage? So the idea that you want to have the element of surprise so that you don't have to worry about a no-shoot situation where there's other people in the house that may get injured. So you want to catch people where they're at an ease posture instead of at a ready posture.
Yes, you want to catch them before they have the ability to get their weapon. And actually, I hadn't mentioned this, but there is a requirement, and I remember us talking about this a couple years ago. There is a requirement that the police list in the warrant the likely people in the house, including, Chairman Clippinger, all pets. If you recall that conversation, that we have to list any pets that are there so that the officers are aware as to whether they're going to potentially hurt an animal like a dog.
And this bill and taking out that whole section with reference to no-knock warrants takes out the section about the officers having to say the number of occupants of the house, whether there's any developmental disabilities of the occupants of the house, the investigative steps that the officers have taken as part of their investigation, which would include, we know this person stays in this room and the weapons are in this other room. So if we give them that 20 seconds, they're going to be able to run upstairs and grab the weapon. Or if we give them that 20 seconds, we know that this individual has child pornography on this computer. If we give them that 20 seconds, they're going to be able to run over to the computer and hit something to delete it. So it's very specific to cases that a state's attorney has to review it and make a determination that it's necessary. And this bill, make no question about it, this bill takes away that tool, that potential tool.
Thank you, Mr. Chair. Thank you all very much for coming. A lot of, almost all the questions that I was going to ask her have already been answered, so that's great. A couple of years ago, when we had this legislation and we were considering it, I was working very closely with you, Mr. Schellenberger. You will recall, I believe it was Vice Chair Atterbury who was actually spearheading the legislation at the time. And the no-knock warrant was of particular interest to me. And we wanted to make sure we did it right. We got it right. You've listed all the different requirements that you are you're required to do. First of all, it has to come to the state's attorney. It has to be, they have to list out all the people they believe are going to be there. You have to make sure they understand what types of hurdles there could be, pets, other types of inhibitions that might be in the house, in the warrant. One of the things that the delegate who was testifying on behalf of the bill said is that you have to balance citizens' rights versus the safety to law enforcement. In our conversations that we had on this, that we spent hours on, did we come out with a process, as you have described it, that correctly balances the citizen's safety with the law enforcement officer's safety?
I believe we have. I believe that the bill that we worked on, which turned into the current law, balances out those two processes, and it makes sure that we can take care of the safety of both parties. The people in the house who are going to be subject to the search warrant, but also the officers who are entering. And that was what our intent was a couple of years ago. And I think that has been borne out by how it's been used.
One last question is, so I believe that we had a meeting, I think was the OPD was there, I think you were there, I think that the delegates were there, there was a lot of people there, and everybody seemed to come to peace in the valley on this policy. Isn't that correct?
That's my recollection, and I would note that I think the ACLU just testified in the last bill and they walked out after that. And so I don't see them here today. And I haven't seen the public defender's office on this yet either, although they may have filed written.
I hate to ask a question I don't know the answer to, but I'm going to ask this question anyway. Since we passed that legislation, have you encountered a situation where you felt you put your law enforcement officers in harm's way because of signing one of these or approving one of these warrants?
Not that I'm aware of.
Thank you.
Further questions for this panel? All right, seeing none. Thank you. I'm sorry, Delegate Valentine.
Thank you, Mr. Chair. Thank you, panel. And this question is for Mr. Schellenberger. You said in your opening testimony about how infrequent. Can you give me a better idea? You said about 15 to 20 a year that you're authorizing. In the grand scheme of things in Baltimore County, about how many search warrants are authored in a given year? Hundreds?
Oh, I'd
not
go
thousands.
I'd go thousands.
Thousands. Thank you.
Yeah.
Just checking again. All right, now I don't see any further questions. Thank you very much. Concludes the testimony on House Bill 27. We're going to House Bill 185 from the Vice Chair, and that's going to include Elizabeth Hilliard, who is right outside. Yannette Emanuel, come on up. All right, Madam Vice Chair, go right ahead. And there's Ms. Hilliard. All right, go ahead.
Okay, thank you, Mr. Chair and members of the wonderful Judiciary Committee. For the record, I'm Sandy Bartlett, Anne Arundel County, District 32. I am going to present to you House Bill 185. And this will be, I don't know what number we're on, but we've presented this bill before. So I'm going to present it again and hopefully this will be it. So if enacted, it will remove the governor from the decision-making process of medical parole. Why do we want to remove the governor, you may ask? Well, because we've already done it. And now we just want to close the loophole when it comes to medical parole. So in 2021, we repealed generally the governor's involvement in the parole process, but inadvertently, the governor was left in the medical parole process. So what this bill does is take the governor out of the medical parole process. And this is only for inmates who are incarcerated with the possibility of parole. If you don't have parole as a possibility, you're not included in this group. So the bill does not grant any more privileges or puts an inmate in a more advantageous position than anyone else who has the possibility of parole. So with that said, I'm going to ask for your favorable report, and thank you for your consideration.
Good afternoon or evening at this point, Chair Clippinger and members of the committee. For the record, my name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland, here in support of HB 185. As a reminder, again, this bill is just a technical fix. In 2021, this body voted to remove the governor from parole for people serving life sentences, and it was clearly the legislator's intent to establish the Maryland Parole Commission to be the final decision maker for all parole decisions for Marylanders sentenced to life imprisonment. However, the section of the code pertaining to medical parole was mistakenly omitted in the bill draft, resulting in a situation where only medical parole decisions require gubernatorial action. As a result of this error, medical parole decisions made by the Maryland Parole Commission remain subject to a waiting period of 6 months, which is dangerous and unfair to Marylanders who need medical parole. HB 185 just simply corrects that omission, and the need for the Parole Commission to be able to act expeditiously is arguably the most critical in those cases where a parole candidate is seriously ill or dying. The 180-day waiting period alone may be the difference between a peaceful death surrounded by family or a lonely death inside prison walls. Indeed, in 2021, 5 people recommended for medical parole died waiting for the governor to act. Medical parole is awarded under extremely strict criteria. Under COMAR, only individuals who are chronically debilitated or incapacitated by a medical or mental health condition, disease, or syndrome, and are physically incapable of presenting a danger or harm to anyone in society may be released on medical parole. HB 185 would ensure that the terminal illness does not bar someone from a fair and expeditious consideration for their request for release. And lastly, I'll just name that this bill passed out of the Senate Judicial Proceedings Committee unanimously, and this morning passed third reader, and we urge a favorable report. Thank you.
I forgot to mention that. Thank you.
Good afternoon, Chair, members of the committee, and thank you, Madam Vice Chair, for bringing this important bill. As Ms. Emanuel indicated, this is a clerical fix. In fact, you will hear me later urging a favorable report on another bill that goes further. And I speak very specifically from the experience of having to be the person who tells a loved one that their family member has died while they're incarcerated. I have spent time in the infirmary in Jessup, and I can tell you it is not somewhere you would ever want to have your loved ones receive medical care, and it is most certainly not somewhere where someone should have to die. This is a very simple fix for a devastating problem, and for that reason, we're urging a favorable report on this bill. Thank you.
Just very briefly, yes or no, since this involves Madam Vice Chair, the governor, has Governor Moore's administration, Mr. Lutke, or anybody else weighed in? Because I searched high and low in the committee testimony that was submitted, and I can't see it. So have you talked to them? Are they amenable to this, or have they not weighed in?
They haven't weighed in, so I'm going to take that as not a disapproval.
News.
No news is good news.
I'll just add, I have had conversations with their office, and they are in support of removing themselves from this process.
Okay, thank you, Yanette. I appreciate that.
Much. We'll go now to one person testifying in opposition. That's Mr. Kroll.
Chairman, Madam Vice Chair, ladies and gentlemen of the committee, I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland State's Attorney Association. And I've been prosecuting cases since 1984. I say to the co-chair, the vice chair rather, that we are very close. And I'm very sympathetic, and I will state to this committee, this bill needs to be enacted in some way because the medical system the way it is impractical. Now, saying that, I'm still opposed. I'm trying to get to favorable with amendment, but I'm still opposed at this point in time. Current Maryland law authorizes the governor to disapprove a decision made by the Maryland Parole Commission to grant medical parole to an incarcerated person serving life sentences. Incarcerated people are eligible for medical parole at any point in time in their sentence if the commission finds as a result of medical condition they are no longer physically capable of presenting a danger to society. Public safety, however, is one consideration in the sentence. These are life sentences are reserved for individuals who commit the most heinous crimes. They're offenses like premeditated first-degree murder, premeditated child abuse, resulting in death of a child under 13, rape in the first degree, all deserving punishment and significant incarceration, even if the offender no longer poses a threat to public safety. We are sympathetic, but we are sympathetic also to public safety. Unlike Senate Bill 202 that everybody keeps referring to in 2021, which I was here present when this happened, which removed the governor from the standard parole process for incarcerated persons serving life sentences, HB 185 deals with medical parole, which permits the release of incarcerated persons serving life sentences at any time, regardless of how much their sentence they have served. For those reasons, I say two things to the vice chair. I still will work with you, and I think we could get a better bill. I'm not there yet. However, I will say I continue, like I said, we'll work with you. But at this point in time, we're asking for an unfavorable report to House Bill 185. Thank you very much.
Thank you, Mr. Kroll. All righty. Are there any questions? Why is everybody laughing? Saved by the bell. Okay, seeing no questions. That concludes the testimony for House Bill 185. Thank you. So now we're going to hear from Delegate Maricopa North on House Bill 191. Yes, bring your panel up.
Yes, Cecilia and public defenders. Wonderful. Okay, just, I thought he was coming up.
Wait, let me see. Someone was outside. Let me get.
Okay. Okay, wow.
Do you have a panel?
I do, Madam Chair, and
So Lauren
I can
Carnes?
Well, one is virtual, Carolyn Mass. I don't see Lauren Carnes, but Ms. Benita Taylor is here.
I'm here.
Okay, great,
Okay.
wonderful.
And Benita Taylor might have stepped out. Well,
She's just about to try to
She did.
get
There
the
she
other
is.
person who I guess they just miss each other. So we
No,
are ready to get started. It's all right. It's all right. May I proceed, Madam
Yes,
Chair?
please.
Okay, good afternoon or evening, Madam Chair and the distinguished members of the Judiciary Committee. I'm Delegate Bernice Maricopa North from District 14, presenting testimony on House Bill 191, Correctional Services, Pregnancy and Postpartum Support, which is the Prevention of Forced Infant Separation Act. I was here last year presenting this bill, and you're asked what has changed since last year. Well, this bill is contingent on the opening of the pre-release center. I made that very clear in this version of the bill. And in the interim, we had a series of conversations with DPSCS, and I want to commend them for the serious conversations on how do we improve the bond between mother and child when the mother's incarcerated. There was a consensus that we can do more to build a better bond between mother and child, but we're still working on what that looks like. So that is why we're presenting this option before the committee today. Currently, when an incarcerated mom is separated from the child after giving birth after 48 hours, and currently that's the current status quo, the separation 48 hours once the mother gives birth to the child. There's also no visitation from the secondary caretaker or the father. There's also maybe a couple visits a month between the mother and child in person. There's only a couple more times per month virtually. That's simply not enough, and we are seeking to do more with this bill. So what does this bill do? It changes the current treatment between mother and child. It makes the mother eligible for pre-release status so they can actually spend time with the child after delivery at the pre-release center for up to 1 year. Why up to 1 year? Because that's the most critical time for a baby's life and for a mother's health postpartum. It also provides liberal visitation with secondary caregiver and the father, as well as creating a Healthy Start bonding program that is scientifically based.
And that's something that I understand from reading the letter of information from DPSCS that they are looking into once the pre-release center is built. And who is the impact? You should have received data that I actually received from the department as to the number of women who've been incarcerated and were pregnant within the last 5 years. A number of them were in pre-release status. So this bill is doable. These women do exist and they can fit this particular circumstance once the bill hopefully will be passed. I would note that it's a priority of the Women's Caucus as well as the Delta Sigma Theta Maryland chapter. Why is this bill important? This is really going to the heart of the best interest of child in these cases. It also is going to deal with addressing the negative consequences for babies when they are separated from their parents. It not only leads to behavioral issues, potential criminal issues, we're dealing with issues of foster care, which I'm sure the Public Defender's Office will go into. But as for the mother, having that time with the child is going to increase their possibility of reducing recidivism and reducing chance of depression. So I ask for a favorable report on House Bill 191. Thank you.
Sure. Good evening, members of the committee. My name is Lauren Carnes. I'm a certified peer recovery specialist for the Maryland Office of the Public Defender. I also identify as a person in long-term recovery from a substance use disorder, and through my lived experiences, I assist OPD clients in navigating the judicial system. In 2011, I found myself in a very unstable part of life. I had made a series of reckless decisions that ultimately led to being incarcerated while 5 months pregnant. I was placed in a general population where I was immediately targeted by fellow inmates for receiving special treatment in my housing unit. And to be clear, those accommodations were anything but special. The typical stress of being in jail at that point got so much worse, having to fight over things that are automatically given to us pregnant women. Extra bunks, bagged lunches to meet calorie needs. While that subject matter for those issues are very minuscule, the excessive threats and stress from them were so repetitive and overwhelming that they caused additional health issues to be adding to my ongoing list of pregnancy complications. If House Bill 0191 had already been in place in 2011, I likely would have been housed in a space with other pregnant women and women with their newborns, where wanting to bond with our bodies and babies was our only objective. These acts are fundamental during pregnancy and in those first few days of postpartum, but they're stripped of us when we're incarcerated. I can assure you that I'm not alone in those experiences, especially since there are no words to express a woman's mental state once they are returned to their jail cell with nothing but a sore body and a broken heart. Today, I'm urging this committee to issue a favorable report on House Bill 0191. The impact that this bill would have on women incarcerated and their babies would only be positive. Thank you.
Good afternoon, Vanita Taylor from the Public Defender's Office. I am in charge of the panel attorneys, formerly the chief of the Criminal Defense Division. And I would like to really ask this body to support this bill. This bill passed legislation to create a women's pre-release center because there is none in the state of Maryland. Montgomery County has a pre-release center on Neville Street that has one small unit for women, but it does not accommodate pregnant women or breastfeeding women. I will tell you about something that recently happened to me in Montgomery County. I have a client who was arrested. She had a 3-month-old little girl, and I made a request, everyone thought I was crazy, that she be allowed to continue breastfeeding her daughter, even though she was incarcerated. The judge agreed with me, Judge Kathleen Dumais, who was in this body before, but we couldn't figure out how to get it done because there was nothing that where she could go where we could get it done. Fortunately, the federal government passed a law about lactating parents and mothers that they have to have a lactation room somewhere. The lactation room they did have in Montgomery County at where the women are housed in the detention center. And the warden allowed her to use this room so that she could go and breastfeed. And her family member had to come to the facility and pick up the breast milk. It ended up being a hollow victory because it took almost 4 weeks to get that all set up. But what it did indicate to us is that everyone thought it was okay that we just take this baby who was breastfeeding and put her on Similac. that it was not crucial that the mother be able to pump and give the child breast milk. We did accomplish it in this case, but in other jurisdictions across the state, I'm told that when attorneys make that request, that people laugh at them. I would say pass this bill so that when the pre-release center is finally built for women, that it accommodates the women that need those services.
Thank you. So now we're gonna hear from our virtual testimony. We have Ms. Mast and we have Ann Kirsch. So Ms. Mast.
Hi, thank you, members of the committee. My name is Carlin Mast. I'm a licensed clinical social worker and social work supervisor at the Maryland Office of the Public Defender's Parental Defense Division. Prior to my position with this agency, I was the inpatient perinatal social worker at a major birthing hospital in Baltimore where incarcerated pregnant people gave birth. OPD urges the committee to pass this bill. The devastating impact of early disruption in the maternal-infant bond is well documented and readily available. Children are collateral in this system. Today, I'm not here to discuss the impact of this horrific separation solely on infants and children. I'm here to tell you firsthand what separation looks like on a human level. For a newly postpartum and incarcerated mother, the bliss and magical moments of the immediate postpartum time often have an undercurrent of grief. Parents know that when the discharge papers are signed, they face the horror of leaving the hospital in shackles without their newborn. I can't begin to describe to you the sound of a newly postpartum person being forcibly separated from their infant. It's a sound that stays with you forever. It's guttural and jarring as it should be. It's unnatural to separate a new mother from their child. When I worked with incarcerated postpartum people leaving the hospital, I would often beg correctional officers to allow postpartum moms to take a photo of their baby back to prison. These moms are left with nothing as they discharge from the hospital after birth. They leave the hospital to go back to an empty prison or jail cell. They leave only to endure the postpartum time, the leaking of new milk coming in, or the managing of a C-section wound with nothing to show for the grueling work of pregnancy and birth. It's demoralizing and, quite frankly, a human rights violation by many standards. Simply put, it's cruel and we look away. It happens in the shadows. This act would attempt to address this horrific reality. It's not a cure-all, but a necessary step in the right direction that a growing number of states are adopting. It would facilitate preserving the bond between a newborn and its mom. This bond is one of the most protective factors for the child as well as the parent's success. Thank you.
Thank you. For Ms. Kirsch?
I am with amendment. I'm okay to go now?
Yes, go ahead and go because we don't have any unfavorable.
Okay.
Thank you.
Thank you. I am Ann Bocchini-Kirsch. I'm Director of Advocacy for Prepare. We work with people in the parole process and people in the reentry process. And I recognize the deep importance of family unification. And I think that we have a technological solution that has surpassed the need to incarcerate an infant with its mother and deny the father his paternal rights during that same amount of time with the CARES Act. And I would urge everybody to look at keeping the mother with the infant, but instead of utilizing a prison, utilize a GPS monitor. The women that we are talking about are low-risk women. They have to be on pre-release. You can't be on pre-release unless you have no infractions, good behavior, and you're very close to being released from the prison anyway. These are the people coming into the community on work release. These are the people on road crew. And these are the people who the federal government has proven are an incredibly low risk, less than a 0.3% recidivism rate over 3 years with 13,000 people with the CARES Act. So there's no reason to house them in a secure facility at all after they've just given birth to their child. There's no reason to put the father, as is problematically stated in this bill for me, as the father or secondary caretaker, but to encourage family unity right from the start, to send the mother home with her infant, with a GPS monitor, with rules, with partnership with correctional home detention unit, but to start her life with her child and the father and the grandparents and the community and the village that is going to raise that child. So I urge you to look at the bill and amend it to utilize our electronic technology rather than confinement.
Thank you. So I see Delegate Grammer has a question.
Thank you, Madam Chair. Thanks for bringing the bill. Am I understanding the problem is that there is no pre-release unit for women? Is that currently the?
No, not necessarily. Well, the pre-release center is going to happen. The problem is, where is it going to be done in the center? That's where we're literally having conversations, and it's lengthy conversations, because granted, it's not an easy fix because we don't know what we don't see, right? Because it's being built. There is also a discussion on the fact that as I attached to my testimony, there are some women that are not on pre-release status, that are medium status. So what does that mean? You know, the question is, do we temporarily put them in pre-release status? That's what we're, literally having conversations on. So that's what the crux of the issue is.
If there is a woman in pre-release status, what is the reason she would not be in the pre-release unit
Today,
because
there's no pre-release unit today. It's been passed by this body and by the legislature, but it's in the process of being built. It has not been built yet.
Delegate Conaway.
Thank you, Chair, and thank you, Delegate and panel, for coming in to testify. Can anyone talk about how valuable the colostrum is to the baby when they're just born or when they're new and feeding? The days old, weeks old breast milk versus?
Well, there are numerous studies that talk about the importance of breast milk for newborn babies, and that newborn babies who are breastfed tend to have developmental markers earlier. They tend to be healthier. They tend to suffer from fewer childhood illnesses because of the antibodies that they receive from the mother through breastfeeding, which is why, Delegate, I was so trying to get that woman to be able to breastfeed while she was incarcerated in Montgomery County, because I understand the importance of breast milk and the continuation of it versus Similac.
Well, the point I was trying to make for the better of the audience is that the first breast milk is different than the regular breast milk, and that's totally different than Similac or Enfamil plus iron, that type of thing. So thank you so very much.
Seeing no further questions, that concludes the testimony for House Bill 191. Thank you.
Back to my chair.
We're going to move on to, I believe it's Delegate Valentine's bill. Yep. Delegate Valentine, House Bill 973. Do you have anyone you wish to call?
I believe I do, Madam Chair.
Okay.
You signed up. Let me see if I can grab you to start up. Madam Chair, I did have a few signed up. He's checking.
Okay, that's fine.
They were here earlier.
Okay. Hey, that worked out great. We're all here and we're all back. All right, so do we have Richard Norman and Michael Shire and Mr. Boatwright? Okay, whenever you're ready, Delegate.
Thank you, Madam Chair. Good evening, Madam Chair, members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing Washington and Frederick counties. I'm here before you today to present and request a favorable report on House Bill 973, Public Safety Law Enforcement Officers Positive Community Feedback. This bill will require law enforcement agencies to maintain a record of positive community feedback for all law enforcement officers within their respective agencies. This bill directs the Maryland Police Training and Standards Commission to develop a uniform process to collect this feedback from members of the public. These records would be subject to public inspection in accordance with the Maryland Public Information Act. During the last several years, the Maryland General Assembly has spent a significant amount of time and effort in making changes to Maryland law so the public could be more informed with regards to records of law enforcement officers. I believe this bill is consistent with those efforts. This bill contains provisions which would create an accessible and uniform process that can be implemented by all law enforcement agencies in Maryland. While it is possible for law enforcement to implement such a process on their own, this bill would ensure law enforcement agencies in Maryland have the information on file and available if requested by a member of the public. A uniform standard would make it easier for these agencies to implement this initiative and create a transparent process. Allowing positive community feedback about an officer to be collected, reviewed, and released would provide a complete picture of that officer's employment history. In law enforcement, an officer's future depends on his or her reputation. This bill would help to provide a more comprehensive picture of an officer's complete body of work. These public safety professionals are the men and women who protect our families, our businesses, and our communities, assuring law enforcement officers that their full record would be available if their reputation or integrity is questioned or challenged will be beneficial as agencies in this state continue to struggle with staffing shortages, with retaining quality personnel, and the future of policing in local communities and throughout this state. For these reasons, I request a favorable report on House Bill 973.
Good afternoon, Madam Chair and members of the committee. My name is Clyde Boatwright, President of the Maryland Fraternal Order of Police. We feel as though that this piece of legislation will be something that our officers can look forward to when there's an opportunity for people to make judgment, whether it's at retirement or it's at the worst day of their life if they have an allegation against them. There's a history that balances out both the bad and also the good. I'll give you an example. A few years ago, I was leaving work, going to coach high school basketball, and I came upon the intersection of Pennsylvania Avenue and North Avenue in Baltimore City. I heard a boom, and I looked and I saw people that were standing at the subway stop. Everybody's attention focused across the street to one area. I was in my personal car. I got out of the vehicle, and there I saw a lady holding a baby. The baby was bleeding from the head. The baby had stepped out in front of a car and was run over. So the mother turns to me and sees me in uniform as I'm calling for assistance and just hands me the baby. So we started CPR and we did everything we could to save this baby's life. But there's no history or record of it in my file. There were members of the public. What's your name? I need to call your chief. People need to know about this. You guys worked to save this baby. And I recall when the medic showed up, I was so thankful that the paramedics was there because we were going to get this child help. And the medic, I heard the medic's voice say, "Don't stop what you're doing, keep going," until they got set up. But there's no record of it. It's almost like it didn't exist. So this is the type of things when I report to scenes and I give our officers positive feedback by saying, "Good job, you did a good job." We want to archive that. So we ask for a favorable report.
Good. I think we're on evening now. My name is Mike Shire, representing the Maryland State Fraternal Order of Police. Been a sworn police officer in Maryland for over 20 years now. Spent the majority of my career in patrol duties, and I'm also an attorney practicing in Maryland. You've heard about some of the struggles we've had as police officers just today alone, but I'm going to give another example, as President Boatwright did. A few weeks ago, I actually attended a town hall meeting hosted by my county executive, Pittman. I gave testimony about my role on June 18th, 2018, just down the road from here at the Capitol Gazette. I am extraordinarily proud of our profession's response to that incident, and it stands in contrast to actually some other active shooter events that we've seen in the news recently. That day, as I hurried to the call, I resigned myself to the fact that I might never see my family again, that I might not come home that day. I rushed into the building with my fellow officers, and we did what we need to do, and we captured the suspect that day. It was a long day. It was a hard day. There is no letter in my personnel file. There is no commendation on my record. I was one of the first officers there. I've also been the subject of false complaints. One woman filed a brutality complaint against me. She admitted I never struck her, I didn't hurt her, and I didn't use excessive force. She was just upset that she got arrested and convicted. The complaint was unfounded. But the General Assembly has changed that law so that incidents like this never get removed from my personnel files, and they're available for public inspection. Does anybody see the contrast there? You've allowed for expungement and forgiveness for citizens who commit crimes against our society, but police officers are not permitted to receive such forgiveness today. Everything we do on a negative is permanently public. So we need to be able to provide some balance and require agencies to hold on to the positives as well as the negatives. We need to do something to support our police officers because of the staffing crisis that we have mentioned. And the messages we are receiving from this General Assembly have just not been supportive of our profession. So we are asking you to collectively consider those impacts, start to highlight the good, and support House Bill 973. Thank you.
Good evening, Madam Chair and members of the committee. My name is Rick Norman. I'm a retired captain with the Maryland State Police, serving 28 years in the department. I'm currently the executive director for the Maryland Trooper Association, representing 2,600 people, of which 1,100 of them are active state troopers. Here to support 973 to add positive community feedback as a list of records that can be released for public information. If I was an active trooper today and you pulled a PI request on my file, you would see that I had an accident and I was disciplined for that. Luckily, that was the only thing that ever happened to me. And that's all you would see. What you wouldn't see is the governor's citation I got for a heroic fighting a person with a gun. No one was shot, no one was killed, and the suspect was apprehended. What you wouldn't see are the 3 superintendent's commendation I got for exemplary performance I did in my 28 years. What you wouldn't see are over 60 letters I've got from citizens praising me for the things that I've done as a criminal investigator and as a state trooper. You would see none of that. All you would see is an accident, and you would probably think he's a bad driver. How can you make an assessment based on very limited information? And that's all we're asking. Let's put it all in there. Let's make it all available to the public. Anybody wants a PIA request. Therefore, I would ask that you have or ask for a favorable report on House Bill 973. Thank you.
Thank you. Delegate Munoz.
Thank you, Madam Chair. Delegate, thank you for bringing this bill again. I just want to clarify, there was no opposition to this bill whatsoever. Is that correct?
That is correct.
And there's no material fiscal impact on absolutely anyone. Is that correct?
That is correct also.
And you have a Senate cross file?
I do. That passed the Senate last year as well as the year before.
Wonderful. I hope we can take care of this for you this year. Thank you so much.
Delegate Tolles.
Thank you so much. So let me just start off by saying I don't think it's a bad bill, and I see one of my good friends from FOP 89. If he's listening, hello, Angelo. They're good friends of mine. So I guess I want to understand, is this record for the public? So I have a question and a follow-up question, Madam Chair. Is this for the public or is it for the record? So like you're getting, well, I know you said it's for the public, but if you.
The answer is yes.
It's for the
all those
public and
things.
for your file, right? So is it for
Yes.
your file, for you,
Yes.
if like promotion purposes?
All those things.
For the public?
Right. It's requiring the agencies to be able to accept that feedback and hold on to it so that it's not going away, so that it doesn't disappear from your file or some way. Come up with a uniform system for
Do
holding
you-
it and receiving it as well, so that it can be available for the public and for the officer.
Do you admit that there are bad apples?
There's
Every group, right?
Bad apples in every group.
Will they see, Delegate Valentine, will they see the full file as well?
Yes, this would include records that are subject to public inspection and public information, along with the negative that is already available. So you would be able to see both sides.
You all came before and say you didn't want your record open because people may misconstrue what it's supposed to mean? Have you testified to that before?
We didn't want the
4 years?
negatives, because what we have now is anything negative against you is open to public inspection. So whether they're sustained or not sustained complaints, they're all subject to MPIA, and we're the only government employees that have this provision in law that accepts us from the MPIA normal provision, which is personnel records are not subject to public inspection.
So I would say, I will say it publicly. I don't mind saying it publicly. Again, Angelo is a good friend. They're great friends. I don't think it's a bad bill, but we all sign up for public service, right? So we gonna have good people have said some crappy things about me. Trust me, I've been in office probably about 10 years now. And so people said bad things. So I'm concerned with this bill because community policing and other great work that you do, I think the community will see that, but they also see the bad. So I don't know if you need to keep a record, right, to see this. So if you want to answer, I don't know if you need to keep this record because it's public servants, right? People know, I think, that the police community is there to, keep us safe and recognize that there are some people that will act up in any profession. So I'm not sure we want to, I guess I'm just trying to figure out why, and you please help me.
So it actually is twofold. The officer gets that positive affirmation that this is not a thankless job, that some of our people believe it's a thankless job. You go from sitting, writing a report to the worst day of your life in 30 seconds. And that could be the extreme of discharging, shots fired, or whatever. You're sitting at a rested state and the call comes over the air, it's around the corner, and then you run to that action. And then you have to take action, whether it's tackling somebody or doing everything under the law to prevent that suspect who is armed, has decided that he's going to injure people, and you take him into custody without incident. And his mother says, my son didn't take his medication. Thank you for not killing my son. I want to send something to your chief. I want to archive the fact that you did exactly what the legislature wanted you to do. You factored in everything. The fact that he has a disability. You talked to him. You gave him verbal commands. You worked with him. You reasoned with him.
Sorry to cut you off, and I'm sorry to cut you off. Do they not already, if I wanted to send a letter, and I'm just going to use my friend again, Angelo's great, president over there. And you put it in his,
there's no file to put it in.
Right. Can't people still do that?
There's no file to put it in.
You're requiring the agency to do that through this legislation. Right now, maybe the supervisor gets it, says, hey, that's great. And they say, hey, officer, you did a good job. And then they put it in the waste basket.
So I had a supervisor who said, I'm never writing my officers up for awards because they're doing their job. They got a paycheck next Friday. And that's not what this was.
Good morale.
It's not good for morale. Correct.
I would say, and say this, two things. You all have a police award ceremony, is that correct?
Some agencies don't.
Okay, well, I know Prince George's, we have a Valor Awards and to recognize it.
Get a lot of things right in Prince George's.
Of course, it's Prince George's. What's that thing? Of course it's Prince George's. Why wouldn't we get it right? Whatever that little stuff that's going around. So, I just say that to say that there are some agencies that do have that. Isn't that so? That they have those award ceremony. And so would you be willing to put in, like, when you do, community policing? Because I think that's one of the things I think we've lost since the time that I first got in office. There was a lot of community policing, and that is not as much. Would you be willing to put something like that in the record as opposed to, hey, he, saved a cat from the tree? Right? That's the firefighters do that, right? But let's just say you all, it's late, we get silly, we got a lot more to go. But I'm saying, would you be willing to put those things that you actually do in the community, not just beyond not just what you kind of sworn to oath to do, but all of those things. I think that's what's most important.
Yeah, I think this encompasses everything, especially if it's positive feedback. If a member of the community decides that they want to write, like right now, if the community services officer gets promoted, and they go to the community meeting and let them know that they're now going to patrol, they'll buy a cake. They'll talk about all the good things. They'll get citations from the mayor and the governor and all. And then they'll put it on Facebook, but then it's still not in the personnel file of the officer that this community association had such great admiration for this police officer, and now he's gone on to bigger and better things. So we just want to create a mechanism that you can also see the good, because the bad is going to be there, and we accept that. We don't like it. But it's the fact that if an officer is cleared and exonerated of any wrongdoing, that will live on forever for the rest of their career. And that allegation will always be there. We're now saying, let's also put the good there as well.
Yes. Thank you. Thank you, Madam Chair.
Sure. Delegate Simmons.
Thank you once again. This resonates so much, right, for those in the law enforcement community and what takes place on a day-to-day. Just quick, last year in Anne Arundel County, I just happened to be driving from my doctor's office, and where I witnessed an officer pursue someone on foot and eventually catch up with him and tackle him. I stood by, watched the officer.
Anne Arundel.
Anne Arundel.
Prince George is great, but yeah.
Anne Arundel. The gentleman subsequently had drugs and a weapon on him. And then I went out and did a citation for the officer. Did not put a letter in their file. Well, I probably should have did that as well. My question to you is that, what is the process from a police recruit to a senior officer or retirement, for as how do you escalate in rank? And is that an appointment or is that a test?
It varies by agency. Every agency has different testing and assessment mechanisms. Sometimes there's actual exercises, kind of practical exercises, interacting with the community, a critical incident of some sort, like a tabletop exercise, what we call them. But there's also reviews of their personnel files at some agencies, of their yearly evaluations. Their yearly evaluations may or may not include mentions of community members sending in emails. So the answer to your question is it varies by agency.
If you don't mind me just quoting your chief, who indicated to me that she promotes based on activity. You got to be involved. You got to be active as an officer if you want to gain rank in Anne Arundel County Police Department.
Right. And
so that goes to the letters and that goes to acknowledgement of things you're doing, because I was recently made aware that one of the SRO officers in the school, when y'all starting to draw down on officers out of the school, that he's a football coach, a mentor. It's a lot of other things that officers do that you're right, that they do not get credit.
Right. And this just provides that mechanism, just like you can go online and file a complaint, go online and file a compliment, and it'll get included in the officer's personnel file to give a complete picture.
Delegate Williams.
I just wanted to comment that yes, that chief she promotes by activity. Before she came to Anne Arundel, she was the chief of police in Hyattsville, Maryland, in District 22 in Prince George's County. That's all I wanted to add.
And a major for Prince George's County Police before then.
I don't know. Was there a question there?
The question was, who's got her now? Who's got her now?
Who's got her now? So I have a quick question. So Mr. Boatwright, you mentioned, you said they will put it on Facebook, meaning if you got, you get the cake and somebody's leaving or whatever. Are officers allowed to post their own attaboys or attagirls on the World Wide Web? I just always want to say that.
Typically in uniform, no.
Right.
Yeah, social media policies prevent that. When I say they, I mean the community members.
Right.
Yeah.
That's what I figured.
Yeah.
I just wanted to, so I was getting to the fact that while we around this table, if we do something that we think is great, we can post it all day long. We can send out a newsletter and tell the world. But I don't think you all have that same privilege. Is that correct?
You're correct. Yes, ma'am.
Okay. Thank you. I see no further questions. That concludes the testimony for 973, House Bill 973.
Thank you. Thank you so much.
Okay, I need to change the order ever so slightly. I'm gonna call up Delegate Embry's bill, House Bill 302. Delegate Woods, if you could just stand by, I apologize. And if those witnesses who are here for House Bill 118, if you could just stand by. Thank you. So we're gonna pull up House Bill 302, Delegate Embry.
He had to leave. Oh, is that okay? Yeah. Thank you.
Thank you. Should I
Sure.
start?
Yes, please.
Thank you so much, Madam Vice Chair, and all my wonderful committee mates. This is House Bill 302, Elizabeth Embry, Delegate 43A. So you may remember this, Delegate Nicole Williams introduced it last year. And so you've heard, I think, well, I have 3 minutes, but I probably should only get 2. But I will not use the full 3. So currently it is a misdemeanor for a police officer, correctional officer, or a few other categories of persons to have sexual contact with a person who is in their custody, or who is a victim or witness or suspect in an open investigation that they are involved in and know about. So that's existing law. But what we've learned, and State's Attorney Braveboy is going to talk about some of these really awful cases, is that that penalty really doesn't reflect the nature of the crime. This is a sexual crime. Consent is impossible under those circumstances. And so the bill proposes to make it a felony with a 10-year penalty, which is consistent with a 3rd-degree sex offense. Which we think is the comparable crime for this behavior. And it also requires, consistent with that, registry as a tier 1 offender, which is sex offender, which is, there are 3 tiers, it's the lower tier, but would require 15-year registry for that person. So with that, I will turn it over to the state's attorney, who has examples of how important this bill is. Thank you.
Thank you very much. And I appreciate this opportunity. I want to first thank Delegate Embry for taking up this bill, as well as this committee for considering it. So good evening, I believe it is, Madam Chair and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here today in strong support of House Bill 302. When a law enforcement officer or a person in positions with similar authority participates in a sexual act with someone who is in custody or under their care or supervision, it really becomes impossible for that individual to have given consent. There is a power dynamic there. The individual's liberty is at stake, especially their immediate liberty is at stake. And so in these situations, we believe that the individuals who participate in sexual activity, they're doing so because they feel like they have to, and no person should be in that position having to make that difficult choice. I can tell you about a couple cases that my office has handled. One involved a young 19-year-old mother who was on her way to pick up her son when she encountered police in Fairmont Heights. She was arrested. She was brought back to a station that was within the municipal complex. And so she was the only one there with 2 officers. One of those officers, propositioned her and then essentially conditioned her release in being able to get back to her child with her agreeing to have sex. Ultimately, she did agree. But again, it's not something that she would have done, but for the fact that she was scared, that she felt she had no other choice at that moment. And so we did prosecute that case. The officer was found guilty of having sex with someone in their custody. However, because it was considered a misdemeanor, the amount of time we could ask for was very, very a short period of time. And so we think that this is absolutely a felony offense. It's absolutely a more serious offense than how we treat other types of misdemeanors. And then just one other case I want to mention, an officer.
Could you hold that since we have the time? I wanted you to finish that story, but
okay.
I'm sure someone will ask the second case that you wanted.
Oh,
to
okay,
mention.
yes, then I can hold it. And but thank you so much for your consideration of this bill, and I ask for a favorable report.
Thank you. Is Mr. Nicholas Leonardi here?
He was here. He had to leave to pick up his family.
Okay.
So.
Okay, great. Well, are there any questions? Delegate Carden?
Thank you, Madam Chair. Thanks for the bill. Delegate Embry, this was introduced last year. Did you introduce it last year?
No, it was Delegate Williams.
Okay. And did it pass the House last year?
It did not.
Okay.
It did not, was not voted on in committee, I believe.
I hate to steal Delegate Munoz's thunder, but former Delegate Brave Boy or State Attorney Brave Boy.
Yes.
Can't help it. Can you give us another example?
Sure. Thank you. Thank you for asking.
Thank you. I love it.
We had another case where an officer stopped an individual who was, we believe, targeted because of the fact that she was an immigrant and she was in an area where we have a lot of migrants and people who are here in our community. Some are documented, some are undocumented. And we think that this individual who does not normally patrol that area, that officer went to that area essentially seeking a victim, which he found, and pulled her over and forced fellatio, or let's say conditioned again, not getting arrested, not having further encounters with that officer on her performance of a sexual act. And again, this is not a misdemeanor. It's not like slapping or hitting or threatening someone. This is essentially forcing someone because you're in a position of authority over them. You have a badge and a gun, right? And the force of law behind you. And so for people, that is very intimidating. And so we believe that, we should hold all of our officers, those who are sworn to protect and uphold the law. We should ensure that they meet all of the standards of someone in that type of position. And by acting in a way that is contrary to that is putting, people in a position to have to make these life-altering decisions. I mean, this woman who I've had a chance to now meet, her life will be forever changed. She will always look at law enforcement with a jaded eye because of what happened to her, and no one should have to experience that. So we just ask that this type of offense be given the seriousness that it deserves. Thank you.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. Just to clarify, there is no opposition whatsoever to this bill. Is that correct?
That is absolutely correct.
And was it cross-filed last year?
Yes.
Did it pass out of the Senate?
I believe it did. I'm sorry, I should know that. I believe that Senator Muse's bill did come over.
Okay, and my
But
final question would be, do you believe that this crime affects mostly women?
Yes. I
So
would
this
say
is a
that's
crime
correct.
against
Yes.
women? Okay, thank you very much.
Not exclusively, but primarily. Yes, thank you.
Delegate Simmons?
Thank you, Madam Chair. I wanted to know with the incidents pertaining to the patrol officers, number one, were they in uniform? And number two,
Yes.
were they wearing body-worn cameras?
They were in uniform. They were not wearing body-worn cameras. These incidents happened before that law that you all passed, which was a great law. Thank you to the legislature, went into effect.
Did you have any? Okay. Delegate Conaway, did you have a question? Okay. Well, kudos to you for passing that bill. Thank you very much. Okay.
Thank you.
I see no further questions. So that will conclude our testimony on House Bill 302. Okay, we're going to move back in order. House Bill 118.
All right.
Okay.
Would you like to bring up the panel?
Yes, please. I have, I can't say it all of a sudden. Miss Braveheart. I've been calling you Miss Braveheart all this time. Willie Hamilton and Stanley Mitchell. It'll be on my first panel, please.
Okay.
And you know what? We have a second panel. If you want me to just go ahead and have.
Yeah,
a
you
fun-
can.
Okay, Gerald Dent.
Mr. Dent,
Mhm.
Mr. Timmons, and Mr. Smith. Okay. Okay. Gerald Dent, Ralph Timmons, and Percy Smith, if you'll come on up. Come on up and just pull up chairs, and we're gonna share mics. Okay, so the first panel will be Ms. Braveheart, Mr. Hamilton, and Mr. Mitchell.
There you go.
All right.
They move around. And so what we'll do is you'll switch. Okay. Yeah.
All right, you ready to go?
I am ready. Thank you,
All
Madam
right,
Chair.
there you go.
Thank you very much, Madam Chair. Thank you, members of the committee. I'm Sandy Bartlett, District 32, Anne Arundel County. For the record, I'm here to present House Bill 118, Correctional Services, Geriatric and Medical Parole. So House Bill 118, if enacted, does a few things with respect to the parole provisions. The bill establishes some parameters for geriatric parole. The Maryland Parole Commission will, under the bill, would consider the age of an individual and allow for parole if, based on the totality of the circumstances, there is a reasonable probability that the individual will not recidivate. Importantly, the commission evaluates whether such release is compatible with public safety. These provisions apply only to an incarcerated individual who is at least 60 years old, has served at least 15 years of the sentence imposed, is not registered or eligible for registration on the state sex offender registry, and is sentenced to a term of incarceration for which all sentences being served, including any life sentence, are with the possibility of parole. If you were not sentenced with the possibility of parole, these provisions would not apply, and a parole hearing under this bill would be allowed every 2 years. In the bill, we also tighten up the terms of medical parole. We define chronically debilitated, incapacitated, terminal illness as determined by a licensed medical professional. We also provide minimum guidelines for the commission to use as to what to consider when deciding whether to grant medical parole. House Bill 118 brings compassionate release to Maryland and addresses ambiguities in medical parole. You will see there is testimony. Actually, you won't see it just yet. I don't think you have it, but we will pass out the testimony from the chair of the Parole Commission, you do have it, great, Mr. Bloomberg. So thank you very much for your consideration. I urge you to read the testimony, especially the favorable testimony with respect to this, and render a favorable report. Thank you.
Okay, and Ms. Braveheart?
Sure. Good evening, ladies and gentlemen of the community. I'm Shakina Braveheart with the Justice Policy Institute. It is beyond the training and responsibility of correctional officers to change adult diapers, feed, bathe, address the frail, push wheelchairs, or even rescue the vulnerable from occasional mishaps. For example, in the winter of 2022, a 100-pound, 86-year-old prisoner wandered off her housing unit at 4:30 a.m. for morning insulin. The wheels of her walker became stuck in early morning ice and snow, so she remained outside on a prison compound in dark sub-freezing temperatures. Others could see her from their cell windows, and alarmed, they began to bang on their doors and yell in an attempt to alert the officer on duty that she was stuck outside in the snow. What did he do? He threatened to issue a disciplinary infraction to anyone else who yelled or banged on the door. He didn't dare venture out to get her or call an emergency code on his walkie. Why? Because it is prison. It's not a nursing home or a hospice center. And there's a degree of cruelty, maybe not policy, but definitely in practice. At what point did incarceration become less about correction and rehabilitation and more about exacting revenge through perpetual punishment? And who exactly are we really sticking it to by keeping fragile, harmless people behind bars? It's not about public safety. Nationally, it costs about $34,000 per incarcerated person per year, and that rises to $68,000 per year for someone over the age of 50. And this difference is attributed, of course, to higher healthcare costs. Yes, justice must be served, but it should not deviate into the inhumane cruelty and expense of over-incarceration. Medical and geriatric parole laws were meant to solve this problem, yet grant rates show that it is unworkable and will remain so until we make the corrections to the statute language and make practical reforms. Right now, the older a person is, the longer term they serve, the least likely they are to reoffend, the more likely it is they'll be denied parole. And for these reasons, I ask this committee to please issue a favorable report on compassionate release, geriatric medical parole. Thank you all.
Thank you, Mr. Hamilton.
Good evening. My name is Willie Hamilton. I'm a formerly incarcerated person. And the reason that I asked for you all to give a favorable reading on Bill 118 is that recently I was there on these forgotten tears. And the reason why we call them forgotten tears because they're strategically placed in areas of the institution that are less frequently traveled. And also, and not to be graphic, but when you go into these housing units and you go to this tier, immediately you can smell the stench of the units. These are men and in some cases women who are housed in an institution that was not designed for them. And like Ms. Braveheart said, that there's no nurses or aides who are there to change diapers, to clean up after these men and women. So we, as incarcerated individuals who have the ability to go to these forgotten places and the compassion to do so, we do it for them. We bathe them. We change their diapers. We clean them. In some cases, we feed them. And in some cases, we clean up the housing, their cells that they're in, because no one is there available for them. So I ask for a favorable viewing of this bill for all these reasons. And also, this is not about punishment. It's about humanity and compassion. And I yield the rest of my time. Thank you.
Thank you. And Mr. Mitchell, next, please.
Good evening. My name is Stanley Mitchell. I'm a returning citizen. I've been in the community 13 years now. Came out on the Unger decision. I was one of the guys that Mr. Hamilton was talking about. I was 65 years old at that time, and I was in that unit. And my health was totally dependent on how another inmate felt in terms of taking me. I had a stroke. So this is a parole issue. These individuals that are on that tier, when you go for parole, the first thing they want to know, what have you done since you've been incarcerated? Have you been to school? Have you worked? These individuals are not given the opportunity to work because of their medical reasons. So the chances of them making parole are slim and none going through the regular process of parole. So this bill is definitely needed to give them an opportunity to be paroled. Thank you.
And thank you. And Mr. Dent is next.
Good evening. I'm Mr. Dent. I spent 40, first of all, good evening, Madam Chair, ladies and gents. I myself spent 40 years in the prison system, and the last 15 of that odyssey, I was tasked with watching over the guys that was apt to commit suicide, and those guys whose health was so fragile, they passed away any day. And from the time I was 50 till 69, when I was released, I'm 77 now, I got blood tests from 50 to 69 and didn't understand or realize I had hepatitis C until I was released. So the medical response in there is shoddy at best. And I pray tell y'all be humane enough to take in consideration. But my friends who I left behind and consider medical parole, Bill 118, can't think of a better blessing than that. Thank you for your time, and it's a welcome opportunity.
Thank you very much. So let me go to Mr. Timmons.
Yes, I'm Mr. Timmons. I served 30 years, 10 months, and 17 days. And in 2010, I was diagnosed with hepatitis C. And when I went out to get a liver biopsy done so I can receive the medication for treatment, they told me I was too early. So which means that I wasn't in late stages for the treatment. When I got released 4 years later in 2014, I went to see a doctor about getting treatment for my hepatitis C. There, I found out I had cirrhosis of the liver, which came from the hepatitis C, because the prison knew where I had it, and that's why they didn't give me the medication, because they thought by me having cirrhosis of the liver, the medication wouldn't help me. So if I'd have stayed in there, I'd have been dead now from that hepatitis C, because they didn't give me the treatment. So, and I feel there's other inmates in there like me that been locked up long as I have, that they should have an opportunity to their life and their freedom to get their health taken care of just like I did.
Okay, thank you very much. And Mr. Smith.
Good evening, everybody. Thank you, madam. Thank you with your powerful crew here. That's what I said, powerful crew. We, the Second Chance Returning Citizens, have done a great deal since having had another chance at life on the outside. I have been involved with many projects with the community and for the community. Right now, I'm involved with 2 Baltimore organizations, BUILD, Baltimore United and Leadership Development. Also, Baltimore Connect, which is a resource hub. I am a certified peer recovery specialist and supervisor. I have assisted over 250 young men to get back to work and get GEDs. And over 500 young adults get treatment for their addictions. I also have organized over 5 resource fairs within this Baltimore city and throughout the city, established 2 men's groups. And I'm now working with Turnaround Tuesday, which is a job movement that help people in Baltimore City get back to work and get a career. So right now, my thing is to ask you all about this geriatric piece of Bill 118. You're powerful. You can make some changes. You can save some lives. That's what we're here. We are at the geriatric age here, but we are here fighting for those who we left behind. If we don't help them, they will die. We're fighting for them. And when they get here, they will do the same things that we are doing now, fighting for somebody else. If you get it to the age of 60, you don't want no more prison. You don't want no more harm. Thank you. Please support this bill.
And thank you. Does the committee have any questions? Okay. All right, anybody else? Go ahead, Delegate Kaufman.
Okay. I just didn't know if you saw me. My question is, and Delegate Bartlett, because the hour is late, can direct who's going to answer it. Thank you, Madam Chair. I want to touch on 2 particular issues. I was once talking to a legislator about this bill, and he said, oh, 60 is not old. I know a 60-year-old who ran a marathon last year. And so, you know, my parents are older than that, and they certainly don't consider themselves old. So could someone touch on how the fact that people, incarcerated individuals, age faster and tend to have more specific health ailments, even if some people on the outside don't view 60 as that old? And also my second question is, what I see the Maryland State's Attorneys Association is opposed, and I'm sure we're going to hear about how it's a threat to public safety. So could one of you touch on, you talked about this in your testimony, but a little bit further on how the chance of recidivism and committing crimes goes down as people age?
Okay, a report that the Justice Policy Institute released in May of 2023 cites a University of Pennsylvania report that reported that an incarcerated person at 50 is equivalent to a person in the outside community at 72. We have to keep in mind, you know, dietary restrictions, the constant level of stress, injuries. Some people come into the system addicted to drugs and or alcohol. So they're, one, not healthy a lot of times to come in, and it's not an environment that would contribute to good health. In fact, health declines. What was the second question? If you have, I maybe.
Is the question about, because we hear, oh, this isn't good for public safety. So if you can talk about how older people and how they're less likely to recidivate or commit crimes once they're released on medical parole.
Want me to answer that question?
Whoever Delegate Bartlett wants to answer.
In my day job, I work with returning citizens and reentry. I've attended more funerals than going back to court for individuals that have been returning. As a result of the individuals that I know that have came to my program and other programs, there's a zero recidivism rate. As I said, more of them are coming out and dying rather than commit further offenses.
Can I add, please? It was about 500 returning lifers that came out on this Unger case. And I'm telling you, you have not heard about any of the lifers getting in trouble or starting in trouble. So that's one. Two, we are coming to the age that we want to live. We want to spend the rest of our life with our families. That's why, Mr. Delegate.
All right, I see Delegate Taylor. Do you have a question?
I do. Thank you, Madam Chair.
Thank you for being here today. Can one or two of you comment on the condition of your release? So you're here, right? So it looks like there's a process for you to be released. And I don't want folks to think that, oh, we don't need this because you're getting out, right? That's number one. And then number two, are we looking at thousands that will be released? Give me an idea of how many people will actually qualify if this bill were to pass.
I can speak to that.
All right. Currently, there are 650 individuals over the age of 60. I think there are 1,233 who are over 60 who have completed 15 years. This was from February 2022. That was the last it was updated because DPSCS, they kind of keep data in like 4-year blocks. And I do want to point this out that reforming medical and geriatric parole is not a get out of jail free card, right? People would still, have to meet criteria. There's victim notification, just like there is in regular parole. And victims can testify, they'll be there at the hearing if it is an open hearing, so they do have a say. And to be really honest, the crimes that the person committed, it is taken into consideration in the case of geriatric parole. When it comes to medical parole, the focus is primarily on the likelihood of reoffense. That means the physical capability to do so. And also the severity, their incapacitation and things like that are taken into consideration.
I'd like to speak to the recidivism. I mean, they got warehouses that dispel guys who coming out, they've been locked up 20, 30, 40 years. That don't even answer into what we got here. I'm saying I was released because I was an Unger case, meaning that I was held 40 years because my rights were violated. I wasn't innocent. It's over 200 of us have been released. I wrote a book. I got 2-3 programs. It's up and running in the community. I got released right after the Freddie Grave riots. I was down in Gilmore 2 days from being locked up 40 years, trying to understand and get some organization to that madness. There's no doubt 60 years, when you're in prison to 60 years, when you in the street with good milk, sunshine, and no stress, you ain't drinking water for 400 years through those lead pipes, you ain't breathing asbestos, because all the prisons back then, that's all they had was that in there. You can stand a free 60 beside an old 60. And you'll know the difference. Trust me.
Yes. Just really quickly,
Mhm.
are the victims somehow included in the decision?
In many cases, the victims even come to court for the guys who've been locked up and feel though they did enough time. And like I said, I was on the death watch, and every one of them men died. Regret that they didn't have a chance to bag them people's forgiveness.
Thank you very much. Delegate Carden.
Thank you, Madam Chair. It's good to see you in that seat. I like that. Thank you all very much for your compelling testimony. I really appreciate it. This is actually for the delegate though, for Delegate Bartlett. So you still have to go through a parole hearing as a geriatric inmate. Is that correct?
That's correct.
And they have to determine whether it's an appropriate time for a release during that hearing, and they will hear all the testimony. Is that correct?
That's correct.
Okay. Why shouldn't we mandate that the parole board consider incapacitation or physical incapability as a factor so that we don't deal with this public safety issue that I know that the other side's going to come up and talk about? Because even if you're 60 years old, I hope to be a healthy 60-year-old, and I think I'm going to be, I'm going to still be able to lift weights and do things. So if somebody is still potentially a danger to the community, why shouldn't that be able to be a factor in terms of their physical ability if in fact, regardless of whether they're 60 or 65 or 25.
So I'm not quite sure. I thought I understood your question, and then I lost
right
you.
now
But-
on line 28 of the bill, one of the factors is that it has been rendered physically incapable of presenting. That's only one.
You're at probably at medical parole. You're probably at medical parole. Yeah, you're under medical. 7-309 is medical parole.
Okay.
Yeah.
On medical parole.
Yeah, that's why.
So
if you look at 7-305 and if you look at 7-310, you'll get into the part on
geriatric.
on geriatric. That's the whole explanation as to what's required, 60 years old, 15 years of sentence, et cetera, et cetera. But also on page 2, the general premise under 7-305 is whether release of an incarcerated individual on parole is capable, compatible with public safety. Ooh.
So they do have to consider public safety.
It is a factor under under the general premise of parole. Yes, under 7-305. It is the general premise of parole.
Okay. All right. Well, maybe I'll follow up with you on that.
So are you saying that you're suggesting that?
I'm just wondering, it seems to me as if that you can have other factors that supersede incapacity to allow somebody to be able to be released. And the question is, if we can let somebody be released, but they still could be a danger to the community, but the law allows them to be released, I think we're creating unnecessary liability.
Well, keep in mind, here's what we have. We have 7-305, and on page 8 of the bill at C, it says that in addition to 7-305, when we start talking about the geriatric parole under 7-310, so in addition to 7-305, which are the general parameters, and public safety is one of those, as I spoke of on page 2, line 21 and 22. So all those parameters have to be met. So in addition to those under 7-305, each commission panels goes on to decide whether or not the individual is suitable for parole. Okay, so it's not just with geriatric parole, it's not just the age and it's not just the 15 years.
But you do get to consider whether, but regardless of whether they are, I mean, physical incapacity, I think there should be no question. I would be perfectly fine if somebody doesn't have the capacity to really cause the safety harm that they may have been convicted of.
Right.
But if they are, if they still have the capacity to be able to do it.
Well,
It seems to me like just because they've been incarcerated for 15 years and they happen to be 60 years old, is that enough of a reason, regardless of whether they're, and I understand that your witnesses have said that the recidivism is essentially at zero. You guys did a very good job of doing that. But it seems to me that, the question is, the purpose of the parole is to determine whether they are a safety risk. And if that's not a major piece of the hearing, then I might have an issue. But
well, it is a major piece of the hearing because you have to get past 7305 to even get to 7310. Okay, so all those factors under 7305 have to be met, as well as, and I didn't read the rest of it because I didn't want to read it, but I will for the record. So after each commission panel determines whether an incarcerated person is suitable for parole, they're going to also consider and give weight to the age. So they're just going to give weight to it. Okay, the 60 years old of the incarcerated individual and the impact that the age of the incarcerated individual has on reducing the risk that the incarcerated individual will not recidivate. So it's very detailed, it's very outlined, it's outlined pretty well so that it'll be nice and clear and it won't just be, okay, you're 60, okay, release. It's not just 60, 15 years, you're automatically released. All the factors still have to be in place, and the public safety is a huge factor, as well as the likelihood that you will not recidivate.
Thank you. Delegate Simmons, I believe you have a question.
Thank you, Madam Chair. So looking at the increased number of people in facilities that have health issues, do any of y'all view your medical condition, whether pre-incarceration or while incarcerated, as a death sentence due to your denial of medical treatment?
Mine was.
That's exactly what you touched.
I had hepatitis C and they wouldn't treat me for it. And it turned into cirrhosis of the liver. And I didn't find that out until I was released.
So did that meet the crime that you was convicted of? Did that view of your death sentence meet the crime to which you was convicted of?
Let me go back to something he was saying about the parole board. I've been in front of the parole board 4 times, right? The parole board did not consider your health when you go in front of them, okay? Only thing they consider is what you have accomplished since you've been in prison. They'll ask you to finish this, to get this, and get that. When you serve a life sentence, a lifer is not entitled to a lot of things to benefit them to program to get out because they're looking at us to be there until we die. So when you ask us to go program and get this and get that, how can we get something that we are not eligible for? So then they'll give us a set off because we don't have what they asked us to get. You understand? And the only time that they do get hold of our medical files, if the jail presented to them, letting them know that this man is sick and that he should be paroled. And it's very rare that they do that.
And may I do a follow-up to the member that asked about whether the person could still be capable of committing a crime? I assure you, I did 40 years. And I've known people that went up parole that had last stages of AIDS and were dying. And they said that was self-inflicted, so we're not going to give it to you. So the people that we're talking about letting out, they can't even change their own diaper. They cannot feed themselves. So the chances of them coming out physically being able to commit a crime is 0. The parole board is like we were saying, to get out on parole, you have to earn it because it's a privilege. It's not a right. So when somebody comes up there and says that, look, I'm 60, I'm dying. They really are. And so when they come out, you know, the chances of them committing a crime, I mean, anybody commit a crime, but we're talking about blind people, people that don't have no legs because they lost them because diabetic surgery. So there's not like somebody's going to come out and then all of a sudden they're going to get well and go into, you know, armed robbery or whatever they were doing before they went in. That just is not a reality.
I'm speaking from a place where still taking these men and sticking them in some lonely corner in the prison system. Give these men an opportunity to come out and die with some sense of dignity. A lot of them.
Can you get in front of the microphone?
Nothing.
Get him, can hear you. Go in
I
front
said
of
a
the
lot of them
microphone.
men don't have no family left or nothing. I watched, man, 15 years my senior, who was in the penitentiary when I got there, and man, 20 years my junior, who was there when I was there, and I watched them all die. Deaths that were so horrible. That's all we ask. Give them an opportunity to die with somebody to be around that care enough to at least say a prayer with them. That's all we ask for. We ain't asking for nothing. And at no time have I ever thought in terms of not about my victims. Because the gentleman that I slayed, I know that he could have been anything. He could have been a lawyer. He might have been a scientist. So he might have been. So I knew that when I got here, I had to live for two peoples in every pop and every other individual that my victim might have been. And I can't lament the point enough to know that them guys died feeling more pain and grief because they never have an opportunity to ask their victim family to beg their forgiveness. We just asking for something humane here.
And can I just say that it's very important to keep if you can read Chair Bloomberg's letter. He's someone who is right there. He is a parole commissioner. Also, keep in mind that this bill contains 3 separate sections. As I mentioned, 7305, which is general parole, 7309, which is your medical parole, and 7310, which is geriatric parole. They're each distinct as to what is required and what is allowed. Thank you.
Okay, thank you. Are there any more questions for this panel? Okay, seeing none, we're gonna go, oh, I'm sorry. Delegate Conaway, go ahead.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. My question is, what about if the victim's family hears your pleas for compassion and they say no?
We gotta respect that.
Could you respect that?
I don't have no other choice.
No, I mean, you could have a choice to say, well, I don't respect that they should be more loving and all of this here and kind and all that.
Well, that's not exactly how the process works.
No, I didn't ask about the process because some of the gentlemen had said that they would like to have a chance to talk to the victim's family, give the victim's family a chance to say, we forgive you, maybe you've done enough time in our eyesight. And all I was asking is, if you ask the victim's family and they say no, I mean, could you accept it? Okay, so I understand.
Absolutely.
Yes. Then you, as the parole panel, got to consider the victim too, also their feelings. So that's just one of the reasons we're saying that.
Sure.
This is not good. We're not trying to make no law. We're just trying to make the opportunity.
Sure. And I was just asking you for the other side of the coin. I was speaking of somebody's out there going to say no.
And right.
So I mean, I have my own personal dog in this fight if you really want to know.
Yeah.
So I would say no.
Yeah.
Okay. So
and rightfully so.
I can say what I want to say.
Right.
If it's in reference to my family members. Thank you.
Well,
And gratefully, that's a part of the law, fortunately, that the family and the family of victims, they do get to speak out. They not only get to write an impact, but they actually get to be present at the hearing and state that for the record to the Maryland Parole Commission in front of the offender and anybody else in the room, how they feel about it. So it is definitely weighed as it should be.
Okay. One more time. Any more questions for the committee, from the committee? Okay, I think we can go ahead and excuse this panel and bring up some more folks for testimony. Okay. Is Elizabeth Hillard in the room? Okay. Douglas Weinstein, Stephen Carver, Heather Warnken, Benita Taylor. Looks like you're the only one, Miss Taylor.
Yes,
I'm gonna
I
call one more
am.
time.
No, Elizabeth
Is not here.
is not here. I'm one person from the Public Defender's Office, and
Okay.
I will make this very short. The Public Defender's Office, of course, is in support of this bill. This is a much needed bill. We don't have a prison hospital in Maryland. We put elderly people, we put very sick people, terminally ill people in wards. We put them in special units where there really is no nurses or doctors really to care for them on a daily basis. There's no hospice care provided to these individuals who are incarcerated. You have our testimony, and I'm not going to belabor it to repeat it because time is going away from us quickly, and I know everyone wants to go. But I would just reiterate a couple of facts is that we're not talking about a lot of people in Maryland, but we're talking about a group of people who are seniors, who are very ill, and that if nothing else, we should have compassion for them. Just like we have compassion for the victims, their consideration, it says in the bill, the totality of the situation. It doesn't limit it. It says totality of the situation. And we're talking about in Maryland that we have, let me take my glasses off, that the statistics say that there were 2,035 people between the ages of 51 and 60 and 1,105 over the age of 60. So we're not talking about tens of thousands of people that were released, and we're talking about people who have been incarcerated for a while, people who have served a large amount of their sentence, but are very ill or chronically incapacitated because of various surgeries or illness. I would just please tell you to look at our testimony and consider it in your deliberations. And I'm available if you have any questions. But I think the panel before me was just excellent.
Thank you. I'm just going to call one more time, Mr. Weinstein, Mr. Carver, and Ms. Warnken. Okay, so they're not present. So does the committee have any questions for Ms. Taylor? Okay, I don't see any. So Ms. Taylor, thank you very much.
Thank you, and we urge a favorable passage of this bill. Thank you very much.
All right, I'm going to call up Ann Kirsch. If she's in the room, she's favorable with amendments. Was she on the?
She's on the video.
Okay, yes, that's perfect.
All right.
Okay, go ahead, Ms. Kirsch.
Thank you. I am Director of Advocacy for Prepare, and I very much support the idea of medical and geriatric parole. The only thing that I would ask would be to amend this bill to remove the charge-based exclusion, or actually the sex offender registry-based exclusion, with attention being paid to how easy it is to get on that registry. People think of the most serious crime. What they don't think of is that two consenting teenagers can have sex in Florida, end up on the lifetime registry, come to Maryland, and end up being ineligible for geriatric parole for a charge much less serious than murder. We have to trust the discretion of our parole commission. They are instructed to look at the circumstances of the crime in 7305. They are instructed again in this bill to look at public safety. The parole commission can sift cases and tell the difference between a third-degree sex offense where perhaps someone in a robbery tapped the victim on the backside with the gun that they were using and ended up with a registrable sex offense versus a severe sex crime and somebody that they're concerned about recidivism. That is the job of a parole commissioner. By adding a broad charge-based and registry-based exclusion to this bill, it really undercuts the purpose of compassionate release. These are people who are incapacitated with medical parole. The Ungers had no charge-based exclusions, and yet the Ungers, which included plenty of sex offenses, have an incredibly low recidivism rate. So I've heard nothing to support the idea of excluding specific individuals.
Thank you very much. And does the
Madam Chair, do you have Margaret Berry
I
from the
do not.
Washington Women's Democratic Club of Montgomery County?
No,
No.
we can double check, but let's
Okay.
finish this first and then I'll double
Thank you.
check. Okay. All right. Committee, do you have any questions for Ms. Kirsch? Okay. Okay, I don't see any. Thank you very much, Ms. Kirsch. Yeah, I didn't see her here. Okay, so we do not have Ms. Berry listed at all. We're gonna go to our unfavorables now. Okay, and we're gonna start with Mr. Kroll. Is he here in the room? All right. And then we have virtually Gordon Pat Jr.
Madam Chair,
Yes.
members of the committee, Stephen Kroll, State's Attorney Coordinator, Executive Director, Maryland State's Attorney Association.
Start with
I've been prosecuting cases since 1984. Let's get a couple things straight. I compliment the people who have testified ahead of time, but the public defender, Ms. Taylor, is correct. We must think of the victims, the victims. Not one person said, I did this to my victim. I'm serving 30 years. I did 40 years. For what? Not trespass, not malicious destruction of property, but serious crimes. And nobody volunteered a single statement to say, I did this because I served time for this conviction. Nobody did it. Nobody honored the victim that the public defender said we should honor. These are the most violent defendants in the system. My comments are directed mostly to medical parole. First, let's solve Delegate Cardin's issue. And we can solve it very easily, Madam Chair. If we look at page 3, line 27, it's changing or to AND. That simple of a change solves this problem. Making that one change, line 3, page 3 rather, line 27, changing or to an AND. DV cases, you have a 45-year-old who kills their spouse, their partner, someone that they love. They're going to serve 15 years and be eligible for parole at 60 years of age. They'll get a parole hearing before somebody else gets charged and paroled for a first degree, where their parole eligibility is 18 years. How is that possibly fair? By putting 15 years for a domestic violence victim, getting a parole hearing before somebody else in a first degree murder case. It is not. The bill is not fair. We talked about cases. I'm being texted by Baltimore City about 3 cases in the city where medically paroled people have committed serious violent offenses. Don't think everyone's going scot-free. And I'll wrap up, Madam Chair, but I've been sitting here since 1 o'clock waiting to testify. In short, we should give credit for those that have done well, but we give more credit to the victims of crime whose scars do not go away. I'm asking for those changes, and I'm not convinced yet, not on this bill, that it should be what? Favorable with amendments. I'm asking for an unfavorable report as to House Bill 118, and I'm happy to answer, even at this late hour, any questions. Thank you.
Thank you very much, Mr. Kroll. And go ahead, Mr. Pat.
Good evening, Madam Chair, delegates, and everyone that's present there. This is a little difficult for me because I find myself on the opposing side of a bill that I believe is very important. I oppose the bill for the simple reason that it has a carve-out and exclusion to a specific type of offender. I question where is the compassion when it comes to that particular issue. As many of the people who testified today, I served substantial time in the prison system. I had the fortune of being released at the age of 58, and I take that as a blessing because I know many who do not have that opportunity. I know many who have died in prison due to their age due to illnesses. So in my mind, where is the compassion? Why is this exclusion present? Why can't anyone who is suffering from a debilitating disease, who will be subject to die in prison if not released to medical attention, why should he be subject to that or she be subject to that just because of offense that was committed maybe 40, 50 years ago? Where does maturity, rehabilitation, where does the growth and development fit in this? So I see no compassion. And as long as this particular carve out exists, I oppose the bill, and I urge the delegates to vote unfavorably for this particular bill at this time. Thank you.
And thank you. And do we have any questions for this panel? Committee members? Okay. Delegate Conaway.
Thank you, Chair. Thank you, people that came in to testify. To the last gentleman that testified, the one carve out that you're talking about, could you be a little more specific as to what you're talking about?
Oh, the carve out is that it is an exclusion for anyone that's registered or eligible for sex offender registration. In some cases, these crimes were committed 40, 50 years ago. In some cases, these people pose no longer a threat to public safety in that particular area. But just because of the nature of the offense, they are being excluded. And there's no data to support that this is relevant or should be.
I hear you on that. So some of the cases that we're talking about, these people that are on the sexual offenders registry, they have committed crimes against children? Really?
Yes.
And so therefore you feel as though these people should have compassion given to them also. That's what you're saying?
Yes, because I don't believe that all of these crimes are severe as others.
That's fair. You have your right to your belief system. So I thank you very much for testifying.
You're welcome.
Okay, thank you very much. Okay, Delegate Taylor.
Thank you, Madam Chair. To Mr. Kroll, I just want to be clear that I asked the question about the victims to allow the panelists to share the fact that they have talked to some victims, and some victims actually are in support of these folks being released from prison. So I just wanted to make sure that the record was straight, that I am fully supportive of this bill. So that's it, Madam Chair. Thank you.
Okay, and Delegate Muniz.
Thank you, Madam Chair. Mr. Kroll, the last panel told us that people who would be available to pursue this option under this bill would not be able to commit violent crimes in our community. And you testified that there are currently cases where this is happening. And I was wondering if you could expand upon that, because that's very concerning.
Baltimore City has told me about a case in 2022 where a man got 41 years. They told me about a case where someone was charged with hitting someone over the head with a bar stool and someone having sex with a minor. These are 3 incidents from the city that they've given me. I'm just saying those are just 3 incidents.
So those are incidents of people who were out on medical parole and committed crimes.
Yes, that's why I gave Delegate Cardin the page 3, line 27 advantage of changing or to end, and that solves the problem, my opinion.
That would solve the problem.
Yes.
Okay.
It's physical incapability, which is what we're after.
Okay, thank you. Any other questions? Okay, Delegate Kaufman.
Yes, I'm sorry, but Delegate Munoz's question engendered one for me. You talk a lot about how you've been practicing since 1984, Mr. Kroll, and
October 1st, 1984, Delegate Kaufman.
Well, I really appreciate your years of service, because I wasn't even born then. But my question is this: you've cited 3 anecdotes in response to the ranking member's question, which I appreciate. But in the previous panel's testimony, they talked about how the recidivism rate was low, and when somebody's been practicing law as long as you have, you can always find anecdotes to support your position. But I would appreciate it if you would share any data with the committee about high recidivism rate or anything like that beyond anecdotes that
I will survey my assistant state attorneys and find any information I can for you, Delegate.
All
I'll do
right,
that.
thank you, appreciate it.
All right, thank you very much. Any other questions? Yes, I do see another question. Go ahead, Delegate Pastor.
Right, I'm gonna try to find, thank you, Madam Chair, and I'm gonna try to find the question in here somewhere. So help me to understand, I'm struggling trying to get this, find a question here, because there's always the issue of what people have done, the notion of redemption, and is in my brain, there's a certain arrogance that goes with how we process anybody who has been incarcerated from the view of those who have not yet. All of the people who were incarcerated for the first time were walking the streets up until there was something that they did. And there was not that, would you agree that there was not that same angst or fear about them until after the fact? That, would you agree with that? That we tend to walk around in our society, because there might be some fear based on race and
Majority of people, Delegate.
help me. Come on.
I will help you. A majority
Yeah,
of, now understand my background's in criminology. It's my degree from the University of Maryland, 1980. Not much has changed, sadly, since then, about what we think about different people who have served time. But I can tell you this, majority of people that I prosecuted have come back from serving time and are back on the street. And we can't forget that.
Yeah, I'm sorry.
Majority of people that I've prosecuted since 1984 have come back to society and are on the street. Majority.
Doing well.
I haven't heard
Is that
from.
what you're saying?
I hope so.
Okay.
I truly hope so. I want to see people succeed. I do. And the other 641 prosecutors that I represent want to see people do well. People make mistakes. However, we cannot ever forget the victims of crime. Ever. In the back of our mind. And if we have arrogance for people who serve time, shame on us. Shame on us, Delegate. Because, but for the grace of God, many of those people were looking at them that way. They just didn't get caught. I can tell you a bunch of people when I was at the University of Maryland who deserved to get caught. They didn't.
Okay. I've heard several people, maybe not tonight because I wasn't in here, but certainly as I've been working on my bill, who have shown deference, who have shown they have been contrite and have said how they feel about the folks whose lives they might have taken, okay? And have felt poorly about it. But I guess I'm trying to understand, and maybe you can help me because you've been doing this for so long.
You keep reminding me of that.
No, well, you reminded us of that, and I can because I've been doing a lot of things for a long time as well, including being in law enforcement, and have seen a whole lot of people in penitentiaries and whatever, and who've done things when they were young, who I would far rather be around than some of the people who've done none of that or been any of those places. I'm just trying to understand around feeling for the victim, and we should always feel for the victim. Absolutely. We should always feel for the victim. But I really like, you were here, did you come to my hearing? That's
I did.
A question. Okay, so see, that was a question.
I knew there would be a question in there.
Not quite the question on the bill, but.
Well, sort of, because they are connected. And I just find.
Let me help you out a little bit, Delegate.
No, don't help me.
Okay.
Because I don't get it. Because I've also seen folks who can't even look at me since my hearing, because I've seen too many people who have been in the storm and in harm's way. and who do and have had an arrogance about anybody who's come out of the mainstream, and they know they are not going to vote for any of these, but they know, but for the grace of God, would you agree, as you just said,
I just said
that's the
that.
question for this bill, that any one of us could have slipped over the edge, but we still maintain that attitude about others and carry it in the spirit. Isn't that so? You said it, that arrogance. I just needed to get that, just say that. Isn't that so? Ask me if that isn't so. Yes, it is so.
Thank
It is
you
so.
very
Thank
much.
you.
Any other questions from the committee? Okay. Okay, not seeing any. I think that ends the testimony for this bill. And I want to mention, Ms. Berry, you submitted written testimony only. Yes.
There was confusion because I corrected the written testimony, which knocked me out for testifying.
Gotcha.
But we support the bill.
All right, next bill will be HB 404, Delegate Woods. If you will come up, step up to the seat. That's right, and thank you for waiting so long as well. Ready? Ready? All right, hold on for one moment. Let me make sure. Okay. All right, go ahead, Delegate.
Good afternoon, Chair Crutchfield, members of this Judiciary Committee. I'm Delegate Jamila Woods, testifying and requesting your favorable response to HB 404 Law Enforcement Wellness Checks Requirements, entitled Gabriel's Law, named on behalf of my late son, Gabriel Tyrell Woods. I pride myself on learning something new every day. And while I'm aware every lesson is not a pleasant lesson, I've always looked forward to having the courage to navigate lessons learned to improve my life, and if within my capacity, to improve the lives of others. On September 7th, 2021, I learned a very heartbreaking lesson that's changed my life forever. Gabriel suffered from what had become increasingly worse seizures. That morning, he was not answering my text messages or the many phone calls to follow. Normally, if unavailable, he would send a system-generated text message or communicate with me with a custom message informing what time frame he would get back to me. September 7th, 2021, I did not receive a response from my 7:32 m text. I followed up with successive text messages and telephone calls, and by 10:30, I became fearful something was terribly wrong and took the steps to prayerfully negate my suspicions and to intervene if my suspicions were accurate. I contacted my son's employer to confirm whether he showed up for work. They called back shortly later to report he was a no-show, no-call, something he never did, as a relatively new supervisor in a position he worked so hard to achieve and with which he was very proud. Becoming increasingly concerned, suspicions that my son was having a medical emergency, I contacted his apartment complex and asked if they would knock on his door or enter his building, to only find out later they could not do so without law enforcement intervention. I contacted the Richmond, Virginia Police Department requesting a welfare check, and surprisingly learned their protocols do not allow a welfare check, despite concerns for potential life-threatening emergencies from a person who does not reside in the state of Virginia. I was informed I would have to contact my jurisdiction and have them contact Richmond to verify I was a legitimate person making the request, and to inform it was fine to complete this potentially life-threatening welfare check. It should be noted Richmond was willing to complete this request immediately because it was reported to be a potential life-threatening emergency. On telephone, Prince George's County, the calls answered through Homeland Security and articulated concerns my son was having a potential life-threatening emergency and Richmond's request. I was told to file a missing persons report, to which I informed that was not the incident. While waiting, I sent a final text message to my son asking where he was. Shortly afterwards, and hours later, vehicles pulled up to my home. When I was asked what was going on, I reported the concerns that I needed an emergency welfare check. that my son had medical conditions. And I demanded to know why I was being asked the same questions as hours ago, only to be told that their protocol was to see the person making the request in person. During the process of answering the questions previously answered via telephone, I received a FaceTime call from my son's former girlfriend, informing me she was successful getting a welfare check as a Virginia resident, and also of my son's demise. All I asked for was a welfare check. I'd done my homework. I answered the pertinent questions. More importantly, I articulated it was a potential life-threatening emergency, a potential fatality, and yet a simple telephone call was not made. That call could have given my son an opportunity to be here today. It wouldn't have been necessary to pull 2 police vehicles from my county away from other duties to block off my street and inevitably provide the requested information to the out-of-state request. For this reason, I'm asking a favorable response in an effort to assure an urgent and emergent request from a sufficient historian of a person's medical condition does not go unaddressed as a part of Maryland's commitment to leave no one behind, because where a person lives should not determine the nature of the emergency. Thank you.
Thank you so much, Delegate Woods. Okay, go ahead.
Thank you. My name is Mike Shire. Good evening, representing the Maryland State Fraternal Order of Police. Here speaking in support of the amended House Bill 404. When this bill was first introduced, the FOP had some issues with it about how it required our police officers to possibly be pulled away from other emergencies and circumstances. But I had the opportunity to speak with Delegate Woods, and she told me the story that you all heard today, and it defied my belief. It was frankly shameful that she could not get the services that might have saved her son's life. I was frankly mortified that any other agency would not provide this service. So Delegate Woods was very gracious. She heard our concerns about the bill. She understood them. She understands that the intent of this bill is not to pull an officer off of a violent crime scene to check on somebody's well-being, because it's the 8th call we've gotten that day. We do get those calls. Some people use them as nuisance calls. Some people try and use us as police officers to harass others by doing constant well-being checks. That's not what she's trying to address here. She's trying to address those emergent issues that absolutely police officers should be going to as soon as possible. Sometimes there are legitimate life safety concerns. People need help. You would think that this kind of thing would be common sense, but you all work in the General Assembly, so you know that common sense is not always so common. That said, so in that vein, making a statement via law that agencies must respond to these legitimate calls when somebody might need help, or to relay those calls to the appropriate local agency, is simply the right thing to do. And the FOP is proud to support HB 404 with those amendments. Thank you.
Thank you very much. Are there any questions from the committee? Okay, Delegate Williams.
So I just wanted to, one, just thank Delegate Woods for sharing your story. I know we've talked about this on a number of different occasions. I just basically have isn't it so that there has been no one that has signed up unfavorable on this bill or submitted any testimony unfavorable on this bill, because this is a great bill? Isn't that so?
It is so.
Thank you.
Thank you.
All right, any other questions? Oh, Delegate Taylor.
Delegate Woods, again, thank you for sharing your story. I'm just curious, did you get an apology or anything? Because, you know, if they had done the welfare check, possibly your son would be alive today?
I believe so, and no, I did not get an apology.
Thank you. Okay, Delegate Tolles.
I noticed in the testimony that we have a letter of support with amendments from our county executive. Angela also supports. Could you talk about what those amendments would be?
I had not seen that or been made aware of it.
All right, don't worry. It's not going to mess up my decision. I just let me know. that, yeah, it sound like they want any, officer or first responder. I think it sounds like it broadens the scope of anyone that could come, not just a police officer, but it could be a firefighter, it could be a sheriff in our county. You know, it could be someone who's volunteering, a volunteer firefighter, you know, career firefighter. So it looks as if it broadens the scope. It may or may not do that, but we don't care. Still supporting you. I just wanted you to be, just wanted to know if you were aware of those amendments.
So I want to respond that I don't have any objection, as I shared with the firefighter, because in essence, what winded up happening was the fire department who actually knocked down the door, but they were with the police. My concern is that some people say somebody else can do it, and the reality is somebody else can't legally do it, right? It had to have, you know, the approval of the police, and that's where the apartment complex said, we can't use the key to open the door without police intervention. So I just want us to be very clear that it still has to be authority because they had to breach my son's door. And when they came in, they found him, he had had a seizure, he fell and hit his head, and he eventually passed away. And that was from when I started at 10:30 in the morning. They knocked down his door at 6:17 p.m.
Story with your colleagues in Prince George's. So we thank you for that. And I know this bill will save someone else's life, isn't that so? And if I could follow up, Madam Chair, thank you. It will do that because I remember being on the council and hearing, which is, I'm going to explain why you need a police officer as well as a firefighter. But I remember being on the council and a similar situation happened. When they were doing a welfare check, but unfortunately they were doing a welfare check and the man was not aware, so started to shoot. And obviously, as a firefighter, they didn't have, they don't carry guns, and they're not allowed to while they're working. And so, you know, ultimately, you may remember that
It was in my district.
Yeah,
Yes,
that's
ma'am.
right. It was in your
It
district.
was in my district.
Because I represented part of your district on the
Yes.
county council, so it was in your district. But so I'm happy to see if it does do that it broadens that scope so that you won't have a EMT person, you know, individual, or a firefighter, you know, nervous about going in because they're just not sure because of a history of that happening. So again, this bill will save someone else's life, and thank you for having the courage to bring this bill forward.
Thank you.
And isn't that so?
Yes, isn't that so, Madam Chair?
And okay, are there any other committee members with questions? Okay, thank you so much for being so brave today, Delegate Woods, and just sharing with us, okay?
Thank you.
And the officer, thank you for being here. You've been here a long time today.
We're still going
All
all the way
right.
to the end.
So that ends the testimony on that Bill 404. And next up, we have Delegate Pippy and HB 320. All right, Delegate Pippy. Let's see. Do we have Scott Schellenberger here? All right, come on up. And Merritt Williamson?
Yes, Moreau.
Okay. Let's see. All right, we will start with you three. Thank
All
you.
right.
Go ahead.
Thank you, Madam Chair and Judiciary Committee, Delegate Pippy, for the record here in support of HB 320. So I'll just kind of go over what this bill does and what this bill does not do. So last year, obviously, Economic Matters passed a robust bill dealing with the legalization of recreational cannabis. And a component of that bill was related to stops and searches. So what this bill does, it's narrow in scope, and it addresses whether a police officer can pull over a vehicle, moving vehicle, based on the smell of an odor of burnt or unburnt cannabis. And if that instance occurs, what would be admissible as far as evidence? So currently in law, there's 3 categories that an officer would have to abide by. One being, currently, they could not pull over a vehicle based on the odor of burnt or unburnt cannabis. 2, they could not pull over a vehicle on suspicion that cannabis does not exceed the personal amount. And 3, they cannot pull over a vehicle based on the presence of cash or currency in proximity to cannabis. Why I brought that up is that this bill only addresses the burnt or unburnt component. And what we're trying to get at is impaired driving. So this committee, for example, has been very effective at addressing impaired driving as it pertains to alcohol. You know, when I was on this committee, we dealt with Noah's Law and other components dealing with that issue. Obviously, everyone on this committee knows that it is still illegal in Maryland to drive under the influence, whether that's alcohol, drugs, or other impairing items. The second component of this bill is that if an officer pulls over a vehicle, it talks about what components of evidence would be admissible. And again, my concern would be this, is that if an officer pulls over a vehicle, let's say lawfully, for example, and they find a pound of fentanyl, you know, if they find ghost guns, pick a category. These are all categories where this committee has attempted to address to make our state safer. And so what we don't want, at least the intent of the bill, is we don't want a scenario where we're creating loopholes for individuals that wish to do harm in our committee. I understand our community. I understand that you know, some of the opposition is concerned about the disparate impact on certain individuals, and I definitely appreciate and respect that, and hope that we can find some middle ground to where we can continue to address that, ensure that we're not disparately impacting individuals in our community more so than others, but also address the impaired driving component and then the loophole as it pertains to contraband and other dangerous substances. So happy to turn it over to thank you.
Okay, go ahead next.
Good evening to the committee. My name is Moreau Williamson. I'm an assistant state's attorney in Anne Arundel County. I'm representing the Maryland States Attorneys Association today. I've been a prosecutor for 16 years, and I have prosecuted felony narcotics cases for almost 9 of those years. It is in the interest of public safety to pass HB 320. In my experience as a prosecutor, the odor of cannabis in a vehicle can lead to the discovery of firearms and other controlled dangerous substances such as fentanyl. Passing HB 320 would return this important investigative tool to law enforcement and would aid law enforcement in getting these otherwise undetected and deadly items off of our streets. Gun violence, drug addiction, and drug overdoses are an issue not only here in Anne Arundel County, Maryland, but the entire country. This bill would enable law enforcement to prevent crimes and deaths before they happen by getting firearms and dangerous drugs off the street. We have all heard the saying that an ounce of prevention is worth a pound of cure, and this bill is the prevention. For instance, in Montgomery County, since the law changed under Criminal Procedure Section 1211 went into effect, according to recent data in early February in 2023, Montgomery County Police seized 119 guns. At that same point this year, the Montgomery County Police have only seized 69 guns. In addition, the Maryland State Police, who enforce traffic laws in Montgomery County, in 2023, before the laws changed, they sent 21 cases to the state's attorney's office. Since the law changed, as of early February, the most recent data I have, there have been absolutely no cases charged regarding guns because they're not being recovered. Furthermore, it's contrary to the goal of public safety to prohibit law enforcement from stopping a vehicle that clearly smells like cannabis and to let a driver continue driving down the street without law enforcement unable to so much as conduct a traffic stop. I urge you to support HB 320 and give it a favorable report in the interest of public safety. Thank you.
Thank you. And Mr. Schellenberger.
Thank you very much. Scott Schellenberger, State's Attorney for Baltimore County. I do need to correct one thing. It's not 1 ounce of prevention is worth a pound of cure. It's 1.5 ounces, as you all have ruled. 1.5 ounces of prevention is worth a pound of cure. Look, this is a very common sense bill that doesn't go all the way back to where we were, doesn't even go all the way back to alcohol. What it does is it takes a step towards the right direction. And I too, in Baltimore County, and I don't have my numbers, I couldn't get all my numbers in front of me, but the number of guns seized out of motor vehicles since this bill passed, 1071 has gone down dramatically. The simple fact is that unfortunately, people who have a number of drugs in their car also tend to have guns. And so we believe that by making this baby step forward, allowing us to at least come close to treating cannabis, marijuana, like alcohol makes a great deal of sense. It makes absolutely no sense that the Fourth Amendment rules everything that police do when it comes to searches, except for one time period, and that's with regard to cannabis here in the state of Maryland. It can be treated just like alcohol, which is a legal substance, and there are rules about which the police must follow in order to properly get that evidence into court. I think HB 320 is a common sense approach, and I would urge a favorable report.
Okay, thank you. And are there questions? I see Delegate Boucher. Go ahead.
Merci beaucoup, Madam Chair. I'll set this up. Before I was sworn in office, I met with the administrative judge of Carroll County. His biggest concern was how to prosecute cannabis while driving. If we pull people over for the smell of cannabis, how do we determine that they're under the influence to prosecute them if there's nothing in place now, or is there something forthcoming?
So there's a thing called a DRE, a drug recognition expert. There are certain police officers who are specially trained to develop certain tests and give certain tests that might help you find out if you're under the influence of something other than alcohol. We can tell you that we've seen a great increase in cases where a person is driving erratically, they're pulled over, there's a smell of marijuana, and you take them back to the precinct, you read them the DR-15, and they take a breathalyzer and they blow 0.00. So now the question becomes, can you still win that case with them driving because they're under the influence of something? The problem is, as we all know, there is no test that can test for marijuana. I tell all the young people I talk to when I go to schools and speak, if you go out there and invent this test, you're going to be the richest person in the United States. The problem is they won't be able to invent a test because marijuana stays in your system longer than it's affecting you. So you could smoke on Thursday, get pulled over on Saturday. If you did the test, a blood test, it would still be in your system, but you would not necessarily, probably not at all, be affected by it. So it's a very difficult area of the law, which is why it makes sense that we have the ability to at least look inside the car where they have the reach. And it's what we used to always call the lunge, reach, and grasp. It's the inside of the car, can't go in the trunk, can't go in any other places, but it allows them to search in those areas for that. So yeah, we are seeing an increasing number of cases where a person is acting under the influence. And there's a thing called a nystagmus test. You do a thing where you move the flashlight or the finger, and if your eye is wiggling at a certain point, and I know one of the officers in here can probably do this much better than I can, but if your eye's wiggling at a certain point, it can be evidence that you're under the influence of something, but not necessarily know what it is.
May follow up. Now that we have legalized marijuana, law enforcement officers don't smell a lot more marijuana. So we're going to be pulling people over and all they have is the smell of marijuana and we have no way to test them, to prosecute them. I'm just wondering if we're going to wind up with more people pulled over who are innocent that don't carry guns, don't carry narcotics, but they say they were at a party, smoke marijuana, but the smell is on them and they drive, and then we can't prosecute them, but we're going to be pulling them over.
So that is the minuscule distinction in this law. If you look at page 2, line 6B, a law enforcement officer may not initiate a stop or search of the motor vehicle based solely on one or more of the following: the possession or suspicion of possession of cannabis that does not exceed the personal use amounts. So that would be 1.5 ounces, or the presence of cash and currency. So you cannot do it solely based on that. So you have to have what I believe are the observations to continue with what you're trying to do.
Thank you, Mr. Schulberg.
All right, let's go ahead. Delegate Conaway, you're next.
Thank you, Chair. Thank you, panel, for coming in to testify. So if the person that you pull over, Mr. Schellenberg, if the person you pull over says that they had consumed cannabis and they closed their door and locked their door and they said that they'll take your field test or whatever, can they refuse to have their vehicle searched by you?
Well, it depends on how much evidence you have. Were they driving erratically?
Sure, of course, that's what you just said.
Okay.
Yeah, that's your reason for your stop, right? Not just because you smell cannabis, but you're gonna use something else, right?
Well, if they're driving erratically and you smell the odor of cannabis, I believe that amounts to probable cause to continue the investigation. So yes, you could probably get them out of the car.
You confuse me because do you mean you smell cannabis after you stop them for driving erratically, or you smell cannabis while they're driving?
You stop them after, because it says.
You stop them after you smell the cannabis?
No, so you stop them for another traffic offense.
Right.
And then when you get to the car, you smell cannabis.
Okay.
And if they shut it down, I think that's probable cause to be concerned, more likely than not, that they are driving under the influence, and you would have a right to pursue the rest of the investigation.
So if they tell you, so you want rather for the person to tell you, I don't want to talk to you or something, and then you just do your own thing.
Well, they absolutely have a right to not talk to you. I mean, that always.
So would you have the right to still search?
You would have a right to get them out of the car and continue your investigation.
Would they have the right to get out the car and lock their car?
They would, but you could still complete your
I'm
investigation.
trying to get to the bottom of this cat and mouse game. I mean, you know, respectfully, you're talking about stopping people and they drove recklessly. There you spell cannabis. But the reason why we got here is because a disproportionate amount of people were being stopped for cannabis stops, or just by the way we stopped you and we smell cannabis, now can we check your vehicle? So we're very unclear as to what your motives are as to why you want to initiate this again.
Well, the motive is that you want the roads to be safe.
Sure.
And people who are under the influence of cannabis might not make those roads safe. And this allows for a little bit more collection of evidence to try and make the roads safe.
Okay, so I was just trying to get to the point where you make the determination that you believe there's enough cannabis in the vehicle to check the vehicle to say, you know, you have too much cannabis in the vehicle versus you're under the influence.
So if I may, I don't know if this is helpful. So this is why this is kind of a tricky issue, right? So the fiscal note's actually pretty good on this bill.
Well,
And I'm
the
not.
tricky issue is because previous years, we found that there seemed to be one group of people were treated differently than another group of people.
Sure.
Is that right?
No, I mean, I've read
You would agree with that, right?
Do I
The
agree?
disparate treatment, the difference in treatment.
Yeah, no, and that's why I said that in my intro,
Yes,
right?
sir.
I mean, we have to acknowledge that. There's actually a disparate impact note in the file as well in this bill. So I think it goes without question that we have to acknowledge that. And I think, I think probably the right decision is to try to figure out a way to address that and also address the public safety concerns that I have in my eyes, right? If we could somehow figure out a way to address both of those things. So the challenge we have is that if you look at the end of the fiscal note, I mean, driving under the influence of even cannabis today is a criminal offense. You know what I mean? I mean, there's all these lists. I mean, they treat that no differently than a DUI. Matter of fact, a passenger is not legally allowed to smoke cannabis in a vehicle while it's moving. That's also current law. And so what we have is a situation, right? The situation is, all right, we want to figure out a way to ensure that people are not using cannabis while driving or using cannabis immediately for getting in their vehicle and driving. The problem we have is we have testing issues, as Delegate Boucher mentioned, because the tests don't, unlike a breathalyzer, gives you a BAC. It can kind of tell you if you're under the influence within a reasonable amount of certainty immediately. Cannabis, we don't have that. So now we're left with a situation where it's difficult to test. And I think there's a rational argument that somebody in theory could smell like cannabis and possibly be not under the influence. And so what this bill has attempted to do is attempted to find like as Mr. Schellenberg said, a step in which, you know, maybe an officer has a way to conduct an investigation, because the current law as written last year that passed is that there's really nowhere for them to go at all. Because what ends up happening is even if you have an individual that is likely under the influence, impaired, transporting contraband, in most cases, the officer can do nothing with this individual. I mean, it's just like a blanket get out of jail free card. And I hate to use that word because I, you know, associated with young people, but what I'm trying to find is a compromise between whether an officer who's narrowly allowed, for example, in bold in the bill, an officer cannot pull over somebody if they think the person just has a personal amount, cannot pull over them if they have cash. I mean, there are certain things they can't do, but
how are they going to think that a person,
but
how do you identify a vehicle
smoke.
that has a
So here's the good
personal amount?
You know the expression where you see smoke, there's fire?
No, I don't know that. I don't know that. We don't
Okay.
use that in my.
You use that in judiciary?
No, we don't use that in my environment, my
Okay.
personal environment.
Fair enough.
What I'm talking about, how you can find that there's more African-American people that's been charged with having cannabis in the past, and you don't want to bring it up now.
I miss being on committee with you. by
Well,
the
well,
way.
I'll come talk to you personally if you
Good,
need to talk
good.
to me.
All right. So here's my response to that. Here's my response to that. And it goes back to, of the three prongs at the beginning of my testimony, only one was changed. And that was dealing with the odor of burnt and unburnt cannabis. And the reason it's worded that way is so that in the event where an officer observes smoke coming out of a vehicle, that might be a reasonable inquiry as to whether the driver is operating a vehicle under the influence of cannabis. So that would permit the officer to make a stop. And then in that stop, we talked about different tests. You know, for example, if you roll up on a car now for whatever, a lights out, the officer rolls up and smells alcohol, that right there is indication enough for the officer to say, hey, I smell alcohol. Have you been drinking? Would you mind stepping out of the vehicle and conducting a test, whether it's like a field test that doesn't involve the mechanics or the machines, but that starts the process. I'm not saying it's apples to apples, but the point is that might be a fair, reasonable, rational indicator that somebody is operating the vehicle under the influence. That's the heart of this whole thing. And by the way, if it happens that an officer conducting a reasonable, rational test among a vehicle that is operating under the influence happens to have 2 pounds of fentanyl in the back seat, you're damn right. I want that fentanyl and I want that guy to go to jail because that's doing a lot of damage in our community. If the officer is transporting human trafficking victims, you're damn right. If the driver has ghost guns in the vehicle, which this committee has worked very hard to get rid of, we want to address that too. So I don't want to carve out an exception for people that happen to be using cannabis while driving. This whole thing is not about the contraband and then the taking Fourth Amendment rights away. What it's about is criminals are savvy in most cases. I'll tell you what, if I was going to transport drugs or guns through Maryland, I'd light up a joint and do it. You know why? Because my chances of actually them convicting me on all that other stuff would be very slim if I could argue that there's cannabis involved. And so I don't want to carve out exceptions for people that are doing harm in our community. But the last thing I'm going to say, Delegate, to your point is we do need to acknowledge and address the disparity that it's having in the community around the state. You're absolutely correct. And if there is an improvement to this that we can do that, I'm all ears. If there's a 50-50, if there's anything that you have that can make this workable to address that, I'm all in. I'm all in.
And one more thing that's very interesting when it comes to marijuana and cars. If I'm driving my buddies down to the Maryland game on a Saturday and they're in the back seat drinking alcohol, I'm not getting drunk. But if I'm driving my buddies down to the Maryland game and they're in the back seat smoking marijuana, I can be affected. And so that's why some of this odor is so important, because it could affect my driving, even though I'm not actually doing it.
I respectfully agree with you, because you could be sitting in your car by yourself and somebody else's car comes by you, and next thing you know, you're just sitting there at the green light. So.
And just so you know, that was a complete hypothetical about myself.
Thank you, sir.
Hey, hang on.
Thank you very much. All right, Delegate Grammer, you're next.
Thank you so much, Madam Chair. I have a more brief question. So this is the bill that passed out of the Silver Room last year at the last minute. People knew there were problems with it. A lot of people didn't know what was
Oh,
in
we don't
it.
want to bring that up again.
Yeah. So there are two parts to this bill. One governs the when a search is permissible. The other is what was inserted in the bill at the last minute, which is the exclusionary rule was ripped out last year. And this portion about complete, frankly, with the evidence that would be discovered would have been completely inadmissible. To what degree is the rules governing the search, is that causing your issues, for example, finding illegal guns? And to what degree is the portion of the inadmissibility of the evidence?
And I'll chime in and then maybe Scott can correct me on the record here. So I think the way it's written now is nothing's admissible. Right. So you have a scenario, even if the police officer did everything right and they find horrible things, and I'm not talking about weed, other things, horrible things, and none of it's admissible. And that's a terrifying situation, because there's a lot of things in this state that I think everybody in this room would agree that we got to get off the streets, we got to address, we got to take care of. And the way the bill's written is that none of it's admissible. Right. And that's a tough pill to swallow, because people take advantage of that. You know, there are sophisticated people that are operating in illegal activities that know this law and will use this to their advantage. And that's what I want to go after. I don't want to go after our young people that are, you know, young and doing their own thing. That's not who this is going after. It's going after those people. And that's why this portion of the bill is addressed, to your point.
And I would chime in regarding the consent portion that this seeks to remove. Consent's a very important law enforcement tool of the United States Supreme Court. The Maryland state courts have all acknowledged the important role that consent plays as an investigative tool. Now we have body camera. We don't have to worry about who said what. You know, is what the officer wrote what really happened, because we can all see it in court. When I have a consent case in court, really my lawyering skills go out the window, because I just push play and we all just watch what happened, and then the judge makes a decision based off of that. So any concern in terms of, was this person coerced? Were they separated from their friends? You know, how many police officers were hovering around them, are completely out the window, because we can all see what happened.
Let me ask this a more brief way. If we were to just strike the search portion of this bill and this bill became strictly the evidentiary portion, would that fix your problem?
So what,
allowing evidence admissibility when consensual searches?
I think the search part would also have to be struck.
Okay, thank you.
Unless you have a
other.
I will tell you, bill drafting is
Okay, so you wanted to.
No, I don't know. I'd have to look at it, because I tell you what, the way they draft, no disrespect, because they work hard, but the way bills are drafted, I mean, I spend like hours trying to understand how they drafted what I'm trying to, you know, but I'll look at that, Delegate, and I appreciate the suggestion.
Okay, I think Delegate Phillips is next.
Thank you, Madam Chair. I just want to make sure I'm thinking this one through. If a police officer pulls up beside a car and the driver is smoking, and it appears that they're smoking marijuana, will that officer be able to pull over that vehicle?
If it's the smell, it addresses the smell.
No, not if it's smell, but they see the smoking of marijuana.
under the current law, no. Because on criminal section 10-125, it says you may not use you can't smoke in your vehicle, but it says it may not be used as a reason for a traffic stop under the motor vehicle law. So unless there's.
No. I don't believe that's what it says. So if you see a passenger smoking in the backseat of the vehicle.
No.
I think
Under my understanding of criminal law section 10-125.
I think that's incorrect, but it's okay. So we know that smoking in a vehicle and driving is illegal. Is that true?
Yes.
Okay. Passenger smoking in a vehicle and driving is illegal. Is that true?
Correct.
So the idea of smoking in a vehicle is actionable by a police officer if they observe. If an officer sees a person with a can of beer and they're tugging it back, can they stop that vehicle?
So, and Mr. Schellenberger may have a different under my understanding of criminal law, 10-125, there's a section in there that says this may not be used as a basis to stop a motor vehicle on. I think someone might be looking it up right now.
That's fine. So the challenge that I have with this is there is a lot of presumption on the basis of a law enforcement officer that gives a whole lot of leeway to make a stop and also to then search the vehicle. And I understand what Delegate Pippy is attempting to do. This just leaves too much judgment to the officer, in my estimation. Isn't that so?
Actually, no, it's not. It's what we do every day with regard to the Fourth Amendment. We have Fourth Amendment rules on what searches are allowed and what aren't, and we teach the officers those rules. And if they violate them, then it gets stricken and it can't be put into evidence. And, you know, we have a perfect example of a legal substance that have rules for how you deal with it, and that's alcohol. And what I'm saying, and I said last year, was why don't we go back? Why don't we stay where we are and let the Fourth Amendment tell us what it is? But this is the one place, the one and only place where the Maryland General Assembly says Fourth Amendment's not good enough. We're going to write a law. And what I'm saying is that law has been hurting us. We're not going completely backwards. We're taking a few steps to give officers a little bit more leeway. That's the difference.
Okay, thank you very much. So I have a couple of questions as well. Getting back to Delegate Phillips, so one of the things I wanted to just ask is, what is your understanding about public consumption of marijuana right now?
Talking to me.
My apologies.
I'm sorry.
Assistant State's Attorney Williamson.
I'm sorry.
Yes.
Can you repeat your question, please?
So my question is, right now with recreational cannabis,
Right.
what is your understanding of public consumption? For example, someone sitting in their vehicle with a joint.
Right. That is prohibited.
Correct.
Yes.
Okay, thank you.
Sure.
Now, the other question I have, which probably both you and Mr. Schellenberger could possibly answer for me, is, are there other ways to stop an impaired driver regardless of what they may have? Just an impaired driver. How do you stop an impaired driver?
So currently, the police officer would observe driving that is unsafe. So whether it be speeding, swerving, failure to stop at a stoplight, a stop sign, something like that.
And under the present cannabis laws, can you do so? Can you stop an impaired driver?
Yes.
Period.
Yes.
Okay. All right. And so do you feel that, let me just go back for a second.
But you can stop the driver.
Yes.
But you can't do the investigation based on the way the law is written now.
And why not?
Because you told us we couldn't. It says the odor of, the odor of cannabis.
No, what you can do, okay, and I just want this to be clear, is that you can stop an impaired driver. Okay?
An impaired
An
driver.
impaired driver.
Correct.
Okay? And then if you see more than the odor, okay, of cannabis, all right, then you can proceed. Right?
You would need to see more, but
That
the
is
law
correct.
right now says a law enforcement officer may not initiate a stop or a search of a motor vehicle, motor vehicle, vessel.
Or
Based solely on one or more of the
Correct.
following: odor, possession, presence of cash occurrence.
That is correct, but you can stop, as you mentioned earlier, right? A vehicle, an impaired driver, correct?
Yes.
Okay.
It would be nice.
And as you approach and see other things, then yes, you may proceed.
Yes, it would be nice though for the police to have the ability to smell.
But as we just said, you can still proceed for that impaired driver, correct?
If they observe the impaired driving.
That is correct.
Right.
And that's how you will get to the impaired driver in the first place, more than likely. Is that correct?
If they observe those items, but if they also.
That's correct,
We're able to,
right?
yes, we're able.
Okay, so normally with a stop, it doesn't mean that you have rolled up and you just smell cannabis. Is that correct? It's usually because of some reason that you see a driver driving in erratic behavior, or as you said, speeding or something else that gets you to the vehicle. Is that correct?
Or it could be that, or it could be a combination of an odor and the driving.
Okay, but it could be a combination of things, correct? But usually it is the initial observance of the erratic driving, the speeding, something that gets you to the stop. That's what I'm going for.
Right, I can't speak for the
correct?
police in terms of what their first impression is, whether
Okay.
it's the odor
Okay.
or
But
observing. driving.
usually that's what you've probably encountered. Is that correct? With a stop.
So, again, I can't speak for the police in terms of what they notice, the odor or the driving. If they could see just the driving.
Well, you just
the
said it
odor.
earlier, that usually it is the erratic driving,
Well,
the speeding, et cetera.
Without,
So is it or is it not?
that's without the odor taken into account. It would be
That's
nice.
correct. That is correct. And that is my question. Even now, you can stop a driver, correct? For erratic driving, speeding, whatever, to get to the vehicle to stop it, correct?
Yes.
Okay,
the
thank you. That's
Yeah.
all I need.
But if you're sitting at a stoplight and you smell that odor wafting out of the car, and that's all, then you can't,
That is correct.
okay?
But if you see the individual smoking, okay, you might be able to do something further, okay? So anyway, that's my question. Sorry, I will go on to, Delegate Carton.
Thank you, Madam Chair. I just want to follow up on that one question. So you either pull up next to somebody or you pull somebody over for, as the chair said, impaired driving. But you don't have anything, you see smoke. You see smoke like you were talking about. Is that enough to then go to the next step? Not smell, I'm not talking about smelling, I'm talking about seeing smoke. Are you able to do anything?
I don't think so.
Okay, fine, you're not. They roll down the window, the smoke's coming out and it smells like marijuana. Now, can you do anything? You've pulled them over for erratic driving or for some violation or some potential violation. You've now seen smoke come out. So clearly somebody was smoking in the car. It's not just aroma, and it's the aroma of marijuana. Why can't you then initiate the search? You've now got, that somebody was smoking, and according to 10-125, anybody in the passenger area is not permitted to be smoking cannabis or using cannabis.
And
That's what the law says.
criminal procedure 1-11 says, a law enforcement officer may not initiate a stop or a search of a motor vehicle based solely on one of the following events: the odor of burnt or unburnt cannabis.
But we're not talking about the odor. First of all, this is not, we didn't have the odor until they rolled the window down. Right? So you have the smoke.
So you're saying that
So you-
it makes sense in Maryland that if you smell the odor of burnt
No.
cannabis, you can't do anything, but if you see smoke, you can. I don't
You see this because the difference is that the question is whether somebody was smoking in the car or whether the smoke, the aroma of it came with them into the car. I have clients that come into my office. Clearly they were smoking previously, but they're not smoking now. And the entire office smells after they leave. The entire office smells. So that's not what we're talking about. We're talking about them actually smoking in the car, which is illegal. It's in the code. You can't smoke in the car. So the question is, why can't you then commence at that point? You see smoke, you smell smoke, you've pulled them over for another reason. You got three different things going on there.
But the key element is that other reason. That's the one we keep coming back to.
You've already pulled them over for something.
I understand, but they've crossed over the double yellow line. Any of those things.
Yeah, they got too close to the car next to them, swerving a little bit. I'm just, okay, thanks, I'm sorry.
Okay, thank you. Go ahead, Delegate Eric. And I know you've been waiting. Thank you for waiting patiently.
Thank you, Madam Chair. It's fine. I feel like reminds me of gun bills where like everyone's trying to pass policy, but no one in here's ever hotboxed a car before when they were a kid. So here's the problem. The law as it stands is unenforceable because people can smoke cigarettes in their cars. It's going to fill the car up with smoke. You open a window, it doesn't matter what it smells like because we specifically said it doesn't matter. So it doesn't matter if the whole car is filled with smoke. It could be anything. It could be one of those little, jewels or those little smelly incense things. Who freaking knows what it is? So it's not enforceable. It doesn't matter. It doesn't matter that we have this on the books, that it's a crime. You could see somebody smoking a joint. It could be a hand-rolled cigarette. You don't have probable cause. I'm sorry, you just don't. So it's, even if it's written, it's totally absurd and it's ineffective. So that's like, problem number one. Problem number two, I'm driving down the highway constantly, back and forth to this glorious place. Every time I'm in the flipping tunnel, it reeks of pot. It reeks of pot every time I'm in the tunnel. And I'm getting stuck in traffic with these whack jobs who are smoking in the freaking tunnel. So this is an actual problem. And I don't want you guys to wait until somebody's swerving out of the lane. I want a cop in the tunnel with me to go, who's hotboxing in the freaking tunnel? It will be a problem. It may not be a problem now, but it will be a problem. So anyways, I think there's a way to fix this bill to address some of the concerns. But as it stands, all of the existing laws that we should be able to use are clearly not being used because it's happening constantly. I'm around it all the time now. And it wasn't like that 2 years ago. So anyways, isn't that so?
Yes, it is.
Okay, are there any other questions for this panel? Okay, seeing none, let's go ahead and call up the next panel of unfavorables. And we'll start with Robert Landau, if he's present. Yannette Emmanuel. I think that's it. Okay. Nishana Cass. And Mr. Gallagher, if he's here. Or Miss. Okay, sorry, my apologies, Miss Gallagher. Okay, go ahead.
Good evening. For the record, my name is Yannette Emmanuel, Public Policy Director for the ACLU of Maryland, here in opposition to HB 320. First, I'd like to thank this committee, especially the Legislative Black Caucus and you, Delegate Crutchfield, for passing this bill last session and recognizing Black people's humanity. What HB 1071 did last year is prohibit police from conducting warrantless stops and searches solely based on the alleged odor of a now legal substance. The proponents of HB 320 have said that banning odor vehicle searches will impede law enforcement's ability to investigate incidents of impaired driving. But just as we've discussed, that's simply not true. The law makes it explicit that the odor of marijuana can be considered as part of the totality of circumstances to support the officer's observations of suspected impairment. The odor of marijuana simply cannot be the sole basis of a stop to investigate driving under the influence. And the reason why is that the odor of marijuana alone does not indicate that someone is an impaired driver. Opponents of the current law have also said the law must be repealed because law enforcement relies on cannabis odor as a justification for searching vehicles and seizing guns. That is simply ridiculous because, as previously stated, the simple odor of marijuana does not indicate whether or not someone is in possession of an illegal firearm. But what the police do use is alleged odor of marijuana to justify racial profiling. Furthermore, police and state's attorneys do not actually have any real data to support their claims. And we know this because we've actually filed a public information request for their alleged data on gun seizures obtained through odor searches, and their offices have reported that they do not track this data. Lastly, public safety is the utmost importance for all of our communities, but diligent law enforcement can and should solve a crime using honest evidence-based techniques without relying on pretextual bases like the odor of marijuana for stopping and searching Black and brown people. And so for all those reasons, we urge an unfavorable report on HB 320. Thank you.
Thank you. And next, Ms. Cass.
Good evening. My name is Flannery Gallagher. I'm a legal fellow at the University of Baltimore School of Law Center for Criminal Justice Reform. We are grateful for this opportunity to testify in strong opposition to House Bill 320. House Bill 320 would result in a return to high discretion, low suspicion, warrantless stops that are ripe for abuse and racial profiling. The General Assembly got it right last year when it passed House Bill 1071. Less than 8 months have passed since current law took effect. No rigorous, compelling statistical evidence or scholarship supports this body reversing itself. What this body knew then remains true. A national study analyzing over 100 million vehicle stops found that Black drivers are disproportionately stopped and searched by law enforcement compared to white drivers, despite evidence that white drivers are more likely to be found with contraband. Under current law, Maryland law enforcement officers are not prohibited from considering cannabis as part of the totality of the circumstances supporting a basis for a vehicle stop or search. Current law merely provides that cannabis odor may not be the only basis for a vehicle stop. Under current law, the scent of cannabis paired with erratic driving, you can stop that vehicle, you may be able to search it. The smell of cannabis paired with smoke emanating from the car, you can stop that vehicle, you can probably search it, and you may well be able to arrest that person. The smell of cannabis and the observation of someone smoking a joint in the car, you can stop that vehicle, you can search it, and you can arrest at least one individual in that car. Instead, House Bill 320 would allow an officer who smells the scent of cannabis, a smell that is ubiquitous in our communities, at a stoplight where dozens of cars are idling, to assign that scent to a driver who the officer may want to search for any number of impermissible and unconstitutional reasons. We urge an unfavorable report.
Thank you very much. And Ms. Katz?
Thank you. Good evening, Madam Chair and members of the committee. My name is Nashana Kess, the Executive Director of the Maryland NAACP. And I don't want to repeat some of the points that the other panelists have stated, because they're correct and right on point with how House Bill 320 will substantially negatively impact communities of color. But some of the points I wanted to make was just to emphasize how important or how much this would affect a person for being stopped just simply because of the odor of the cannabis, and given that reason to search your person or your belongings. This means that law enforcement will have the authority to just say they believe they smell something. Can you imagine such a system, right, where someone could just stop you because you look suspicious? Of course, we've been in that system before and it hasn't worked. It will not work. It cannot continue to be something that we live in, or a community that we live in today. Have you ever been in a cigar shop? I've been in a cigar shop. And in that cigar shop, you leave out of there and your hair smells, your coat smells, everything smells, right? And so what we're saying is a police officer will have the opportunity to stop someone just simply because of the smell, even though that smell not even be from them. It may be because they were in a space where someone else was engaging in that type of activity. So we're saying that they should be stopped and frisked because of a smell that they may not have caused, right? And so I don't think that that's a community that we want to live in. So instead of repealing these critical protections, we urge the committee to explore alternative solutions that address the root cause of racial disparities in law enforcement encounters. This may include implementing stricter guidelines for law enforcement conduct, increasing transparency and accountability measures, and investing in community policing initiatives that foster trust and collaboration with the community. Thank you. I urge an unfavorable report.
Okay, thank you. And Ms. Holmes, you may go ahead and testify.
Thank you, Delegate Crutchfield and Vice Chair, Chair, members of the committee. Thank you for this opportunity to speak here today. I think most of what I wanted to say has already been said, but I'm here, Tia Holmes, on behalf of the public defender, strongly opposing House Bill 320. This bill will return us to the decades-old arbitrary policing practice that subjected Black people disproportionately to racial profiling. Now, I wanted to address some issues before the discussion started today, but I'll focus on the issues that I think are integral to the work that I do as a public defender. The first is to address how officers come into contact with people to even use the justification for the odor of marijuana. Let's talk about RIN stops. We talk about pretextual stops all the time, but I noticed that the state's attorney wanted to dance around the issue of how they come into contact with these people. So the two were married for years, and this committee said, wait, we got to offer people protection because we knew that Black people were being stopped and we knew that this law was being enforced against them. What did that do? It re-exposed them to violence. And so this body said that that's not good. We have to do better for Black people, and we thank you for that change. And the other thing that I want to address is the exclusionary rule that was discussed a little bit. So the exclusionary rule provided in subsection C of the statute must remain, because without it, there would be no way to enforce the law. Maryland courts have made it clear that when this legislature does not provide a suppression remedy in the statute, the court will not read one into the statute on people's behalf. So accordingly, officers would return back to violating people's rights, and there would be no repercussions for those actions. And for those reasons, and those provided in my written testimony, the Office of the Public Defender strongly urges an unfavorable report on this bill. Thank you.
Thank you very much. And does the committee have any questions for this panel? All right, I don't see any. All right, thank you very much. And that ends the testimony on this bill.
Okay, now we're going to go ahead and have, well, is Delegate Phillips around? There he is. Delegate Phillips, we're ready for you. House Bill 1081. Yes. I know. If they're still here. All right, and do we have Brian Carney? Okay. So we have Drew Vetter and Kevin Kane? Yes, yes?
Yes.
Okay.
Yes, yes. All right, good evening, everyone. I'm going to try to make this relatively brief. Good evening, Scott Phillips, representing District 10 and a member of this wonderful Judiciary Committee. Thank you. House Bill 1081 really is somewhat of a, what I would call an administrative adjustment to a way that we do business today in law enforcement as it relates to license plate readers. It's a tech bill in many respects. Currently, the Maryland Coordination and Analysis Center houses license plate reader operations information on a server. Now, many of us know that in today's world, most data is maintained in the cloud. And so there are a number of organizations who've placed data in the cloud, technology that places data in the cloud with license plate readers. But the way the law is today, that the data can only be placed on a server physically located within the operations center. And so basically all this bill will do will be allow the technology to be used and the data to be stored in the cloud. And I will rely on my my witnesses to provide more information about why that is important and why this committee should consider passing House Bill 1081 favorably. And I'll be glad to take questions after they have explained the technology. Thank you.
Good evening. My name is Kevin Kane, and I'm the Director of Government Affairs at Flock Safety, one of the nation's leading providers of automated license plate readers known as ALPRs. And I'm here to express our strong support for House Bill 1081. House Bill 1081 accomplishes two primary objectives. First, this bill is enabling legislation that would permit providers of ALPR devices who use cloud data storage like Flock Safety to operate in Maryland and interface with the Maryland Coordination and Analysis Center known as MCAC. Second, the bill strengthens the existing ALPR statute with additional privacy and security protections. Under the current interpretation of the existing statute, law enforcement agencies are prevented from sharing data with MCAC through any ALPR system that uses cloud storage. It's important to note that the underlying statute was enacted in 2014 before the widespread adoption of cloud-based computing by both public and private sector. To be clear, Flock Safety is not the only vendor who uses cloud-based data storage. Furthermore, this legislation does not favor any ALPR vendor, nor does it mandate that MCAC or any law enforcement agency change whichever ALPR system they currently use. I also want to briefly mention two areas of the bill that strengthen existing privacy protection. First, the bill clarifies that automated license plate data captured in accordance with this section is a property of the law enforcement agency. This provision makes it clear that the law enforcement agency alone owns the data, not the vendor. Second, the bill states that ALPR data may not be sold for any purpose. Flock does not sell data, nor, and we're not aware that this has ever been practiced by any ALPR vendor in Maryland, but we just want to make sure that that's clear in the statute. If this legislation were passed, law enforcement would have the option to use Flock Safety or any ALPR vendor who uses cloud-based data storage to help address public safety needs for Maryland citizens. Thank you, and I urge a favorable report of the bill.
And good evening, Madam Chair, members of the committee. Drew Vetter with Schwartz, Metz, Wise, and Kaufman here on behalf of Flock Safety. I wanted to speak to some of the amendments that may be in your package for this bill. You've heard us talk about MCAC, which is the Maryland Coordination and Analysis Center with the Department of State Police. Currently, that's where all of this ALPR data is housed. So we had a number of conversations with MCAC to make sure that they were okay with the provisions of this bill. We had very productive conversations, and we have a number of additions to the bill that we arrived at with them that really serve to strengthen the data security and privacy protections. The original version of the bill made it clear that the law enforcement agency owns the data and then they may not sell it for any purpose. But the amended version of the bill that you will see adds additional protections, clarifies that the data can't be sold in the subscription or license form, states that the data cannot be accessed by a vendor unless expressly authorized by the law enforcement agency, and prohibits the uploading of that data to federal or state agencies that are external to the state of Maryland. It also adds to the list of procedures that law enforcement agencies must have in their policies that PII must be protected and criminal justice information must be protected, and makes it clear that with this change, all of the existing auditing and reporting requirements that exist in the current LPR statute must continue to be followed. So given those amendments, we've got a letter of information from the Department of State Police that confirms their agreement with those amendments. There's a letter of support from the Chiefs and Sheriffs Association as well. With that, we urge a favorable report. Thank you.
Good evening, Madam Chair and distinguished committee members. My name is Lieutenant Brian Carney here on behalf of the Anne Arundel County Police and the Maryland Chiefs of Police and Sheriffs Association. We support House Bill 1081 with amendments which will alter current law provisions governing automatic license plate readers, also known as LPR. The purpose of the bill is to modernize the storage of LPR data while adding additional privacy safeguards. HB 1081 grants the flexibility to store historical data on cloud-based solutions in addition to on-premise solutions which are used today. The transition to more advanced contemporary cloud-based LPR storage systems not only enhances operational efficiency, but it also aligns with modern LPR technology trends within public safety. We believe the integration of cloud storage into LPR offers benefits such as increased options, access to advanced technologies, improved tools for real-time crime centers, and cost savings. Cloud platforms also provide scalability and accessibility, allowing agencies to select solutions tailored to their needs and budget constraints, fostering innovation and efficiency. As with any modernization of technology, there needs to be additional safeguards for data protection. HB 1081 accomplishes this by affirming law enforcement's ownership of cloud-based historical data and prohibiting its sale and transfer to external entities by either law enforcement or vendors. Additionally, penalties, operational procedures, and auditing requirements extend to vendors to assure data integrity. This bill does not change current use of LPR, which provides real-time alerts for legitimate law enforcement purposes to include stolen cars, the search for missing persons, and mitigating public safety threats. The International Association of Chiefs of Police cites studies showing cars are involved in 75% of crimes committed every year in the US. LPR is a necessary crime-fighting tool used in these investigations. Evolving with technology and adding privacy safeguards will contribute to the well-being of our communities. For these reasons, we ask favorable report.
Thank you. Delegate Phillips, have you already sent in the amendments or?
Yes, and I'm sorry, because I thought they were sent around to, sent to the judiciary and sent to the members, but I have the amendment in front of me and it should have been on the floor system.
Well, we can't, we can't pull it up on the floor system. They always say that, but I think it's only until it goes to the floor.
Okay,
So if you could provide us with the
sure.
amendments.
I have the amendments and I'll ask the staff to.
Okay, do you want to describe it for us?
Actually, Mr. Vetter described them fairly well.
Did you?
So
He actually did. If you want to go back over them.
Yes, I'm happy to describe
That was
them
the question.
better this time. So the amendments are the result of conversations that we had with the Department of State Police and specifically the staff at MCAC. And it was to address any concerns about data security and privacy and auditing and reporting requirements if we enabled this change to allow cloud storage to be used in addition to the current way things are stored on physical hard servers at state police. So all the amendments that you'll see really address data security, privacy, and reporting. So the amendments would clarify that a law enforcement agency or a vendor can't sell subscriptions to the LPR data. They can't sell licenses for the data. The original version of the bill said that data can't be sold for any purpose. So it's really just making it clear that the data can't be sold, licensed, subscriptions, et cetera. It would state that the data cannot be accessed by a vendor. So if law enforcement agencies use vendors for this, this amendment states that an employee of the vendor that's providing the LPR solution can't go and access that data. They can't because they don't own it. They don't have the ability to access it. That would only happen under a very sort of narrow, specific circumstance where a member of the law enforcement agency requests that, like a vendor go in and access the data for some reason. And then the current practice of MCAC is that none of the LPR data is shared outside of MCAC, shared outside of Maryland. The current statute is silent on that. So they had suggested another amendment to make it clear that uploading of this data to federal agencies, to state agencies and other states is expressly prohibited. They get those requests currently. They currently deny them. We want to make that clear in the statute. There are also amendments. There's a list of items in the public safety article where like a law enforcement agency's policies and procedures have to cover what must be contained in those policies. And so there are a couple additions to that in the amendments, including procedures to protect personal identifying information and criminal justice information. And it also adds requests made by vendors to the audit requirements under the bill. So the current existing audit requirements say anytime a member of the law enforcement agency queries or accesses the LPR database for any reason, that goes into the audit report that gets sent to this committee, General Assembly, and the governor every year. Mm-hmm. So all of those requests are logged. This would just make it clear that in addition to the law enforcement agency querying the data, if the vendor were to query the data for some reason, that's got to be in the audit report as well. And then finally, there's a requirement to, and this is again, an expansion on an existing requirement. The current requirements are that any data breaches of those servers have to be reported, have to be contained within that report. This would make it clear that that same duty to report a data breach would apply to a vendor as well. So that's essentially what all the amendments do.
Right, thank you very much. Could the evidence be used as exculpatory evidence? Do we know, maybe Mr. Officer Carney?
Madam Co-Chair, can you elaborate a little bit as far as exculpatory evidence? You mean as far as evidence that would be discovered during a criminal investigation?
Yes, and yes, if it would if it would exclude, let's just go with that one. If it would exclude the defendant or somehow exonerate the defendant.
Having the cloud-based storage, I just want to make sure I'm understanding you correctly. Is that correct?
Okay, so and
I
it's
apologize.
okay if we don't know that yet, because I can look at like an evidence section of the law or something, because this is really about the LPR. So that's fine. Okay, thank you very much.
That sounds good. Thanks.
Delegate Arakan.
Thank you, Madam Chair. Thank you guys for being here. So I'm sorry, I forgot your name already.
Mr. Vetter.
Yeah, Drew
Okay.
Vetter. Yep.
Hey, Drew. You'd mentioned that you've already had some 3-letter agencies requesting access. Could you tell me which ones those were?
I would have to defer to the Department of State Police on that. I don't have a specific list.
I'd like to know, and I do appreciate the effort you guys clearly put in with your amendments to try and protect privacy. But I'm just going to tell you a little bit about one of the reasons why the language is described, sort of prohibiting the uploading. I don't know if it's going to cover all of the concerns that I have about protecting this, because what we've seen with Apple and their iOS is that they actually built in to Xcode the ability for some of these friendly agencies to simply access it without having to upload anything at all. So it's essentially a backdoor was built into the code. So is there any assurances in the bill currently to prevent those who are crafting the actual code from building an opening and then letting their buddies know over at our friendly 3-letter agencies how to get in?
Well, this is something that we specifically try to address by clarifying that the law enforcement agency, not the vendor, owns the data. Flock Safety, we don't own any data, period, full stop. And so there would be no way for us to do that. And so we try to make clear in the text that no vendor can own the data to basically do just that. So we want to make sure that the law enforcement agency, with the appropriate reporting requirements, they have full ownership of that so that we can't engage in that practice.
So you legally couldn't, but physically, since you're writing the code, your firm is who writes the code essentially, or maybe you outsource that as well.
It's all data is stored in the cloud. This is not our data. This is not something that sits, in a Flock control cloud. This is not ours. We use a third-party cloud service, and then that data is wholly owned by the law enforcement agency, not Flock Safety.
Okay, and then will we have a list of who the third parties are? I'm just trying to make sure we have transparency so that if this stuff does get leaked out at some point.
No, sure,
we know
absolutely.
whose heads should roll.
So our cloud vendor is we use the Amazon cloud service, and all data is stored fully encrypted at the highest possible security levels.
Okay, that's good.
But again, I just want to be very clear. This is not Flock Safety. We don't own the data. This is owned by the law enforcement agencies.
Okay, all right. Thank you, guys.
Delegate Boucher.
Thank you, Madam Chair, and thank you, distinguished panel, especially my beloved seatmate colleague for bringing this forward. On page 2, lines 14 to 16, talks about the penalties upon law enforcement agencies or individuals, I guess, that would violate this code. If a vendor or someone in the private sector who's commissioned to work on this, if they violate the code, would they be subjected to the same penalties, or would it fall under a different statute? How would that work?
So I'll take that, and I neglected to mention that when I described the amendments earlier. That is another one of the amendments that is added. It would add language stating that an employee of a law enforcement agency or a vendor contracted by a law enforcement agency would be subject to the same enforcement provision there.
Do you think there's a potential, or should we increase that penalty? Would that help? I'm just worried about the private sector not looking at this with the same amount of eyes and concern that someone who's a law enforcement officer does, and maybe have an increase in the penalty.
I don't have an opinion on increasing the penalty, but I would reiterate what Mr. Kane said, which is that the law enforcement agency owns the data. So this is not data that, employees of any vendor have access to. Another one of the amendments specifically prohibits the vendor from even accessing the data unless expressly authorized by the law enforcement agency. So I would think that those concerns are covered under the provisions of the bill.
We just have a security concern about data, so thank you very much.
And Delegate, I understand. Let me kind of just share a little bit about what's happening in the LPR world today. Your car passes through a number of sites where there are license plate readers today. And some of those are not controlled by police departments. As an example, I'm very familiar with the way that is used by third parties to identify folks whose vehicles should be booted in Washington, D.C. or in Baltimore City or a number of other places. That is managed strictly by private sector. And so they've seen you if you traveled in Baltimore City, and they've collected your data, and they've run that against a list that says you've got 3 tickets. And so I know that we're concerned about this issue. Actually, the data that we're talking about here is very secure. But once again, this idea of license plate readers and people checking your license plates, we're in that world where your car is being captured anyway.
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill, and thank you, panel. I do have one question for the lack of a fiscal note. I know that this would not be a service that a vendor would provide for free. So, and I'm not asking you what your fee would be or your competitors, but there's really no way of us to gauge this because there's no figure at all. And I was just wondering if you could speak to that.
Let me just, so there is a vendor today. The vendor today is providing this information directly on the server. So we're not changing the fact that there is some fee associated with providing this service. This is not being maintained strictly by MCAG. So there's going to be a vendor one way or the other. So I don't know that there's a significant difference in how that's handled.
And if I can just expand on that a little bit, you're exactly correct. I mean, none of these services are provided for free. There are actually, like multiple vendors currently operating in the state of Maryland. The reason that there's not a fiscal note is because this is merely enabling legislation. It doesn't mandate that anybody buy anything. It doesn't mandate that anybody change their vendor. It doesn't mandate that anybody use the cloud versus physical hard servers. It just gives local departments the option to use a provider that uses cloud storage. So because it doesn't mandate any changes or anything like that, there's no fiscal note associated with the bill.
Understood.
And we're happy to speak about like pricing for,
No.
Yeah.
I think the first part was MCAG currently uses a service. There's costs associated with it now. In other words, thank you. That clarifies it. Thank you.
Any further questions for this panel? Seeing none, thank you all. I'm assuming that Carney spoke down there. All right, that's fine.
I did. Thank you, Mr. Chair.
That concludes the testimony on House Bill 1081, last bill of the night. Then we're going to go directly into a couple amendments on House Bill 814. So just as a heads up, if people aren't in the room, they probably want to start making their way. House Bill 707 with Delegate Simmons, Mike Shire, Clyde Boatwright, Ari Plout, Nashana Cass, Frank Boston, Michael Davey. Well, I have Mike Davey listed as favorable with amendments, but
the amendments were already submitted.
All right, that's fine. Jerome Spencer's here too. Let's just bring him up too, and then we can talk to everybody. Delegate Simmons, please.
Thank you, Madam Chair. For the record, Gary Simmons, District 12B. Today we're here on House Bill 707, dealing with body worn cameras with the command staff. As you know, this legislation was championed by our great delegate, Conway, several years ago, and we just want to continue to do the good work that he set in place to make sure there's accountability when it comes to superior officers and law enforcement officers being accountable through wearing their body worn camera while on duty in uniform conducting law enforcement activity. With that, I'd like to turn it over to my distinguished panel.
Thank you, Mr. Chairman, members of the committee. My name is Ari Plout. I'm here on behalf of the Maryland State FOP. Mr. Boston, I know he signed up. He's across the street in judicial proceedings. He apologized for not being here. Thank you, Delegate Simmons, for sponsoring this piece of legislation. We support a bill that create a policy for the use of body-worn cameras for command staff, and that's essentially what the intent of this legislation is. Body-worn cameras decrease complaints, they increase professionalism. Command staff recognizes the benefits of body-worn cameras by requiring our officers to wear them. This bill would provide oversight on crime scenes. It would provide transparency and accountability. And with that, I'll turn it over to the experts to delve into this further. And we ask for a favorable report on this. Thank you.
Good evening now, Mr. Chair, members of the committee. For the record, my name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police. And when we had our legislative meeting back in November, we pondered a few pieces of legislation that we thought would be in the best interest of everyone. And this was at one of the pieces of legislation that was at the top of our list. The fact that we are requesting and had the support of, as you see, Ms. Kess, who was no longer here with us from the NAACP. We missed a watershed moment with the FOP and NAACP on the same side of an issue. But we really reached out to our partners and think that this is a good piece of legislation moving forward, that all police officers, if you have a badge, a gun, and the responsibility of taking enforcement action, the public should be able to capture or get a glimpse of what you capture on your body camera. And regardless of rank, if you are out there driving to a community meeting and there's a traffic accident, that should be captured. And for full transparency, we strongly believe that every police officer that has the ability to take action should be wearing a body camera. And so with that, we will urge a favorable report, and I'll turn it over to Mr. Davey.
Thank you. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police. The purpose of this bill is really simple. It makes it very clear that sworn law enforcement officers, regardless of their rank, wear and be required to use a body-worn camera when performing enforcement duties. Consistent with current law, every law enforcement agency is required to write their own policies as it relates to who and when a sworn law enforcement officer wears and activates their body-worn camera. This bill makes it crystal clear that a chief, a sheriff, and or their command staff would have the same responsibility as any other law enforcement officer as it pertains to wearing and activating the body-worn camera. The passage of this bill would prevent a chief, sheriff from writing a policy that would exclude him or her or their command staff, regardless of rank, from the requirement of wearing and activating the camera. It's the FOP's position that chiefs and sheriffs should have the exact same responsibility and obligation as any other sworn law enforcement officer as it pertains to the use of the body-worn camera. Thank you.
Good evening. My name is Mike Shire, representing the State Fraternal Order of Police. And for my grand finale tonight, we're asking for your support on House Bill 707. Each law enforcement officer of our state is sworn to protect the communities and enforce laws. Every officer, from the newest, lowest officer on the totem pole up to the chiefs, sheriffs, commissioners, and superintendents, they're all authorized to make traffic stops, arrests, use force up to deadly force. This body has made it crystal clear that it is important to have BWCs for accountability and transparency. So it makes logical sense that we would have every officer, regardless of rank, wearing body-worn cameras when they're working, interacting with the public, and have the possibility of doing some law enforcement action. There's no reason to believe that commanders are any less perfect than any of us and would not commit misconduct. Why would we not want to see that? Why would we be okay with those high-ranking officers, traffic stops, arrests, or their command decisions and orders on major crime scenes not being subject to the same level of transparency and accountability as any other officer? We're not asking them to record their community meetings or internal command meetings. We're just asking that they follow the same rules that any other officer in their department would have to follow. If you're out in public, wear the camera so that it's ready to go if anything happens. It's always a shock to people when, we say that our officers, for the most part, by and large, they like having the cameras. For the most part, it's showing when they're doing the job properly and within the bounds and expectations of our community. It shows when somebody files a false complaint against them. So why wouldn't a commander want the same protection? We think that they would. You know, it's kind of unfortunate sometimes that we have to legislate these things. Some agencies actually already are having their command staff wear the body worn cameras as a show of solidarity with their officers and for those transparency reasons. That's leading by example, but nonetheless, we request your favorable report on House Bill 707.
Maybe a slightly different response for favorable with amendments. Delegate Grammer.
Thank you, Mr. Chair. Just wanted to say, great work, gentlemen. This is a great bill. I hope you get a vote. Isn't that so?
Yes.
Else, Delegate Conaway.
Mr.
Gave you
Chairman.
a shout out there. Delegate Simmons did.
Yeah, I find myself on the other side of the coin like Mr. Boat right here today. So, what happens in the case when an officer needs to talk to a commander or a chief or something, and the chief shows up on the scene and the officer maybe is a little bit shaken or something like that? Does that have to be recorded or?
No, it does. Basically, most agencies have policies written that if they're going to speak about an investigative technique or something, a mental health issue similar to that, they have the opportunity to deactivate their camera when that discussion's over and they go back to their investigative phase, they reactivate it.
So in other words, the officer could show up at, the chief could show up at the scene, the officer could be somewhat upset and the officer could deactivate, and then the chief could deactivate, talk to his officer and then, or her officer, and then reactivate and it'd be no problem.
That's correct. Most of the agencies have policies that clearly document and
This
dictate
bill
that.
would allow that. Is
Yes,
that
sir.
correct?
Yep.
All right. Thank you very much.
Delegate Tolles.
Thank you, Mr. Chair. Thank you so much, Delegate Simmons, for bringing the bill. And I do think we do need to be on par, all of our agencies. And so just a quick question. I noticed that the Maryland Hospital Association has some concerns, or were not concerned. They had information, a letter of information regarding patient privacy as part of their committee, as part of the testimony submitted. Could you talk about what the current law is for hospitals and your thoughts on this letter?
So there's already protections in place when officers, either in law and policy, so that when officers go into medical facilities and medical information might be recorded, they are permitted in those cases to deactivate, and actually sometimes required to deactivate their cameras so that we don't have the unintentional release of medical information, so that you don't have people's personal medical events being recorded. Those protections are in place, and it was one of the things that we spoke about when the whole body worn camera legislation was coming about and agencies began to adopt them en masse. So we do have those protections. If there are any concerns about that, we're happy to discuss those offline and make sure they're addressed properly.
So it is, just so I can understand, it is current law. You already do that with your
officers when we go into hospitals and things like that. Unless it's, like we're standing in the lobby talking to a victim or something like that. If we're going into an area where there's medical treatment going on, we're going to deactivate our cameras so that we're not capturing any of that.
Just a quick follow-up, Mr. Chair, if it's okay, really brief. Thank you. In the instance where you have, some investigation going on where maybe it was a shooting or some other accident happened and you are talking to a witness, a victim, do you keep your cameras on in that situation?
Yes.
And has the hospital been in agreement to that?
Yeah, basically, what happens if you're in a triage area and you're discussing the accident, your body worn camera is activated. However, if a triage nurse, a doctor comes in and they start treating the patient or doing any medical type of procedure, you deactivate it until that is complete. They leave the room, and then if you have to continue, you reactivate. Yeah, that's never been a problem.
Okay. Great, thank you.
Well,
All right, seeing no further questions for this panel, that is just fine. Thank you very much.
Thank you all.
Sir, if you want to come up favorable with amendments from the chiefs and sheriffs.
Good evening again, Mr. Chair and Madam Chair. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office here on behalf of the Maryland Chiefs and Sheriffs Associations. Here to discuss, to support with amendments, this bill before you today. I hope I'm going to end with a whimper rather than a bang, because bottom line is we're talking with the FOP about this bill. The way the bill is written, it gives us some concern. The way the bill is written, it talks about in uniform, in public, and conducting law enforcement related duties. So several of our chiefs and sheriffs said, wait a minute, when I do my town hall meetings, law enforcement related, body camera on then. Wait a minute, do my budget meeting, that's law enforcement related, camera on then. So we've been trying to work with the FOP to kind of address that issue. We understand their concern is that when officers engage in traffic stops and arrests, they should have body worn cameras. And if a chief or sheriff is out there doing traffic stops, she darn well ought to have a body worn camera on her, if that's going to be part of a regular job, which for most command staff, it's not. So we're going to continue to work with the FOP on this bill, on some language might ease some of their concerns, while still making sure that we're focusing on what body worn cameras tended to do. They're intended to document situations where there's a non-consensual interaction between a police officer and a citizen, the traffic stops, the arrest. That's the primary purpose of body worn cameras. And we're going to continue to work with them and make some language that hopefully accomplishes their goal while satisfying the chiefs and sheriffs as well.
Can you tell me the intended purpose of body worn cameras?
Sure, it's transparency and to allow us to document an event that goes on between a citizen and a police officer.
All right, thanks.
Okay. Any other questions? Seeing none, thank you very much. That concludes the testimony on 707, the final bill of the night. Members of the committee, it's 8:06. If I could ask people who are outside the committee room to come on in, we're going to go directly into a voting session. Yes, so we're going to gavel this meeting out. We're going to adjourn this meeting of the House Judiciary Committee, and we'll be back in 5 minutes. In the intervening time, we're going to pass out copies